All right, good morning. Oh, now, you all have heard me say this when I would pick juries and the jury sounded like that when we started. I'd have to say again, well, good morning.
Good morning.
Much better. Okay, good. Thank you. All right. This is the Michigan Court of Claims. We're in Grand Rapids, Michigan. My name is Jim Redford. It's my honor and privilege to serve in this matter. It is a matter of Krieger versus the Department of Environmental Quality. I'm sorry, the Department of Natural Resources and Department of Energy, Great Lakes. I can't believe I'm getting this wrong. Eagle. At any rate, this is the time and date that's been set for an evidentiary hearing on the plaintiff's proposed expert. I'd like to have appearance of counsel, and then we're going to just memorialize a couple of one side or in-camera meeting I just had with three of our counsel, and then one phone call that we had yesterday, and then just briefly a phone call we had on, I think, August 15th. But starting with the plaintiffs, since plaintiffs they're accustomed to it, they have the burden of proof, so they have to go first and everything. Plaintiffs counsel, if you'd be kind enough to introduce yourself.
Sharon Allman Road for the mass plaintiffs.
Okay, thank you.
Good morning, Your Honor. David Dubin here on behalf of the class plaintiffs.
Good morning, Your Honor. Jason Thompson, co-class counsel.
Morning, Your Honor. Craig Dickinson on behalf of the mass plaintiffs.
Any other counsel want to identify?
Good morning, Dana Fraser from the Miller Law Firm on behalf of plaintiffs.
Good morning, Your Honor. Ken Stern on behalf of mass plaintiffs.
Good morning, Your Honor. Christopher Desmond from Venn Johnson Law on behalf of the mass plaintiffs.
All right, thank you. All right, for defense.
Good morning, Your Honor. Nathan Gamble, Assistant Attorney General, here on behalf of the defendants.
Good morning, Danielle Allison Yocum, here on behalf of the defendants.
Sure. No, just kidding. Okay. All right, fine. Thank you. As I indicated, this is the time and date that's been set for an evidentiary hearing. One of the endorsed witnesses for the plaintiffs. I appreciate everybody being able to be here with us in person. A couple of housekeeping matters before we begin proofs. Today is September 16th, I think September 16th. September 16th, 2025. We started at 28 minutes after the hour of 8. I did want to indicate we have had a couple of phone conferences since we were last on the record. The first one is memorialized in the court's order of August 15th, 2025. We had and it indicates at the top paragraph of the second page of that order, status conference we had on August 15th, 2025. It was because there had been some circumstances that had come up to make it necessary for the plaintiffs to seek an adjournment of what had been scheduled by the court's order for an August 25th, 2025 hearing on the expert witness testimony that's proffered in this case by the plaintiffs. The hearing was attended by a number of lawyers who just identified themselves here on the record, as well as a few other lawyers. I unfortunately do not have my notes of that call, but the gist of it was that there were some scheduling issues that were unanticipated and largely unanticipatable. The defendants did not object to an adjournment, and we settled on today for that hearing, then the one that we're going to do today, and if necessary, tomorrow. We also had a very brief conference yesterday for 10 minutes with Mr. Gamble and Ms. Allman Road. My staff initiated the call at my request, and the reason for this is just out of an overabundance caution. I felt I knew what the order was going to be today, but I wanted to make sure we're all on the same page so we didn't show up. Oh, no, I thought you were going first. And it was to discuss who would be calling witnesses first. And Ms. Ullman Road indicated on behalf of the plaintiffs, they anticipated going first. The defense, Mr. Gamble said he agreed that the plaintiff would be going first. At this point, the plaintiffs have one witness that they plan to call. The defendants indicate that they presently, as of yesterday, did not anticipate a witness, but that some would be available potentially to call if they chose to. So that was that. And then finally, this morning, we had a short discussion in camera about an IT issue, how much time the plaintiffs thought direct might take, the first round of direct for the witness today, and also the lunch. Present at that call or in that meeting were Mr. Dubin and Ms. Allison Yocum. Mr. Gamble joined us midway through it. It was conducted at my request. We were in chambers. Present was also Jeff, one of our IT people. And it was to advise, as was Ms. Husa, one of the court commissioners who's assisting the court greatly in this matter. The issue was we were already seeing digitally that there were some attorneys who were in the gallery, but not in the I'm participating mode. And we wanted to iron out how we're going to handle that. My understanding is that lawyers, even lawyers of record who are not appearing here in court, are going to be in the general gallery. If something comes up that they feel that they need to either communicate with one of their co-counsel, whether, and this is whether you're plaintiff's counsel or defendant's counsel, they're going to need to get a hold of you all digitally somehow. I'm assuming we're all tethered to our electronic gatekeepers of ourselves and our schedules, that is our cell phones. Somebody will be able to get a hold of you, presumably. If something happens that you need to take a short recess to facilitate that so you can communicate with one of your colleagues. I mean, obviously, I don't want to take a break every 15 minutes, but if something substantial is going on and you need a short recess, I just need you to ask for a sidebar. If we have a sidebar, or actually, I keep thinking we have a jury. We don't need to have a sidebar. You just says, Your Honor, can we address something, indicate that's, I'm laughing at myself. I was thinking about some other responsibilities I had as a military judge this morning in the years gone by. Okay, so we don't need a sidebar. You just need to let me know you need a minute, and we'll either take a recess in place or we'll take a short recess. That's my understanding of how we're going to handle that. As far as time for direct, the estimate is somewhere between 90 and 120 minutes and maybe 3 or 4 hours. So don't know, and we'll see how it goes. But they anticipated that the witness being called the primary witness by the plaintiffs probably completed sometime this morning. But it's an important, very important case for all litigants, and it's an important witness for the plaintiffs. So we're going to take what time is necessary. Defense obviously will then be able to cross-examine. Also asked about by Mr. Dubin was lunch, because they're having it delivered, and said for planning purposes, let's plan that we're going to take our recess at noon. If we get done at 11 o'clock, if things are moving faster, let's have a discussion at some point in a logical break. I don't want to interrupt the flow of testimony and the most crucial question for the plaintiffs or the most probing cross for the defense. To say, hey, what about the Jimmy John subs? Not the Jimmy John subs are not important, because they are important. They have nutrients, but just let me know how you want to proceed. Those are the three things we talked about this morning, and that's the only other matter that I am aware of that is not a matter of record. Ms. Ullman Road, any additions, corrections, objections to any of the indications I've made, or any other plaintiff's counsel who's present here today?
None, Your Honor.
Anybody else? All right. As they say, speak now or forever hold your peace when you do that. I never do say that when I preside, the few times I preside over weddings. I'm too afraid what might be said. So, but anyway, no other indication. Plaintiff's defense, either Ms. Allison Yocum or Mr. Gamble.
No, Your Honor.
All right, we're ready to go? Ready to go? Okay, and let's proceed. And I did receive the exhibits, and I'm assuming that the binders that I see on Mr. Gamble's table are the same binders that I have up here in 4 copies. I've not had a chance to read every page, but I look forward to it in my deliberations. And finally, and I didn't indicate this earlier, Mr. Trudell, it's good to see you again. I'm so grateful for your helping us and making a permanent record of our proceedings. If during the course of today, what I'm saying is you're not able to hear it, please let me know, and same with the council. We have a witness and we haven't had witnesses, I don't think, in any of the hearings that you and I have worked on together. So if you have an issue with something, please stop us. So you're the one who has to make the record, not any of the lawyers, thankfully. So.
Thank you. Yep, we'll do.
All right, thank you, sir. All right, Solomon, please proceed. On road.
Plaintiffs,
Yep.
good morning, Your Honor.
Morning.
Plaintiffs call William Sturdivant.
Very well. Sturdivant, please come forward. As I understand it, it is our witness stand is over there. If you can get there, once there, if you could remain standing and face me, please. Please raise your right hand. You swear or affirm that the evidence you're about to give in the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Please be seated.
For the record, would you state your name?
Hold on.
I'm sorry.
Sorry, in the trials I preside over, I'll administer the oath and then I'll ask the witness to say their first and last name and to spell their last name. And if it is a relatively unusual, and usually actually have them spell both first and last name. It's a habit. I blame on 28 years of military service, and that's how the court martial procedure works. So at any rate, Sturdivant, if you could state your first and last names, please spell both for us.
Sure. William Sturdivant. Bill, please. W-I.
You'll be either Mr. or Doctor for me, but
William. Last name Sturtevant.
right. Thank you, Mr. Sturdivant. You may examine counsel. And if you'd prefer to use examine from counsel table, if that's convenient for you, that's fine with the court. It's entirely up to counsel within reason.
Thank you. I'll start here and
Okay.
then we'll see how it goes.
Okay, thanks.
Can you tell us about your education?
I have a Bachelor of Science from University of Wisconsin-Madison in 1980 in Civil and Environmental Engineering.
And what exactly is civil and environmental engineering?
Back then, it was maybe a little different than it is now, but it was a wide spectrum of structural engineering, water system operations type engineering, water system management, hydrology, hydraulics, tanks, wastewater treatment design, traffic design.
After you graduated from college, did you obtain any professional licensure?
Yes, I became licensed first in the state of Wisconsin in 1986.
And to become a licensed in Wisconsin, what did you have to go through?
You have to attend an accredited university, which the University of Madison is. And at that time, you had to take the engineering training exam, an 8-hour exam out of school. Once you were out of school, you could take it. And after 4 years of working under the direct supervision of another registered professional engineer, you were allowed to take the professional engineer's exam. And the company I was working for, the private firm I was working for, asked me to hold off a few years so that I could get reciprocity to other states if necessary, because some states required that. So I took the exam and passed, and the rest is history. I'm still registered in Wisconsin.
And after that, did you obtain any other licensures?
Yes, I'm registered in the state of Colorado and now the state of Michigan.
In Colorado, what did you have to do to become licensed?
I signed up through an organization, NCEES, that collects my transcript, collects 5 letters of recommendation, talks to my past employers and supervisors, interviews them for the quality of work and the professional work. And you have to write a small dissertation on the work that you're involved with in order to prove that you are who you say you are and that you qualify for that position, and then apply to the state that you want to get comity to.
And after that, initially, you got a license in Colorado.
Yes,
What year was that? Do you remember?
2018,
Okay, and when did you become licensed in Michigan?
a couple months ago.
Why'd you do that?
Partially because this case, and it was questioned whether I would qualify to be a registered professional engineer in the state.
And what did you have to do to become a professional engineer in Michigan?
I had to update all the information that I had from 2018. It has to be updated every year to make sure that you're not slipping in your professionalism and your professional life. And they want to know what you've done in between those updates. So I had to supply all the information, the new information, you get 5 more letters of recommendation and provide them with the new supervisor information and how to contact them.
I want to put up your curriculum V type, which is part of volume 1 of our plaintiff's exhibits. And it is called Exhibit A, which is the report and the attachments to that. And the fact that it's an appendix, the CV is noted on the tabs. Can you? We're also going to put it on the screen, but it might be easier for you to look at that in the paper version.
Excuse me. Elizabeth, you have a pointer or something? Apparently we have a pointer, and not just a laser pointer, but a no kidding pointer, just like the ones that
Oh.
nuns use at Jesu grade school. I won't tell you what they did with the pointer as relates to Jim Redford, but anyway, if you need it, it's there. It's not a lightsaber. So. I would just ask that Mr. Sturdivant hit the microphone with him when he's moving about the well of court.
I'm fine here if that's okay. Thank you.
Okay, well, first off, can you identify what this document is?
Yes, it's my resume.
Is this up to date?
It probably could use a few more updates because I'm bumping up to 40 years experience working on dams.
Okay, and you also now have your Michigan licensure, so would that be?
Correct, and that's
Okay.
not in here.
What is your current professional employment?
I'm the chief dam safety engineer for Colorado Springs Utilities. I'm responsible for the safe operation, maintenance, the planning for future projects, maintenance, upgrades for 25 reservoirs and dams in the mountains.
And what exactly is the Colorado Springs Utilities?
It's a multifaceted utility responsible. They actually have water, wastewater, electric and gas in one utility. And unlike or like many other large communities, they're responsible for the collection and retainage of the city's water supply in these large reservoirs above the city.
And we're going to go into some of the specifics, but let's go through your history in general first. What was your employment before you were employed with Colorado Springs Utilities?
The state of Wisconsin.
And what position or positions did you hold there?
I started as an assistant state dam safety engineer when the dam safety program first really kicked off in 1986 and progressed to become the state dam safety engineer, responsible for 13 engineers and then a total of 3,700 dams, 1,000 that were under our direct jurisdiction.
And what do you mean by that about direct jurisdiction?
They were large dams by statutory definition in the state. So the smaller dams were not under our direct jurisdiction, but we were responsible if we were contacted and that owner needed or wanted assistance from the state.
And when you say the large dams were under your jurisdiction, were any of them similar to the Edenville Dam?
Yes, many of them.
And would they have been a similar size, structure? How would they have been similar?
Similar in design and structure, a dam consisting of earthen embankments, concrete structures, powerhouse, and all the associated appurtenant works on that dam.
When in your first position with Wisconsin, can you tell us more in more detail what type of duties that you had?
I was responsible for the inspection, the setting of the requirements to bring the dam up to standards in accordance with the state statutes, administrative codes, and program guidance in that order of hierarchy. And then follow through with the owner to ensure that the work got done in a timely manner, write and draft administrative orders for the state dam safety engineer to review and sign, and respond to emergencies, assist the owners in preparing emergency action plans, reviewing, ordering the owner and reviewing dam failure analyses, hydraulic engineering, modeling, along with stability analysis on the varying structures, all the way from wooden structures built in the 1800s up to modern concrete combination dams with concrete and earthen structures. A lot of dam inspections.
How many dam inspections do you think, can you estimate how many dam inspections you've done in your career?
Well over 600. I averaged about 60 a year when I was the assistant state dam safety engineer, but then when I moved to the state dam safety engineering position, I was more working with the other engineering staff to make sure they were getting what they needed and to assist in their inspections if they needed it, or if they had questions, or if they needed a little bit more of a push to get the owner to do what needed to be done.
Did you have an oversight responsibility of those other engineers in your higher level position?
Yes.
And did you have enforcement responsibilities in either position?
Yes, I could actually and was allowed to draft the administrative orders that told the owner exactly what they had to do with the findings of fact, conclusions of law and order, ran it through the legal staff to make sure that they were comfortable with the approach the state was taking, and signed the order myself and stamped it and sent it off, and then had to defend it.
What types of circumstances would you use your enforcement responsibilities?
As seldom as humanly possible. That's not the best part of the job, is forcing people's hands. You know, it's going to cost a lot of money. It's going to cost some heartburn, but it has to be done to protect life, health, and property. So if the dam was in a state of disrepair, the owner hadn't done anything for a long time, and in some cases, we didn't even know who the actual owner was. So there was a lot of background work. There was a lot of searching and seeking, and then we would issue the order against the owner only as a last resort because they weren't getting the work done. And the work had to be done to bring the dam up to standards and keep it safer.
Would years of non-compliance justify an enforcement order?
Yes, that's really the most common occurrence when I had to issue an administrative order, was the work wasn't getting done in a timely manner. The dam isn't getting in better shape as it ages.
What is the primary responsibility of a dam safety engineer?
Protection of life, health, and property. It really comes down to that, and it comes down to that part of the civil engineering creed or code of your job is to protect people, the public, and the welfare and the well-being of the people.
Let's look at page 2 of your CV. Or page, rather, it starts at page 1 at the bottom where you put a summary of your qualifications. You see that?
Yes.
Okay, and it says diverse engineering background. Okay, can you explain what these various types of background, engineering background are? Identify them and explain what they are in terms of structural engineering.
Structural engineering on dams is a real challenge because there are no two dams that are alike. It's just not possible with the different foundation conditions, the different abutment conditions, the different soils, the different materials available in that part of the world where the dam was built. So the structural engineering component stretches from wooden structures to concrete structures to steel structures to a combination of all the above, to earthen structures to protective structures on the upstream slopes, the downstream slopes, seepage collection, all that is part of the structural engineering component when it comes to dams.
And as a dam safety engineer, do you evaluate those issues?
Yes.
The next one you have listed is hydraulics and you have open channel water distribution and pumping. Can you see that? Okay. Can you explain what that is?
On the hydraulics side of things, you have to be able to understand, analyze, and perform the calculations necessary to determine how much water the dam can pass or its hydraulic capacity, how that water gets through the dam, by what methodology, what kind of gate causes certain amounts or what you can expect to see out of that gate for hydraulic capacity, its operation, and also what flows the river sees and how that flows through different parts of the river, seeing different characteristics through forests, through wetlands, through open river channels, through closed concrete channels. All those things play a role. And you have to understand how to look at that, how to review that. If it's an ordered study from an engineer, what to expect, so that when you do get an analysis in a computer model, you understand it. You can actually run that model. You can perform the study yourself because you've taken the necessary training and you know how to do it. I've done hundreds of those in my career so far. And if you don't have that kind of knowledge ahead of time, understanding what the actual physical calculations are on a piece of paper, you have no idea what you're looking at when you see the actual computer model. Because especially nowadays, you can put garbage into a computer model and get results. It doesn't work that way on a piece of paper. You have to come to the conclusion and go through the steps.
So as a dam safety engineer, you analyze those types of issues?
Yes.
And you've done that hundreds of times?
Yes.
Not more.
Yes, we required all large dams in the state of Wisconsin had to have a dam failure analysis performed. And that is a synthesis of what happens if the dam fills. And there's different criteria on how full you make that reservoir before you physically break it in the computer model. And I was in on the very early development of those unsteady flow models, they're called. So with dam break, with flood wave, with the first generations of HEC-RAS, those are all programs that were developed either by the Army Corps or the National Weather Service that allowed an engineer to look at, to do very large computations in a computer model. So the first waves of that the doctors, Danny Fred and Art Miller and the people who developed these models pulled in 20 of us from around the country for a symposium in Salt Lake. And we sat and we went through, what do we need to see in these? How can we make these work for consultants, for the states, to improve the level of dam safety countrywide? And out of that symposium came what we're seeing now with HEC-RAS, unsteady flow modeling. And what you're seeing as a result in many of these documents, and that was a very trying 5 days of a lot of ibuprofen to get through that week. But it was very rewarding. It was really good to get to know those people who were the brains behind the actual development of those models.
And those models do what?
They calculate how much water is going to get downstream. Where does the water fall? How does it get into that reservoir? And then how does that water move through the entire system? Originally, it was just one dimensional and it would look at the water going straight downstream. Let me take a step back. First, it was a step back water model where they'd put a cross section on the channel and they'd run the water up to there and you'd see how deep it got, right? And then they would keep going downstream where the channel changed and it would change where that water level you would expect that water level to be during a certain flow rate. Now that model runs straight through those sections and calculates the water that can actually move out into the floodplain to attenuate the flow. So they're much, much more sophisticated. And that was the 5-cent version. But it's really rewarding to see what came out of those early analyses and those early sessions.
Were these people who were developing these models and they were looking to you and a few others for guidance from a practical standpoint?
Yeah. They were looking for the people that were dealing with this day in and day out to give them the insight on what's useful and what's not. And how can we make this more user friendly and how can we provide an interface where people can actually use these models?
And these models, are they helpful for dam safety?
Sorry,
They're critical.
can you repeat the question, please?
Are these models helpful for dam safety?
They're critical.
In what way?
They identify the hazard downstream of the dam. They identify the infrastructure, the extent of the inundation zone. And in Wisconsin, we called it the hydraulic shadow. That was the dam failure floodplain. It was just an easier term to use. And it in the long run, it really gave people a good grasp of, holy smokes, that's a scary place to be. You don't want to be there. So if I use that term, that's what I'm meaning is the inundation zone resulting from a hypothetical dam failure. And they're also used extensively to determine what the dam's spillway capacity is.
What, can you explain what spillway capacity is?
It's literally how much water can flow through that reservoir and the dam, including storage in the reservoir, storage in the floodplains upstream and the wetlands upstream. And then routing or looking at what happens when the water makes it down to the dam as the control structure and how those gates open, the timing of the gates opening, what the physical characteristics of the spillway, the gates, the entrance, potential debris loading, trash racks, all that stuff has to be taken into consideration when you consider the dam's hydraulic capacity.
If you look at page 2 of your curriculum vitae, I have that same section that we were looking at. Just if you can scroll up a little bit. Okay, it says you had 38 years experience reviewing dam rehabilitation, removal designs. What does that mean?
There comes a point in a lot of the dams' lives, especially really old dams, where they just are no longer viable. And that's the removal portion of it. And the owners have a right to apply to remove a dam if they can't afford to upgrade it to current standards for one, or if the dam's just outlived its purpose, it's silted in, for whatever reason, it's just not being used for its original purpose, and they're very expensive to keep, and the liability is huge. So there are a lot of people who want to get rid of them. And the rehabilitation, reconstruction, repair, there is a distinction there between repair and total rehabilitation. Rehabilitation would fall into more of a redesign type situation where the dam was built a very long time ago, and now the standards have changed and the standard of practice, the acceptable nationwide, worldwide standards have changed for the design. So it's time to upgrade it. And then sometimes you have to take large portions of the dam out and reconstruct them.
Then the next category you have listed is you completed and reviewed numerous stability, structural design, hydraulic and hydrologic models. Can you explain what that is and what you did?
So during all those processes we just talked about, the repair, rehabilitation, removal, you have to relook at the stability analysis drives it. That really tells you, is the dam stable under normal loading conditions? A hydrologic event where you would see a larger flood event, fill it up, and you're putting a lot more pressure and a lot more stress on the dam. So you look at those considerations, and then you also, in certain parts of the country, you need to look at what happens during an earthquake, what happens during a seismic event shaking, and you look at, in that case, a deformation liquefaction type study where you would actually look at what would happen if the dam shook. Is anything going to settle? Is the crest of the dam going to come down low enough where it's going to overtop and it would be very likely to fail? So those are all things as far as the stability and the structural designs that need to be looked at. And it all has to blend together with the hydraulics of the dam being able to pass flow and the hydrology of how much flow you would expect to get there during certain rate events.
Okay, so that's, do you have anything more to add to explain the distinction between the hydraulics versus hydrology?
Hydrology is if a raindrop hits in part of the watershed, does that get to the dam or not? That's really what it comes down to. So it's looking at particular rain events statistically over time and then determining how much water you would expect to have to deal with once the water gets to the dam. That's kind of the 5-cent version, but that's exactly what it is.
And what's the difference with the hydraulic design?
Hydraulic is the actual physical movement of the water and looking at the conditions as it's moving downstream. You've already had the rainfall event. You already know what to expect in that particular reach of the river, and then you look at what happens when that water gets to that reach.
Did you develop dam safety policies and guidelines in any of your positions you've held?
All of them. The state of Wisconsin just started its dam safety program when I started, and it was and still is probably the most it was very controversial because Wisconsin stopped allowing people to build below dams, period.
To build what?
To build residences, to build
Okay.
critical infrastructure in that inundation zone. And you can imagine we had to write those administrative codes to match the statute, and the administrative codes then had to be updated. I mean, like anything else, you realize, oh, I could have done that a little bit better, right? So you go in and you redraft it and take it to the legislature and get it approved. On the national level, I worked with the National Dam Safety Review Board when I was with the state as a state voting representative. I believe I served 5 full terms, so 10 years worth. And when I retired from the state of Wisconsin, and Colorado Springs Utilities hired me to come out and build and produce their dam safety program formally. I worked on that national level, setting standards that the states could use then in their dam safety programs if they chose to.
And in doing that, was that your role in the Homeland Security Critical Infrastructure Committee or on a different committee?
That's different. That was more of, I was on a type 2 hazard team in Wisconsin, responsible for the boots on the ground analysis and work on dams and flooding. And so I was the response that that type 2 team, which included the National Guard, State Patrol, the DNR wardens, and numerous other state staff and nuclear people, everything I was responsible for any response during an emergency to be the boots on the ground engineer.
The National Dam Safety Review Board, you have that listed on your CV. What is that?
It was run by FEMA. President Trump dissolved the National Dam Safety Review Board and let us volunteers go. I was asked to come back on the board by the head of the board when I retired. James Denby was in charge of it then, and he just asked me if I would be willing to come back and offer the perspective of ex-regulator, now owner, so that it would give that benefit to the board to understand what the owners are going through as a result of the regulations that they were developing.
And did you play a part in developing regulations with the National Dam Safety Review Board?
Yes.
And what was the intention of those guidelines?
To assist the states in developing their programs and even helping with the grant programs. President Biden, his infrastructure bill included a lot of money, and a lot of it was allocated towards dams, and we had to come up with how are we going to distribute that to the dam owners through the states in an efficient manner so that we can get more dams brought up to standards in a safer manner. So that was really what I was working on when the board was dissolved. We were pretty much had it finalized. Congress had approved our approach, and the rest is history.
How long were you on that committee?
I was trying to come up with the exact dates the other day, and it's somewhere around 15 years total.
And you also are a member of the United States Society on Dams. What's that?
It's an organization much like you're going to ask me about the Association of State Dam Safety Officials. It's a group that focuses on dams and the issues revolving around dams, the issues with hydroelectric generation, the issues with how to inspect dams, the education for the public, for the consultants, for dam owners to understand what their dams are, how they behave, what they need to look for, how to do those interim inspections. And I still sit on ASDO as the Association of State Dam Safety Officials. I'm on the editing committee for the Journal of Dam Safety. So I provide the expertise involved in reviewing papers for conferences and for the journal publication.
And do those two organizations coordinate guidelines and policies with the use throughout the country?
Which two organizations?
Sorry.
USSD and ASDSO. And I'm not as forward active in USSD as I am in ASDO. And ASDO does have a presence, or did have a presence, on the National Dam Safety Review Board. They were very instrumental in helping us get some of the things passed and get some of get the information to Congress and get it out to dam owners. They're a very efficient organization.
Have you ever testified before any governmental body or court regarding dam safety issues?
Yes and yes. I served as the state's expert witness on dams because I was a state dam safety engineer. So if everybody has the right to contest what we do. And that's a good thing, because if we're not doing it correctly, we need to be called out. And when those contestations came, I was the state's witness saying, this is why we did it, A, B, and C. And also when we were deciding that we needed to update or change the administrative code to address changes in the political environment, changes in age of the dams, and we just found a better way to do things. I had to testify to the state legislature on why we were doing what we were doing, so they could make the decision whether to allow that administrative rule to go forward.
Okay, if you look at the column to the left on your page 2, you indicate some of your achievements. You see that section?
Yes.
Okay, I want to go through some of that. What did you do for developing guidance for authorization of previously unauthorized dams in Wisconsin? What type of guidance did you develop?
Instead of forcing the dam owner to come back in and apply for a new permit, myself and the rest of my team came up with a plan on how can we do this and make it efficient so we're not always spending the taxpayer dollars to get to the same end. How do we do this without making it too cumbersome? So if a dam showed up on the landscape unauthorized, or we just couldn't find the authorization, it may have been built pre-statehood under a different set of acts and under the Mill Dam Acts, and there just wasn't an adequate record and it couldn't be found. So how do, it's been on the landscape for 150 years. How do we make it legal? And so I came up with the rest of my team, came up with a process to follow that resulted in a dam that was identical to what it would be if they came in and wanted a permit for a new dam. And then we had a responsible owner at the end, and we had a dam that met requirements.
Did that include reviewing dam safety related to those issues?
They had to meet all the requirements that the state law required.
And that's true, even though the dams in many cases were old. Is that what you're telling us?
Can you repeat that, please?
Even though many of the dams were old,
Yes,
did you consider dam safety?
yes.
And you also indicate you developed well-received statewide dam owner training workshops. You see that? What did that involve?
So 3 times a year, we would travel around the state. I would pull different members of my team in, so they got, honestly, it was my way to help them be able to speak more efficiently in public, was to have these workshops that the federal government sponsored. And we would go out and pick a specific set of topics, and we would teach those at one of the local community colleges over the course of a day and offer it to the consulting world, the dam owner world, anyone who was interested, for the public at an extremely minimal cost, just to cover the cost of lunch. And I was authorized by the state then to sign continuing education credits for professional engineers. And the consultants loved that they could get 4 to 5 continuing education credits for $20. So they kind of like that.
Can you tell us about some of the dam repairs that you've been involved?
Oh my goodness. Anything from pulling the concrete dams down into the foundation with large rock anchors, to rehabilitating earthen embankments with buttresses of various kinds, weighted filter buttresses, steel sheet pile driven upstream slope protection that resulted in seepage mitigation, filter systems, embankment raises, concrete rehabilitation, gate rehabilitation, gate operator, gate rehabilitation, powerhouse work. We can keep going.
Okay, why don't you tell us about the Crystal Dam repair that you mentioned on your CV?
Crystal Dam is a 90-foot high structure on Pikes Peak, and it's very similar. There's another one of our big reservoirs right next to it at South Catamount, and they're very similar. They have steel faces on the upstream side. The embankments needed work. They were seeping pretty heavy. And I'll go to South Cat versus Crystal. That one's ongoing. It's very similar to what Edenville was. And we'll talk about that just real briefly. Is the upstream face on the difference is the upstream face on the South Catamount Dam is steel. that was built in 1936 and 1937. It's been very well maintained, so we're just recoating it. And the downstream side had a mystery berm for as long as any
Sorry.
mystery. And I'll try and explain that, Your Honor. No one knew why the heck it was there. And that's kind of scary when you pull up to a dam and you go, well, why is that there? It doesn't show up on any of the plans. There's no reasoning. There's no record of it. So why is it there? So that in conjunction with the dam was just aging. It needed new piping, new valving. It wasn't a safe situation for our caretaker to operate. So I went to management and said, look, I think we should just wipe the slate clean and start over. When we're done with this, let's have a dam that everyone can sleep better, knowing we own. So we cut into the mystery berm, figured out what it was, and it was a weighted buttress. So there was obviously some slope stability issues. And in lieu of putting that back in, I worked with our geotechnical engineers that we hired to design what's called a filter buttress, so that big buttress on the downstream side now has a filter on the embankment side, and then it's weighted on the downstream side. So it's a combination of both. And that's kind of what's out on the rest of the embankments at Edenville.
Are you involved with the Emergency Management Institute with FEMA?
Yes, I was fortunate enough to be invited to EMI in Maryland to present, that's the Emergency Management Institute, to present dam safety topics. And over the years, when I was a state rep, state dam safety engineer. So I did some emergency response type stuff, and I did presented Wisconsin's dam safety program and how we responded to some very large flooding events in 2008.
Is the purpose of some of these organizations to share information on a national basis?
100%. That's how we learn in this world of dams and dam safety is experience, how other people have dealt with it, how you've dealt with particular situations, how consultants have come up with solutions, and how not to do it. So there's both of those lessons.
When you were retained in this case, did you have any prior knowledge about the Edenville Dam failure?
Yes.
And what was that knowledge?
That the dam had seen a large amount of flow, filled to a very high level, and one portion of an earthen embankment on the left side of the dam had washed out, and I saw the videos online. So just real quick, when we're talking about dams, we don't talk about north, south, east, and west. So if I use left and right, that's standing on the dam looking down the stream into the floodplain. So same with river, is you're always standing in the river looking downstream. So right, left, upstream, downstream. That way we don't get goofed up with compass bearings.
What did you understand your role was supposed to be in this case?
To go through the available information and the studies and determine if something could have been done different to prevent what happened with the dam, and determine if the necessary precautions were taken ahead of time or not.
And did you analyze the state's regulatory authority?
I did review their statutory authority, yes.
Did you have to be a Michigan engineer at the time to evaluate the Edenville Dam failure?
No,
And did you have to be a Michigan engineer to evaluate the regulatory actions?
no, it very clear cut, not dissimilar from the statutory authority of Wisconsin.
As an engineer in dam safety effort, could you evaluate the safety of the Edenville Dam and the risk it posed for health, life, and property?
Yes. especially as my role as a state dam safety engineer, it wasn't possible for me to look at 10 dams during the course of the year that my engineers were already reviewing and get out there and do the physical work that I'd much rather do than review the studies and the analyses. So you have to be able to look at what the analytics are showing you and how to interpret those in conjunction with what you're seeing with your own eyes. And the videos, the pictures, the historic documents are absolutely critical in that process.
So as a dam safety engineer, when you are reviewing the structural condition of a dam, dam safety and regulatory compliance, do you have a particular methodology that you follow when you're going to start looking at a dam?
Yes, and it follows very closely with the Department of Interior's SEEDS, the safety evaluation of existing dams process, and we fine-tuned it to meet the kind of dams that the Midwest sees versus what the Western dams look like. So we looked at what does an engineer need to do to prepare for an inspection, and came up with guidance that I could hand off to my engineers and say, you know, here's your checklist. I strongly suggest you use this so you don't miss anything. You will miss something because some of these dams are 150 plus years old, and there's going to be a piece of information somewhere in there that isn't there that you needed. But here's what you need to do. 1, 2, 3, 4, 5 in order to prepare to do the physical inspection.
And who's the we in that description there? We developed for the Midwest.
That was internal to the state of Wisconsin. It
But
was myself. It was at that time the associates, the engineers I had working in the near vicinity of my office.
But what you developed, was that similar to the guidelines you were developing with the ASDSO?
Yes,
And
it follows they have very good continuing education or educational videos that follow those same protocols.
and those protocols, are those protocols used nationally?
Nationally and internationally. ASO reaches out internationally. There's members all around the world.
So while you developed some specifics in the context of Wisconsin, did you rely on principles and methods that are utilized nationally and internationally?
Yes.
Okay, so can you tell us what you would do when you're confronted with a dam that you're going to need to evaluate?
First thing is
What's your process?
look at its history. Pull the original construction documentation to understand how was this thing built? What does its foundation look like? What were the measures taken to control seepage? What were the materials used in the earthen embankments, especially because generally that's the weak link. And looking at what was, or was there a hydraulic design involved in that process? And some of them built in the 1800s were just built to cross the river and open up to the full flow of the river if they needed to. So they didn't have the information we have now. They didn't have the years of history of the precipitation events to help them determine what those flow rates were and what they needed to do. So historically, you want to look at all that background. And then if you have them, look at the construction notes from the on-site engineers, if there was one. During that time, a lot of times there was not. But you could at least ascertain from those documents how carefully the construction process was monitored and performed. And then looking at what's the history of the dam's operation. Has it performed well? Has it not performed well? Were there any intermediate construction actions taken to stabilize any particular parts of the dam? Were there issues with getting the dam to work, to operate the way it should? Has the operator, has the owner been a responsible owner? Have they done what they've needed to do to keep the dam maintained and operating properly.
And what types of documents would you look at for those purposes?
Everything from the original construction documents to any engineering documents that were produced as part of the original construction and any remedial actions taken from the original construction to the point of the inspection.
And would that include engineering reports?
Yes, it would.
In this case, did you apply that methodology to the review that you did in this case?
Yes.
And the methodology that you used follows follows what's used nationally?
Yes, it is. That's why I asked you for those specific documents.
Okay, and that's, okay, what evidence did you ask for when you were asked to review this case?
Knowing it was a project that was licensed under the Federal Energy Regulatory Commission, I knew we had the upper hand as far, and I mean, we as dam safety engineers had the upper hand because their regulatory authority is more broad reaching. And they require a certain set of inspection and analytics, mainly the Part 12D inspection program, where you get great background information, you get all that historical information in one place, you get the studies that you need, the hydraulics, the hydrology, the stability, the seismic, all that in one location and one set of documents. That's why I believe it was the first one that I asked you guys for was, I need the Part 12D stuff, and that's could be a challenge because it's considered critical infrastructure information.
B.
Well, D.
12D is in David, yeah. So, and those are extremely valuable documents because not only do you get all that background information in one location, and you may not get what you want, and I didn't. That's why I came back and asked for other certain documentation that we could pull that further identified the background they used to come up with the documents necessary for that Part 12D inspection. So when you get all that information, then you figure out, well, there's still a void here. What do I need to see? There's still something missing in the original construction that I'm not seeing in these or whatever it is. So the short answer was yes, those, the Part 12D is huge and it gives us that overreaching federal authority. They go through what's called a probable failure modes analysis or a PFMA. And I will try really hard not to use acronyms because I don't like them either. But for the purpose of the PFMA, what the very short process description is, the dam has all these components, and within all those components, there's a potential that they fail. So you go through an initial screening, and you'll see in the 2015 PFMA that in the Part 12, that it will show the initial screening and what's more likely to fail than something else. And then you go through what's called the probable failure modes analysis, and you pick those apart in a room full of experts that have specific expertise in that very narrow part of the field. And then you have dam safety experts in that team as well, myself included. And I participated in those as a state dam safety engineer too. We were invited to those and sat through them and determined whether or not those probable failure modes should move forward to further evaluation. And that is incredibly valuable when you're trying to analyze a dam, especially the first time around.
Were you provided that information in order
Yes.
for you?
Yep.
Okay, I want to look at, okay, you have some binders in front of you, not the white one, but the blue one.
Yes. Yeah, there's no way. Yes. Yeah, those are documents you would normally review. I'll be honest, you normally wouldn't look at emails and stuff like that and just going out to do a dam safety inspection. But you would look at historic records on, especially another huge advantage is FERC goes back and forth with the owner, FERC being the Federal Energy Regulatory Commission, and that correspondence is very important because then you see what FERC was concerned with and what the owner did to respond to that.
I'll look at it, at the second slide, which is Exhibit A, Volume 1, the Appendix B. Can you pull that up?
The PFMA, what's the A stand for again?
Analysis.
Thank you. Pretty sure that's what you said, but
I hope so.
didn't catch it. Thank you.
Can you see that document, the appendix? Okay, who's going to put it on the board?
Yeah.
Oh.
Jeff, can you share the screen?
Nope, that's not Exhibit B, that's the
What you're
report.
looking for?
Well, you know what, let's just use the report right now. It's, you can put on the screen from Volume 1, which is Exhibit A, the declarations. And, can you look at that? And this is the your declaration and you executed that document.
Where is it in here?
It's the first thing in that binder. If you go to the very front, ahead of your resume, CV, the next one should.
Oh. Thank you.
You're welcome. There's no pressure on the court. I get to just sit here and take notes. So you're very welcome. And let me just interrupt briefly. I have some L4, L5 issues in my spine. So on occasion I'll be standing up. If anybody else is so burdened, please feel free to do so. So I used to tell juries, you can't do the Marine Corps Daily 7 of jumping jacks, push-ups and sit-ups. But if you need to stand and stretch, you're unless it starts to become distracting, you're more than welcome to do so. So I'm going to be standing here in a minute. It's not because I'm going anywhere, Ms. Almond Road, or because I'm anything other than very interested with this in this testimony, but I do want to just stretch my back. So
Thank you.
thank you.
Is that a declaration that
Yes,
you want to get a flat okay?
it does.
Well, let's move to Appendix B. It's titled Exhibit Cited. Does that Appendix B reflect the exhibits that were cited in your report?
Yes, it does.
I'm calling it report, it's the declaration. Yeah.
Yes,
We understand.
I understood what you meant.
Okay.
Yes.
Now I want you to look at Exhibit A, Appendix C.
I feel like this is an SAT question on logic and I'm having trouble. So where is that?
That's also in the same binder, and it goes, his report, Appendix A, Appendix B, Appendix C.
And that's in the white one?
Yeah, it's in the white and volume.
No,
No,
that one.
it's in ours. That's Nate's. That's Mr. Gamble's. We're not ready for that one. So, no, it's right there.
I'm really sorry. I'm just. You may.
If you look up to the screen.
Right.
Oh,
And I do want to acknowledge the very substantial work of both plaintiffs and defendants counsel and preparing the exhibits for the court. I know I gave a burdensome order.
My fault. I have the wrong volume. I'm citing for C. For C is actually in volume 3. I think.
I completely lost my vision on this, so. So it's fine.
C. Dana, am I wrong? Is it 3?
Spring.
Okay, it's in volume 3. No wonder it was misdirecting everyone. Sorry.
All good. We haven't lost our video feed yet, so it's a success.
There we go. Okay. Thank you.
Okay, got it.
Have you had an opportunity to look at that yet, Mr. Sturtevant?
Yes.
And have you been able to find it, Your Honor?
Yes.
Okay. This is titled Index of Materials Reviewed and Considered. Just to be clear to the court, we did not print all the documents that came with Appendix C. We spared you all those binders. So whereas the other,
First of Michigan, thank you.
so did you review the documents that are listed on Appendix C?
I did.
And was that hundreds of pages, thousands of pages? What was it?
A whole lot. I would, in the hundreds at least.
Yeah. And some of the documents in that it lists, for example, you looked at inundation mapping. If you look at number 8 on that. Nope, first page, Craig. Yep, right there. You have a list of some things. You say you looked at 2007 inundation mapping. What was the significance of that?
Like I said earlier, the inundation mapping helps set the hazard rating for the dam. And to be clear, the hazard rating is not the physical condition of the dam, it's the threat the dam poses to the downstream areas.
And at number 8, it indicates 2010 STID for the Edenville Dam. What's that?
That's the technical information document that's prepared as part of that Part 12D inspection.
And what kind of information does it provide?
Background information, technical information, summaries of some of the studies, that kind of information.
And
Can you hold on just a minute?
okay.
I apologize, but I'm, when I hit at the appendix. Oh, I see. Okay. You're still on the narrative, page 1 of 45. Is that right?
And no, not of the 45. We've moved on from Appendix B.
Yeah.
This is,
Sure.
Yes, 145.
okay, thank you.
That's it was such a rare treat as a federal prosecutor to have a co-counsel or a military lawyer. But boy, when you have a co-counsel, it's nice because they're, no, hey, like, thank you.
Well, Ms. Fraser's an alumni of the Court of Appeals, so she knows her stuff.
We have only the best and brightest that serve the people of Michigan and the court on our staff. The judges, we're fortunate to be here, but our staff are truly outstanding. So.
Okay. It also indicates that you looked at the 2011 HEC-RAS.
Yes, that's the computer model that routes the flows through the reservoir. And
What's the flow?
HEC-RAS, it's a program that's developed by the Army Corps of Engineers for modeling the hydraulics involved. And it can synthesize a failure of the dam and then identify what that inundation area is downstream on mapping.
And you looked at it for the,
You're
what
welcome.
was available for this, for the Unionville
Yes.
Dam? Did you look at it?
Yes,
And and reviewing modeling, is that something that you have done throughout your 40-year career?
yes,
You also reviewed the transcript of the hearing on the Part 307 proceeding. What did you understand that to be?
believe that was the water level hearing.
Uh, and number one indicates you reviewed the Natural Resources and Environmental Protection Act. Did you review the study?
Yeah,
mean,
I
the
reviewed it,
statute?
yes.
Okay. And I'm not going to go through each one of these, but this lists some 225 other documents, and you reviewed all of those. Did you review all of those?
Yes.
Okay. Did you review any published material informing your opinions?
I did read an argument from, not an argument, but an article. There was a short publication by ASDO. There was also something in the American Society of Civil Engineers documentation talking about the failure.
And did you review something from the Department of Interior?
On this particular failure, no.
Okay, the design of small dams.
Oh, yeah, that's kind of the Bible of dam safety. That's the design standards, design techniques, calculations. It's an older volume, but it sets the theory and the precedent for what we're seeing now with computer modeling.
Can you just, in a couple of sentences, summarize your opinion in this case? Or more, if you need more, but just, I'm not asking you to do a long dissertation. We'll go through everything individually, but can you just give us a brief overview of your opinion in this case?
My opinion is the failure could have been avoided with some changes to what happened out on the dam prior to the flood event. And measures could be taken if those changes to the dam could not be made in a timely or expeditious manner that would have either prevented or made the failure very unlikely. And that would be get the pressure off the dam is my first and strongest opinion. Is there was too much pressure on that dam. It couldn't hold. And that's in the way of high water levels behind an earthen embankment that wasn't properly reinforced or constructed.
What I'm going to do is go through some of the documents that you reviewed and how they help you inform you.
Okay.
Let's look first at in volume 1, the actual exhibit 1 behind the report, which is the FERC 2017 compliance order. They need to share the screen again.
Jeff. Thank you. Thanks, Jeff. So when the Supreme Court is reviewing this record, I'm not just shouting names randomly, speaking out. Jeff is the IT expert who's in the roving room monitoring everything and making it work so that we can use technology as well as old fashioned paper. So thank you.
And at the time that you were formulating your opinion, did you review this document?
Yes.
And did we review this document yesterday again?
I did look at it again yesterday.
Okay, and did you identify some sections that were particularly important to you yesterday?
Yes.
Okay, we're going to put some of those up on the screen and talk about them. Let's, first off, as an overview.
Just sort of for planning purposes, we're about 12 minutes before the hour of 10. We've been going for a little, at 10 o'clock, we've been going for 90 minutes. We're going to take a 15-minute recess at 10 o'clock, just for people's planning purposes. So
Thank you, Jan.
I am guessing this witness, the direct exam will not be completed by 10, but
I
so
don't
we'll
think so.
then continue with the assistance of this witness's testimony after the morning recess. So just for planning purposes.
Thank you.
Okay, you want to put up page 1 of that document,
Which page, please?
page 1.
Oh, great.
1 of 53. And, okay, we've highlighted number 2 here. I don't know if you can see the screen, Phil, Mr. I want you to review that, tell us what's significant to you about this in terms of your opinions here.
In my opinion, this is what caused failure of the dam. And FERC knew that it was a serious issue, a serious enough issue to finally revoke their license, which FERC does not do lightly. That should jump out and go, this is really a serious issue. We need to deal with it. We need to see if, FERC requires a probable maximum flood or a PMF for their high hazard dams. State of Michigan's a half PMF. It's not 50% of the PMF. It's a half of a PMF. So at the very least, I would look, can it pass that? What can it pass and what can't it pass? That would be the single biggest violation in this document that I would look at and do some serious research on to find out, well, wait a minute, if you overload an earthen embankment, it's sure to fail. Not really, no. It's PMF has long been an issue because it's not identifiable with a return interval. So you can't, there's no predictability. It's not like a 100-year event or a 1,000-year event. It's more like a 10,000 or a 100,000-year event. It's a huge, many of us in the field call it the Noah flood. In Wisconsin, it was 29 to 30 inches of rainfall in 24 hours. Extremely large precipitation event.
What is a PML?
Probable maximum flood is what they're using as what's called the inflow design flood, IDF. And that means the dam has to pass that. So that flood is plotted in what's called a hydrograph, a time versus flow relationship. And then you figure out, can the reservoir and the spillway safely pass that water? Because a critical component of spillway capacity is reservoir storage. I mean, that's why we want to leave our wetlands alone, right? So wetlands absorb that flood water. So upstream has to store the water and then the dam releases it. The combination of those results in the spillway capacity. So you have many dams across the country that sit dry all the time. They're flood control dams. You probably see them in your neighborhoods as stormwater ponds. That's the same thing, only on a much smaller scale. You fill it up with water and you discharge the water slowly so it doesn't damage the downstream. It's that, I mean, that's the clearest way I can describe it.
In terms of spillway capacity, what is it?
Spillway capacity is the ability of the dam or the spillways, the outlets of the dam to pass water downstream. And it's not just the physical opening of the dam and how much water you can shove through that hole. because you still have to count on the reservoir storing some of that water. Because there's many dams across the country that you can't look at a snapshot of just, if we open all the gates, can we pass the inflow design flood? No. None of the 25 dams that I'm responsible for fall into that category. We leave a buffer in the pool, or we leave the freeboard from how high we hold the water to how high the water can get for either one of two things. The dam becomes unstable in a computer model, or we run out of storage room and the spillway, the auxiliary spillway, the emergency spillway, whatever you want to call it, can discharge the rest of the water. So we purposely never spill our dams so that we've got 2 to 4 feet, depending on the structure, of extra storage sitting in those reservoirs, should we get that kind of rainfall event. And we can control every single drop that goes in and out. We don't have run river dams.
But here, did the Eagle Dam have extra storage capacity
If it was kept at a lower water level, yes.
at the levels that was kept? It would have extra storage capacity.
Yes, some. You can count on being able to fill the dam up to the point, again, where your stability analysis shows, or the data that you have from your monitoring equipment shows that the dam is stable at those elevations, at those water level elevations. It's literally as simple as loading a foundation. You can't put too much weight on it, or the building's going to tip over. It's really the same thing.
Number 2, the commission cited a concern of the high capacity rate of the, and that it would that if it failed, it would create a threat to human life, and it would cause significant property damage. Was that significant to you?
Yeah, that's literally the definition of a high hazard dam. A high hazard dam is going to cause loss of life. It's likely that if you have an adequate emergency action plan and enough time to warn people, you might be able to prevent that, but you can't prevent people from not listening. So you have to count on that factor too. And there are, in the risk analysis portion of what FERC calls now a FERC Part 12D comprehensive assessment, you have to do a risk assessment as well. And that risk assessment looks at things like, how likely are people to actually be able to get out of there? What happens during daytime? What happens during nighttime? What's the population during those specific times? And what are we likely to see for loss of life if the dam fails? And we just went through it on our one FERC dam, and it cost my budget $700,000 plus to do that one study, because these are very extensive, and the Part 12D and now the Part 12D comprehensive assessment program is extremely expensive, but it's comprehensive, and it gives you that risk assessment of what they're talking about here is likely to cause it. Okay, let's figure out what's really more likely based on history, statistics, risk analysis, to really come up with you'll never get a warm, fuzzy feeling with the dam, but at least you'll be able to identify what hazard your dam poses.
What's the risk of an inadequate spillway capacity?
That's one of the biggest things. I mean, other than a concrete structure moving and coordination with inoperable gates, or we can come up with a number of scenarios that involve foundations, abutments, seepage rates, seepage location, seepage expression on the downstream slope. We can go through all that stuff. But really, what it comes down to is loading. If you don't have the spillway capacity, the water is going to get too high. It's really that simple. And it's not a matter of if it will happen, it's a matter of when it's going to happen.
So is that a red flag?
That's a big red flag. And what I saw before I retired from Wisconsin, starting in the late 1990s, was a real change in the climatological events we were seeing. And talking with my cohorts at that time, including the state dam safety engineer from this state, and Iowa and Minnesota and Illinois and Indiana, were these huge, large scale chained events, not necessarily one massive precip event, but a chain of events that resulted in saturated soils in the watersheds and prior to a continuous rainfall. And we're seeing that more and more. And whether or not you believe in global warming, that doesn't make a difference. The statistics are there. The climatological environment is changing.
Let's look at page 2 of this order.
Excuse me.
Typically, item 3. That's another. That isn't that.
Mhm.
We can talk about that.
Solomon Road, is this a convenient time to take?
Certainly.
Okay, so it's 9:59. Looks like we're going into another section of this document. So we'll take a 15-minute recess. We'll reconvene at 10:15. 10:15 means 10:15. So we'll be ready to start testimony then. Thank you.
Thank you.
It's asked for 15 minutes. Please go by. Yeah.
You know what, maybe I need to bring this mic closer and that can help. If I bring the mic closer, because Craig says he's having trouble hearing me. And I didn't know that.
Yeah, this.
I know,
Swear down,
yeah.
because when you turn.
Yeah, well, I can put it a little bit over. Then we're gonna go to 12D. This is, because I couldn't get that printed, I was gonna make a copy of that for you. This is the order. We've got everything. No, you can just have it. I don't have any need for it because my binder's got it in order.
Yeah, that's all. I didn't hear you last time.
I'll put it over here.
I didn't hear sharing. It was no indication that you're sharing, but I had.
Yeah.
So that all people want to, because it's live stream.
Yeah.
So all they see was last. Looked off. That makes sense.
Yeah, I understand.
apologize if I'm a little bit-
That's okay.
The last time Judson Ajay turned.
Yeah. Well, yeah, Craig's operating it but I'm vertically challenged and I think you're having that over here and, over here. I think it's probably better here than you'll probably pick.
That's fine.
Yeah, pick up.
We can sit up here. but I think we're fine in everybody.
Okay, yeah. Well, is that too high to pick up my voice?
Oh, no.
Okay. Okay, yeah.
But the call's pretty big.
Oh, okay.
If you're over here.
Oh,
but that's in
Okay.
your face.
yeah, because I have a,
That all- You're-
oh, yeah, that's fine. Now I can't find my pen. Okay.
I thought I had a piece of photo. So.
You can see the. Oh, okay. So, hopefully everybody doesn't have fat backs. All right. Ready?
Yes, we are.
Sure, then you're still on the road. Please continue.
Let me,
It's 10:15 or 10:14, sorry.
okay. slide 5. Pardon? Okay,
Let me
we
just
need the screen
interrupt real
share.
quick. Jeff, we do need the screen share. Mr. Trudell, any issues or concerns with regards to your extremely important role in the process? Anything we're doing wrong that we need to fix?
No, we're good.
All right,
Thank you.
thanks so much. Appreciate it. Okay,
Okay, you want to take a look at item 3 at the same exhibit that we've been on, page 2 of 53.
Yes.
Okay, I'm going to take a look at that and then tell us why that was important information to you from this document.
excuse me.
It just gives you the physical characteristics of the dam to understand that there's two spillways available and what they consist of.
As a regulator inheriting this dam from FERC, is that important information?
Yes,
And is it do you understand if the state had this information available to it?
it is my understanding. And that's, again, based on experience. When I was with the state of Wisconsin, I participated in these we were allowed to come in and view, and if they had a question for us, we could answer it, but we weren't a voting person on the PFMA type process. So we had access to this, and FERC supplied these to us on a regular basis.
But let's talk about when they assumed regulatory authority at that point in time, September 25th, 2018. After that, would they have had access to this information?
I assume they did. And again, this is a gift to a state regulator when you take over a dam to take over a federal dam, which is very rare. But because you get this kind of background information that just doesn't exist on most of your other dams you have to regulate.
Let's look at page 4 of this exhibit. Item number 7. Can you read that first sentence to us into the record?
Given Edenville Dam's high hazard potential rating, the potential loss of life and destruction of property and infrastructure is grave should the project not be maintained and operated appropriately, with consequences that could certainly affect the village of Sanford, Northwood University, city of Midland, Michigan, and other downstream and other areas downstream, excuse me. So it kind of surprised me that, and now they would classify this as a high hazard, a class 1 high hazard, because of the number of residents that are in that inundation area, which makes it their highest hazard classification.
And did that provide important information to the state regulator?
Yes, because this would certainly then, and they knew this, that it was a high hazard dam to begin with.
There's a lot of information in this document, but we're not going to go over all of it. But did you review that at the time that you prepared your report?
I did read through the whole thing.
Okay. Okay, I want, Craig, can you pull up okay, Exhibit A, Exhibit 11 to, I want to, that's not what we're going to use as Exhibit A. I want you to pull up Plaintiff's Exhibit B, Volume 2. Which is identified as the 2015 Consultant Safety Inspection. I'm sorry. That's Volume 4. Thanks. It's the 2015. Okay, Volume 4, Plaintiff's Exhibit B2,
Oops, I didn't hear that last bit, please.
Volume 4.
Yes,
It's the 2015. Okay,
yes.
okay.
What tab number?
Tab 2. Should be the 12D report.
Okay,
Did you find it?
yes.
Okay. Okay. Oh, okay, you're ready for it. Okay. I do want to provide one clarification that the report, when it was submitted to the Attorney General office in accordance with the court CMO guidelines, this report was attached as Exhibit 11, which is attached to Volume 1 or Volume 2 rather, Exhibit A. And it was, but it didn't, when they attached it, they didn't attach the copy that had colors. And he actually reviewed the color one. But so that there would be no misunderstanding of what we actually submitted to Mr. Gamble originally versus now, we're making this a new exhibit to the report, the color version.
Campbell, council, any issues?
I don't think so. You're just saying that you're presenting the color copy here?
Yes,
Yeah, that's fine.
yeah, but
No objection, Your Honor.
because we originally did the black and white to you, I want to make sure that you know that he did review the color copy. It's
Okay.
just it was attached wrong. Okay.
Any further clarification?
Okay.
No objection by the defense. Appreciate it.
Okay.
And in this binder, where are we exactly, please? Sorry.
Okay, we are in Volume 4, B2.
Thank you.
Mr. Sturtevant, how long is this document? How many pages?
It says it's 197.
Okay. And did you review this document?
I did review it.
And,
It's actually shorter than the ones I'm used to.
but did it provide a lot of pertinent information to you?
Yes, it did.
And is this the type of document you've been talking about earlier this morning that a federal dam has available to a regulator?
That's correct.
Okay. And in reviewing this document, there were a number of items that you identified. And so why don't we go to page 8? That's 8,
Okay.
page 8. Okay. Can you read the section on, can you look at the screen and see that section and can you read that into the record?
Yes.
Yeah, okay, but can you read it for us or out loud?
Oh, I'm sorry. Several piezometers, numbers 48B, 47C, and 46B show cyclical swings of up to 7 feet. In comparison, readings for piezometers 48A and 50A, which are roughly in the same cross-section of the embankment, but higher up on the downstream slope, remain nearly constant.
What was the significance of that to you?
That tells me that the phreatic surface of the standing water level inside the embankment is very reactive in,
I'm sorry, what page, please, is this?
This is on page, 8 of 197.
Thanks.
This tells me at least those three piezometers were very reactive to changes in the reservoir level. That's what causes those cyclical changes. Now, piezometers that are located within the embankment generally do respond somewhat to reservoir levels, but 7 feet is pretty significant on a dam of this height.
First, I'm sorry, I interrupted you.
I wouldn't expect to see that, but this further supported the construction documentation that said that the soil characteristics were medium loose materials and they weren't highly compacted, semi-permeable or permeable plastic soils, that they were more granular in nature.
And you put a lot out here. Let's try and unpack this. Okay, first off, what's a piezometer?
Can I use the whiteboard?
Oh,
Are you okay
absolutely.
with me
Oh,
getting
Your
it?
Honor, may he?
Yes, thank you. I'm sorry, in defense, any objection from the defense?
No objection.
Thank you. Please proceed.
It's easier to show it than to do try and explain it. I get different colors do that. So, do you want to be in that?
You gotta have the mic with you. There's people out there in cyberspace listening to you.
Most importantly, our court reporter,
Oh,
who I want to have record of what we're doing.
Hopefully he can hear this well enough. So,
I can hear you now. Yep.
All right, thank you, Mr. Trudell.
so inside the dam, and we'll just use really simple stick figures because I'm not an artist by any stretch of the imagination. So you have a cross section of the earthen dam. And inside any earthen dam, I don't care if it has a steel face and a geotechnical or a geotech liner on the upstream side, a fabric liner or a steel wall, whatever, there's going to be water standing inside that embankment. The embankment itself has water in it. So if this is the pool level here, or the reservoir level, there's going to be a water level inside that embankment. Controlling that water level, what's called the phreatic surface, is critical for that embankment to remain stable. I've shown this phreatic surface exiting where it is because that's the worst case scenario. Is there literally is no control other than what material is in the embankment. There's no core, there's no impermeable layer in there to force it down, right? So if the water were to exit the embankment there, the dam fails. It's really that simple. So what you want to do is drive that down either by making the embankment bigger, putting drain tile down here to drop that water level to collect the seepage water, because every dam's going to leak. You just want to control it. So you collect that seepage water and then discharge it downstream in a safe manner. So the piezometer is just literally a point well that's stuck into the dam. You drill a well, it's got a casing around it, and you put it either into the embankment or very deep into the foundation if you suspect there are foundation issues. And then you have a screen section in here that picks up, that collects the water, and then the water that stands in here represents what that screen, where that screen. So if it's in the embankment, and that's what these were, is you put them down into the embankment and not to scale. You put them into the embankment and that tells you where that phreatic surface stands. So as this water goes up and down, so like when they were allowed to do winter drawdowns, that phreatic surface goes down. The water level's down here, that phreatic surface goes down somewhere. Can't tell you where, because it's not to scale. But when it goes down, the dam is safer. The embankment is more stable. The soils are dry. They remain however cohesive that particular soil type can be. So when they're talking about a 7-foot range, that means the range inside here changes 7 feet cyclically, which is commonly used term for annually or with changes in the reservoir elevation, the water level in the reservoir itself. And I'll use the term reservoir just so we don't get into lake, pond, stream, whatever. So that's all that is. A piezometer is a well. It's an extremely useful monitoring tool along with seepage weirs that collect this water that tell you, does that seepage increase as the water level goes up? And it does say it does. Of course it's going to, but you want to keep it low enough so you're not moving embankment material out of the embankment itself.
But what does the cyclical swing of 7 feet mean to you?
It means to me that the soils inside the embankment are poorly compacted and they're probably more granular than they are a plastic type soil, a
And what,
non-permeable soil.
Type soil?
Less permeable, we'll say that. Clays are plastic, sands are granular. That makes sense?
No, but
Okay.
I'll look it up.
There's an old school way that we,
Equaling plastic does not, I
it's
don't
the way,
understand.
it's physical characteristics in the lab is really what it comes down to. There's an old school way that any engineer can use when they're building a dam and you suspect the soil they're using doesn't have enough clay or silt in it to prevent that kind of cyclical movement or prevent excessive seepage through the dam, is you pick it up and you roll it in your hands. And if it rolls into a ball, you're good to go. And if your hands are dirty, you're good to go. If your hands are clean, there's a problem.
in terms of the cyclical swings of 7 feet though, what kind of flag is that for the regulator?
That higher water levels behind the dam could absolutely occur or coincide with higher water levels inside the dam.
Okay. Let's go on to the next section of this report. There's a chart here called potential failure modes, and you've sort of touched on that. But what is it in the context of this document and this,
I kind of touched on it very shortly early on. This first table is the potential failure modes, looking at each one of those specific pieces I talked about earlier of different components within the dam where there are different materials in contact. So concrete in contact with soil, man-made fill in contact with natural ground, either in the foundation or on the groins or the abutments of the dam. So what you do when you're going to conduct one of these studies is go through each one of those components of the dam and determine if on this particular structure is that a threat, and do we need to look at that further to determine if something needs to be done to correct it. That's really what this whole analysis is trying to get to. So on number 2,
can you read
thank
that?
you.
Can you read that out loud for the record?
The embankment is overtopped during an extreme flood event. This could result in significant erosion of the downstream slope, leading to failure of the embankment and an uncontrolled release of the reservoir. And that's the other reason I used reservoir, because I didn't use a lake in this.
And it's under the column category 1.
That indicates that the team that's working on this is deciding that needs further investigation.
And what's the significance of this item number 2?
In this particular case, embankment overtopping because the dam did not have adequate spillway capacity, the likelihood of embankment overtopping or embankment failure increases because you're going to stress that embankment. You're going to fill it up. You're going to push that phreatic surface up. And if you've seen the video of the dam failing, that's the reason I have the phreatic surface exiting where it is. It's a third of the way up from the toe. And that's typically, historically, worldwide, where earthen dams fail is that 1/3 of the way up from the toe.
And the second part of this could result in significant erosion leading, I'm not going to reread the whole thing, but that's the second part. I want to get to that. Can you explain the significance of that?
Unless specifically designed to withstand overtopping. So may I?
Mhm.
Thank you.
I'm assuming there's not an objection to the witness getting up unless somebody indicates otherwise.
No, but you might need the microphone.
Oh,
Thank you, Your Honor.
Thank you, Mr. Gamble.
Be loud enough, my kids could hear me a county away. All right. So if this thing were to overtop and the water got up this high and it started to go over, which indeed it did eventually, when it started to slough off, the dam did overtop. When a dam that's not designed to overtop does, it will fail. How do you fix that? You either flatten that downstream slope or you provide enough spillway capacity elsewhere in the structure where the water can't get that high under the design flood. And the design flood is based on what's downstream, what's the hazard potential for that particular structure. So that's what they're getting at here, is that because the dam can't pass the design flow, and I realize it's under FERC regulations at this point in time, so it's a full PMF, not a half PMF, but it doesn't make a difference. If it doesn't meet the capacity requirement, it doesn't meet it, regardless of what that requirement is. A percentage of a PMF, a flood that actually gets a percentage or a likelihood of occurring, 100-year event is probably what most people hear. A 200-year event, a 300-year, not a 3 because you don't really ID that one, but a 5 or 1,000-year. Some states regulate to those types of events and some do based on a percentage of the PMF.
what is this a red flag for the regulator?
This just.
This item number 2.
Yes, that's why they chose to move this particular probable failure modes into the analysis stage of this process.
And when the state and FERC ceased when FERC ceased regulating the dam and it ceded to the state of Michigan, would this have been a flag?
Should have been. And that's again, the huge advantage to taking over a federal dam as a state regulator is, as far as I know, right now, there's only one state that does a similar type analysis or requires their dam owners to do it. And that's Colorado. They do it's a more advanced dam safety inspection process, and they help fund through their federal grant doing this type of work. And it's really helpful to us because then what it does is we get a bunch of professionals in the room, and then we can identify, well, if we're going to do work on this dam or when we do work on this dam, this is where we need to focus our efforts.
Did this 12D report tell the state regulators that this dam was at risk?
Yes.
Let's go on to item number 4, which is at page 9, item number 4 of this PMF analysis. Okay. Can you read that into the record?
Seepage through the embankment enters into a tile drain pipe or seeps along the embankment's foundation, resulting in piping or internal erosion. I can do a diagram of piping here in a minute. This could lead to a developing pipe or sinkholes connecting to the reservoir. Increased seepage over time could result in a blowout of the embankment and an uncontrolled release of the reservoir. So may I get up again?
Yeah, you can. Can you? Yeah. Can you? I'll explain what this means and the significance of it.
An eraser.
Oh, you know what? I don't think we do. Oh.
We have just, is that this hanky or?
No, paper.
Oh.
I was like,
I don't-
really?
I don't want Irish linen hanky.
You carry one of
Or,
these?
or the fancy hanky that your co-counsel brought back from his visits to Sevilla, Spain to be used.
No, that wasn't him. That was me. I didn't bring anything like that.
No, I'm saying you brought it and gave it to him as a
Oh,
gift
yeah.
because he's such a valued colleague. So, but good. Paper towels we can recycle.
So we talked about overtopping as a potential failure mode. Now, this one, this potential failure mode identifies internal seepage, foundation seepage, causing piping, a sinkhole, a blowout. You won't see the term static liquefaction in here. It's not a term PERC really uses, and we just underwent the comprehensive assessment one. They don't use that. Blowout is the same thing. When you see the video, you look at that dam, you're not gonna say, well, that's static liquefaction. You're gonna say that thing blew up, and it really did. So liquefaction on the federal level is really preserved, especially for the western states where seismic activity is a serious concern and a design parameter you have to work with. So liquefaction on this level in the FERC world, it is not the geotechnical term that was assigned to the failure mode when this dam failed. Liquefaction is a dynamic situation caused by shaking of the earth during an earthquake. And you assign a certain ground acceleration and a certain magnitude of the earthquake to design around. So anyway, we'll get on to what happens when this thing starts. The water levels go up. You get the seepage, you get that phreatic surface to rise, and you get the seepage, the phreatic surface rises, you get the seepage starting to express itself or show up on the downstream slope. And that's when you start to get movement of the embankment materials out of the dam. And as you do, it creates like a little pipe as the material washes out from the seepage. And as that increases, this gets closer and closer to the reservoir, and that's what they're referring to. And as it gets closer, the velocities increase, the flow volume increases, and the amount of material that's released and pushed through the embankment out of the embankment increases. So you either get a sinkhole forming above, you get total collapse of the embankment and virtual and overtopping and total failure. And as soon as it connects, the dam is gone. And it's usually well before that. I've seen piping failures occur on very small dams, but it usually only takes about a third of the way into the embankment and for part of the embankment to collapse, and there's just not enough weight to hold back that energy in the reservoir.
What, the piping, what is the piping form from?
From the material washing out caused by the seepage, the embankment material washes out. And that's why you want to build an embankment out of really tight soils, really well compacted.
In terms of this, how does it, was that information important for the regulator inheriting this dam from FERC? This information contained in item 4?
Yeah, this is one of the failure modes they push forward because with an embankment dam with already classified with loosely compacted soils within the embankment and questionable construction practices at the beginning, then you have the likelihood of embankment failure moving to the top. And the other failure mode they talked about was through the foundation or the contact surface of the dam. Even if it had a key in it or something, that foundation surface is again what I alluded to earlier. It's the difference between man-made and nature deposited materials. And that will also give you a plane for possible failure.
Is this a form of stability issue?
It would. Not necessarily. In a stability analysis is going to look at how saturated that soil is and different kinds of yes and no. So it's a hard question because piping can lead to that and just excessive seepage can lead to it when this downstream slope becomes unstable. So as the water comes up, this saturates, it's not as strong. So you start to get a slip in the embankment. And that goes way back into the hand calculations when you used to use Bishop's curves to do this kind of stuff, but now it's all computerized. You can determine where that slip might occur based on the soil compaction characteristics and the particulate matter inside the dam.
Did any of those events occur here?
Combination of all the above, pretty much. What happened was not necessarily this pipe forming, but the embankment became so wet and saturated, it lost its strength. If you, whatever you want to call it, static liquefaction, supersaturated soils, blowout, whatever. What happened was the thing filled with water. The embankment filled with water, lost its strength, slipped out. And you can see then after it slips out, we lose part of the crest and the water comes over and the rest of the dam fails.
And was that a potential, that potential event was flagged in item 4? Was that flagged in item 4?
Yes.
Okay. Let's go to item 9 on this chart. And can you read that into the record? That item 9, by the way, is at page 9.
Yeah, page 9, number 9. Significant deterioration of the concrete that comprises or compromises the spillway, OG rollway, or retaining walls leads to a structural failure of the spillway, resulting in an uncontrolled release of the reservoir.
Okay, what does that mean? What does that tell us?
When you look at the stability of a concrete structure, you look at tipping over, you look at sliding downstream, all a result of either uplift or deterioration of the concrete. So what they're looking at is the actual deterioration of the concrete, whether the walls deteriorate or the spillway. And this one has an OG spillway. It's a specific crest design that increases the hydraulic capabilities of the spillway versus just a rectangular weir like the top of the desk versus it's a very specific design based on the height and the expected flow rates that the water that it clings to the nap of that spillway, the OG spillway, and increases the capacity by up to 20% for the same opening. So that's the particular design that's underneath the gates.
Well, that increased the capacity by 20%. This was still had a problem with spillway capacity, correct?
But that's all taken into consideration before you do the capacity analysis.
Okay. And is this a flag for the regulator inheriting this dam?
Yeah, if they determined that the concrete was deteriorated enough that it could actually rise to a level 1 and be pushed forward, it should be a concern.
Okay, let's go to page 28 of this document, item 3.221. They're still on exhibit B2.
And this is, just to clarify, this is what follows after you do that pre-screening, is now they're getting into looking at the particular failure modes they see as more probable, more likely to happen, and analyzing them in more detail. So this is when you pull in the individual subject experts to say, tell us what you think. And then the rest of the group goes through and the team comes up with, do we keep moving this forward? What do we do about it? Is this something that needs to be addressed immediately?
And you're talking about the 12, in preparing the 12D
Yes.
report.
Yep, this is part of the now we've moved into the probable failure modes analysis portion, analyzing the probable failure modes.
Let's look at 3.221. And can you read that into the record, the description of the PFM?
Seepage through the embankment enters into
I'm sorry.
You said page 31 of 197?
28, Your Honor.
Thank you.
The bullet is 3.221.
Seepage through the embankment enters into a tile drain pipe or seeps along the embankment's foundation, resulting in piping and internal erosion during normal pool conditions. This could lead to developing pipe or sinkholes connecting to the reservoir. Increased seepage over time could result in a blowout of the embankment and an uncontrolled release of the reservoir. So, and this is at normal pool. So again,
Excuse me.
at the very onset, we talked about what you want to look at. You want to look at normal hydraulic loading, extreme hydraulic loading, and seismic loading when you're looking at these failure modes.
Okay, normal pool is what?
The normal water level that the reservoir is held at.
And what does this tell us? This 3.221, what important information?
They expected that the embankment was suspicious and that it deserved a closer look as how this moves forward.
In other words,
If this is an issue where the dam owner, the operator, the caretaker, whoever's in charge of it, would focus their efforts on inspection on these particular areas of the dam and focus any remedial action required on these particular areas.
and when the state inherited this dam from FERC, should this have been significant?
It's certainly a huge help because this sets the groundwork and saves a lot of time for the new regulator in determining what areas they need to focus in on right away.
Does it tell the regulator that the embankment stability is at risk?
Yes.
And in this case, did the embankment fail?
It did. And again, it really doesn't matter what you call it or how it failed. It's really, all of those are addressed here, whether it was piping, static liquefaction, i.e. blowout. All of those, it's just embankment instability.
You know, one thing you've talked about here is the core pressure on the phreatic surface. Can you explain that to us?
Just what I showed in the diagram is the phreatic surface is a direct reflection on the pore pressure. As the water level goes up, the phreatic surface comes up, the pore pressures increase in the dam. It's not anything overly complicated. It's just there's more pressure on the dam. And that's the more water you put in, the more pressure you put in. So it's just like overfilling a little plastic pool or something. You can only put so much water in before it either overtops or the sides blow out.
This flood event occurred during the springtime. Are there other considerations in the springtime regarding water levels?
Springtime is always the biggest concern, especially in this part of the world where there's generally some snow melt occurring and precipitation events that aggravate or increase the amount of flow coming down the river as a result of melting the snow and adding on top of that rainfall. So typically in the springtime, you expect higher flows. It's one reason a lot of dam owners in the upper Midwest and in Dakotas and upper part of the East Coast draw down their reservoirs in the winter to protect them, to add that extra spillway capacity or to add that extra storage capacity behind the dam to pick up those spring runoffs. I mean, that's pretty common practice, and it's a commonly used activity.
Do you have an opinion about the water levels in this case in terms of how high the state wanted the water levels to be kept?
I think the normal pool levels that were established weren't unreasonable at all for a dam that met required spillway capacity and had been properly maintained over the years. It wouldn't be an issue to hold the level that they wanted the water level to have, and the riparian owners have a word in that. So if the dam was in good shape and it could withstand pressures above that, resulting in or from flood flows that you can readily expect, that water level would have been okay.
But was it okay in this
It
circumstance?
turned out not to be. They didn't have the spillway capacity to maintain that level during a flood event.
And the fact it didn't have that spillway capacity was known. Was that known?
Can you rephrase that, please?
You said it turned out that it didn't have the spillway capacity.
Yes, that's correct. So
Okay, but was it known before the flood that it didn't have the spillway capacity?
yes, that was one of the items that FERC cited in their revocation process.
And in setting water levels for this dam, should that have been a consideration?
Absolutely. Dam stability is still the number one issue you consider, along with, that should be first and foremost, is the public safety. And then you look at what the riparian rights are. Does the owner of the dam have the authority to flood the land? And then you have to look at, of course, down the line, you're going to look at what are the environmental concerns. Are we flooding out wetlands? Are we affecting some endangered species? And that's what you use experts along those lines for, secondary to public safety.
What is the primary responsibility for the dam safety engineer?
Public health and safety.
In this case, in the fall of 2019, if you assume that Boyce Hydro applied to lower, okay. Oh. You were going to say something. I was anticipating that Boyce Hydro filed an application to lower the water levels.
That's my understanding.
Should those water levels have been lowered at that time?
I don't believe they were. They might have. It becomes kind of confusing to me with all the dates. I know they raised them and then they were
But I just
forced
want
to
you to
raise or
assume,
lower them, and then they were
I
forced
want
to
you to-
raise them because of environmental
yeah,
concerns.
I want you to assume that they requested to lower them.
Okay.
Was it an appropriate course of action to lower the water
Oh,
level?
100%.
And if you assume in the spring that they raised the water level because in the state conditioned it on Boyce agreeing not to change, lower the water levels. Was that appropriate at that time?
Objection, lack of foundation.
Response.
Oh. You-
What's your response to the
Have
board?
you,
To the objection.
I think he's established his familiarity with the water levels in this
overruled.
case.
You may respond.
Could you rephrase the question again, please?
If you assume in the spring, they applied to raise the water levels and the state conditioned it on them agreeing, the owner of the dam agreeing not to lower the water levels again. Should the water have been raised in the spring of 2020 in view of the condition of this dam?
No.
And why is that?
Again, you want to provide that additional storage, which results in additional spillway capacity. And it's your factor of safety as a regulator to say, if nothing else, let's wait till we get the snow melt, we get the runoff, we get that precip event that is likely to happen. It may not. But the risk isn't worth taking. So as a regulator, and it is in the purview of the state of Michigan to order the lowering of the water level until work is done or in the event of potential public safety issues. So that's really the strong arm approach you don't want to have to take, but is there because it's necessary. And in this case, it should have been done until the work was performed. There's a long history of noncompliance. And it's not a cheap or fast process, but nothing promotes getting the dam brought up to standards like not having your reservoir full of water.
The fact that there was a history of non-compliance, is that a flag to the state regulator?
It is, and it can certainly be made a condition of the transfer of ownership to the new owners is, before everything is done, before the transfer is done, we need a plan and we need a plan of attack. And if it can't come for a period of time that's not acceptable to the state and their engineering staff, then draw the water down until you can get it done. It's really that simple. And it's not an easy decision to make as a regulator because you are going to take a lot of heat for it. But that's your job.
Are you aware of the fact that the state filed litigation against Boyce Hydro over lowering the water and the impact on mussels?
I am aware that that was an issue.
And as a regulator, what do you consider about those courses of action?
You approach the biological side of your organization and say, is this impact really greater than considering the public safety impacts of losing the dam altogether? And if we lose the dam, you've lost all your mussel beds over the entire stretch of that reservoir. And you most likely are going to dry up the wetlands on the upstream end of the reservoir as well for a period of time. And that will change their configuration. That's what you have scientists for. It's not to make the decisions related to public safety.
Does the dam safety trump the environmental concerns?
Public safety does, yes.
Should the dam owner have been forced to raise the water levels?
No, they should have been required to lower them.
And how low should they have lowered them?
As low as possible without breaching the dam unless it was determined that breaching the dam or cutting out a large portion of it to pass all water down and not retain any dead pool, it's called, behind the dam. You don't necessarily want to go that route because you're kind of in the same route that you are right now, is now you're rebuilding an entire embankment. And to do that is always a risk in that you now you have to blend the new material in with the existing, and you have to make sure that everything is cohesive and consistent through that embankment section. Again, if you call for a forced breach. So the logical thing to do is to bring it down to the spillway crest and leave it. And it may take 6 months to a year, depending on the climatological situation, in order to completely drain the reservoir and the surrounding soils to bring that water level down as close to the spillway crest as you can possibly get it.
How low should the water have been? Lower to, what are you?
All the way down. The gates.
But all the way down, we
In a
kind
situation
of
when
need
you're
to-
going to order the dam lowered to its full extent, you lower it down, you open the gates all the way. And if that takes special equipment or a boom or a crane or whatever, you get it in there and you do it because it's not an emergency situation. You do it in a controlled environment, which is safer. And then you literally chain those gates open and lock them so that people can't mess with them, because they will. There's going to be a lot of angry people up on that reservoir that want their water levels back,
But what level should have been lowered to?
all the way to the sill.
And is that called Run of River?
That's called, in this particular case, it'd be Run a River.
And you mentioned the gates. Were the gates fully operable here?
They were not. And that was one of the huge issues.
And what was the problem with the gates?
The configuration over the years, and this is really common with radial and or Tainer gates that swing up like this, is that the attachments to those gates deteriorate over time, just like everything else in life. And when they get put back in, they don't always get put, the components don't always get put back in as originally designed or as configured in such a way where the gate is readily operable the way that the operation on the gate and the cables or the chains are attached to the gate. And the way these were attached, the reports vary between 6 and 7 feet as their maximum potential opening without the use of an A-frame device to pull it the rest of the way open to a full 10. And some places they call a 12-foot opening, but we'll call it 10 foot opening. So you do that in a controlled environment. You can't do it in a flood environment because it was proven that it wasn't safe. And that makes sense to me, because if these gates, and we'll get into that, so I want to stick with, you get the gates open to that 10 feet, however you need to do it. If you need to bring in a crane to do it, I've done that. It has to happen sometimes. And you lift them up, chain them, and you contract with a designer, get out there and fix it. And then at least you've taken one step in getting closer to getting your spillway capacity.
And what, if you assume that Four Lakes Task Force had a plan for repairing the gates in the spillway, but a multi-year plan, were there other steps that should have been done in the interim?
Depending on the incremental increase in spillway capacity or how much you could actually get by taking those intermediate actions, yeah, there's a bunch of them. Two that come to mind that are most prevalent is get operation equipment in there that can open these dams to the fullest, open these gates to the fullest extent possible. And then build a section of the dam that is designed to flow water, an auxiliary spillway. We used to call it emergency spillway, but that kind of fell out of favor, but that's really what it is. It's a part of the dam that's lowered, and in this case, it could be, I'm not saying that would be the preferred design, but it could just be a section of the embankment that's brought down lower so that when the water level came up, the water could flow over there, but then you have an extremely flat slope downstream of it that takes that water away. So normally in this part of the world, we would design that at a 10-to-1 or a 12-to-1 slope. So very gradual. And so that you don't get the high velocities that tear the dam apart.
Was there anything significant about the slope of this dam?
The embankments, in one of the geotechnical reports I read, do say that especially the section, the embankment, the downstream embankment slopes are steep.
And what's the significance of that?
It doesn't give you the ballast. It doesn't give you the weight. It doesn't increase the seepage. When I drew the phreatic surface, it doesn't give you a long seepage path to slow that flow of water down.
But is there something that you can do until the more permanent structural changes are made?
Absolutely.
And what is that?
Build a buttress on the downstream side. I referred to the mystery berm on one of our dams, but the rest of the embankments on this dam, most of the rest have a berm on them. This section hadn't been done for whatever reason, but the fact, and when you go out there and you see that the rest of the dam is burned and this one particular section isn't, would be alarming to an inspector to say, why not? What's different? Is this Is this portion of the embankment constructed in a better manner? Is it not necessary? And it would cause you to look at the report and say they just haven't gotten to it.
Would the placement of a berm in that section of the dam have made a difference in the outcome here?
I think from the water level that raised the reservoir to during the flood, yes. Can we say with 100% certainty that the water level wouldn't have gone higher and it overtopped and failed? I can't say that for certain, but certainly the highest risk was with this particular one was that downstream slope.
But it didn't overtop. Did
It didn't until the dam started to wash out.
Right. I mean, there was failure of the structure of the dam before it overtopped.
Correct.
So overtopping wasn't the initial mechanism.
That's correct.
Okay.
And I'm just saying that had that part of the dam held, the likelihood the dam would have held is greater, but I can't tell you that it would have been certain. I think a combination of having the additional storage in the reservoir from a lower water level, in addition to that berm, would be huge. But again, it would be to do that kind of work, to build that kind of berm, you have to draw the reservoir down or it's not safe. Because if you start using excavation equipment on the downstream slope and you inadvertently get too close to that phreatic surface, that seepage starts. It initiates. So this is a procedure you normally have to drain the water all the way out.
Was there an issue with the drainage tiles on this dam?
The original construction plans show an absence or that they missed some drain tiles in the vicinity where this dam failed. And the construction inspection reports show that indicate that the inspection was really lacking. Not uncommon in this time zone. I'm not pointing fingers, but that was generally the case. It was a construction technique that was really poor, but honestly, they didn't understand any better back then. That's why we're correcting those problems today. Is they brought the material in on carts and dumped it. And hopefully they compacted it, but they didn't have the sophistication we do now. They don't have nuclear density testing for the soils. They don't have the big sheep's foot rollers with vibrating these things to a percentage of their maximum. So there's all kinds of inconsistencies that are shown on the construction drawings and the pictures on that particular side of the dam.
But those factors, are those known to the dam regulator and should be considered by the dam regulator?
They do appear in numerous documents. And again, a huge benefit of taking over an ex-federally regulated dam is having this kind of documentation.
But how this dam was constructed and the absence of drains, were those flags to the regulator?
They should be. There were flags for the PFM, or the probable failure modes, and the probable failure modes analysis.
Okay, so it showed up in the 12D report. Is that what you're telling
Yes.
us? Okay. So that information was available. Okay, I want you to go to, let me see what we call this exhibit. This is in volume 2, exhibit 12. It's exhibit A, exhibit 12 to exhibit A, the report.
Yeah, let me catch up here and get the right volume.
Yeah, volume 2.
Volume 2. Where am I going?
You're going to exhibit 12.
A lot of pages to get there.
If you want to see what it looks like, if that'd help you, it's up on the screen.
I'm there.
What I've directed you to is a Spicer Group memo to Luke Trumbull of the Michigan Dam Safety Unit from Ted Champagne, a project engineer with the Spicer Group dated September 18, 2019, regarding Edenville Dam Gate Test. Did you review this document as part of your review of this matter?
Yes, I did.
Okay, and I want you to take a look at it and then tell us what particularly, I want to go to the conclusions after you've had a couple minutes to refamiliarize yourself with this document.
This document supports what I said earlier about the gates not being fully operable to the fullest extent, based on how they were connected. And this was one of the documents I used to support that they couldn't use the A-frame during an emergency event, that operating the gates prior to an event was the most responsible and the safest manner.
I want to take a look at the conclusion that's up on the screen, or you can read it from the document itself. And if you could read that into the record.
The current engineering opinion based on observation of the gate test is that the gates at Edenville should only be operated with the original hoist mechanisms until they can be replaced with electric hoists. Using the portable A-frames and the manual lever hoist is cumbersome and requires too much time to operate under emergency conditions. Most importantly, though, the A-frame requires that a minimum of 3 operators be at each site. Those operators would be exposed to unsafe conditions, which is unacceptable. At this point in time, based on documents reviewed, the Four Lakes Task Force does not believe that the Edenville Dam can be operated to meet the Eagle Dam safety requirements to pass the 1/2 PMF without certain repairs and improvements.
And what is the significance of that?
It affirms the fact that the dam is undersized and does not meet state requirements.
What action should be taken if a dam doesn't meet state requirements?
You have to increase the spillway capacity somehow.
And how do you do that?
Through getting these gates fully operable, changing the configuration of the spillway as it exists, adding a spillway, either an auxiliary or another permanent spillway structure. Auxiliary spillways are much easier and cheaper to build. And there seems to be plenty of room to do that. And so there are a number of ways to do it, and we could come up with a dozen of them.
But are there steps that can be taken that are more immediate
Yes.
to decrease okay.
Yeah.
Well, what steps could be taken to decrease the risk of
The
damage?
immediate would be draw the reservoir down until you could get any one of these repairs is going to require drawdown anyway. So bring it down, do a more thorough inspection so you can see every component, especially on the concrete structures, and start the process of getting design, at least for an auxiliary spillway. And then if the engineer certifies it, to bring it back up to normal pool, bring it back up to normal reservoir elevation, with a plan of we're doing this, this, and this within this time frame, and get the engineers right off that that's acceptable now because we can pass the inflow design flood, the required flood.
And at this point in time, does the state now have notice that in all likelihood, that dam cannot pass state statutory requirements?
Yes,
And when they have that type of notice, do they have a responsibility to act?
they do.
We have a responsibility not to act contrary to the safety of the dam.
Yes.
Okay, let's go to the next one, which is exhibit, it's in volume 4, exhibit C1. Okay. Okay, I read that wrong too. It's exhibit B1. I've written it, but it is in volume 4.
Okay, I'm there.
Okay. Uh, have you been able to find it, Your Honor?
Thank you. Yes.
Okay,
Mr. Gamble, have you got it?
Yes.
okay. This
And
again,
co-counsel.
oh, okay. This again is a substitute, a color copy substituting for one of the original 1 to 45 documents that didn't show up in color when we submitted the report to Mr. Gamble. But he did actually review the color report. Mr. Sturdivant did, but just so the record's clear on that. Okay. What is your understanding what this document is?
This is a dam safety inspection performed not as a federally regulated dam, but as a state regulated dam.
And it's prepared by the Spicer Group.
Yes,
Do you understand what their role was in this case?
excuse me?
Do you understand what Spicer Group's role was in this case?
Yes.
And what was it?
Consulting engineer for Four Lakes Task Force.
And did you review this document and preparing your opinions in this case?
I did.
Okay, I'd like to go to page 4 of this document, and I think we have some slides on it.
Hold on a sec, please.
Okay,
Hold on.
oh, we will.
Thank you.
I want you to look at conclusions and recommendations. Can you read what's on the screen?
Yes, I see that.
Can you read that out loud for us,
The
please?
visual inspection of the dam and its appurtenant structures indicate the dam is in fair to poor condition.
What's the significance of that?
What page?
That is page 4, 39, exhibit B1.
Thank you.
And let's go to the next part. Okay, let's, this talks about inadequate spillway capacity. Can you read this, this part of this report?
I'm going to back up and complete the whole sentence so
Okay.
it can't get taken out as
Right.
out of context. The
Okay.
FERC revoked its license because of the Edenville Dam's history of noncompliance with FERC regulations. Foremost being inadequate spillway capacity to meet FERC dam safety requirement or standards. Upon revocation under Michigan law, regulatory oversight of the Edenville Dam came under the jurisdiction of Eagles Dam Safety Division.
What's the significance of that to you?
There, an independent consultant is pointing out the same conclusions, that the dam is undersized. This is why one of the primary reasons for revoked the license to produce hydroelectricity and operate the dam for that purpose, and stating that now the oversight of the regulatory authority falls in the state of Michigan.
Let's go to the next one, which starts with the paragraph currently, yeah. Do you want to read that into the record and explain it?
Currently, there are deficiencies which need to be corrected. The dam does not provide adequate spillway capacity to pass 1/2 probable maximum flood PMF events sufficiently to meet the Eagle Dam safety requirements.
Interrupt for a moment.
This has been previously identified. Sorry, what?
I said, stop, please. I said, I'm going to interrupt for a moment. We didn't do this at the beginning of our journey today. There were 4 binders provided to the court for purposes of this hearing. I've been looking at them. We've been talking about them. There's been testimony about them. Sections of them have been read into the record. No one has moved for their admissibility, at least for purposes of this hearing. We probably should have done that from the get-go, and I apologize for not fulfilling my gatekeeper role in an appropriate way. Do you want to move for their admission for purposes of this?
Yes, Your
Hearing.
Honor.
Mr. Gamble or co-counsel, any objections for purposes of this hearing as to binders, Roman numbers 1, 2, 3, and 4, and all their contents therein?
Your Honor, I do want to clarify that we do have an objection to many of these items ultimately
Right.
for the
No-
purposes
no
of trial.
question.
And so I just want to put on the record very clearly that we are not objecting to using the binders from either the plaintiffs or the defendants, obviously, solely for the purposes of analyzing the opinions that the defendants have challenged.
Very well. The court, for my colleagues on the Court of Appeals, of the 21 remaining eligible judges who are not currently serving on the Court of Claims, who may have to review these decisions, and the very capable and outstanding 7 justices of our state Supreme Court. I apologize, I didn't catch this earlier. Bad on me. At any rate, I've reviewed to the extent we've been talking about them. I have not reviewed in their entirety, of course, the thousands of pages of documents, but I think that it's appropriate in the role of the court in its gatekeeping function on the motion of the defendants challenging the admissibility of the testimony of this proffered witness at trial, for me to be able to consider these for purposes of the matter that's before the court. The court recognizes that the defendants have preserved and are not preserved objections potentially to some or all. My guess is not all, but my guess is some of these should the matter proceed to trial. And we'll address those as we have the opportunity to continue to work on this case together, should the case continue. That's the court's ruling on the admissibility for purposes of this hearing. Any further ruling or clarification on that for the plaintiffs requested?
No, Your Honor.
Defense?
No, thank you, Your Honor.
Thank you all. And I, again, should have caught this at 8:28 and I did not, and that's my bad. So please continue, counsel.
Okay. Okay, do you want to go back to this? Currently, there are deficiencies.
Yeah. I'll start over on that if that's
Yeah,
okay.
Please.
Currently, there are deficiencies which need to be corrected. The dam does not provide adequate spillway capacity to pass the 1/2 probable maximum flood, parentheses PMF, event sufficiently to meet Eagle Dam safety requirements.
And what does that tell you?
That the dam doesn't meet state standards, that it's undersized.
Is that a time for immediate action?
Yes,
And would that have been lowering the water levels? I believe you testified to that.
To
What would that have been, the immediate action?
lower the reservoir levels.
And this report is dated June 20, but June 2020. But are you aware that this information was available to the state much earlier?
That information was, yes.
And did you review documents that told you that much earlier in time, the state was aware that it did not meet the 1/2 PMF?
Yes.
I'm sorry, what's the date of exhibit B1?
It is, let me find it again. Okay. It is, well, it says June 2019 to March 2020. I said June. Yeah,
It's the date that it was issued.
that's,
Anybody knows?
I know that,
It was after the dam failure, Your Honor. So it's June 2020.
but just for the record, we have contended there's evidence that shows us this information was largely available beforehand.
I, might be. I
Yeah.
want to know when the
Yeah.
report came
Yeah.
off the printer. And it sounds like it came off the printer after the dam failed. Is that, that's the people that, that's the defendant's position, right?
Yeah.
Well, that is correct, Your Honor.
Thank you. I'm suggesting that, perhaps all of this information talked about in February of 2024, when I started my service in this case. Earthen dams have been around since Mesopotamia, so much of this information has been around in different varieties, one way or another.
Mr. Sturdivant, looking at page 4 of this document, and I believe you read it into the record, does this reference that the information about the PMF event was previously identified before the publication of this report?
Yes.
Just 1 second, this is just housekeeping. I do anticipate that we'll probably take our recess at noon for 45 minutes to an hour. How long do you want for lunch? The choice is either 45 minutes or 60 minutes.
45 minutes is fine.
Is that gonna be enough for the people?
Yes, Your Honor.
So just so for planning purposes, if you need to call someplace or get your friends to bring your lunchbox, 12 o'clock is when we're going to take our recess for the lunch recess. So thanks. Sorry for the interruptions.
Oh, no, that's okay. I look back at my counsel who's kind of orchestrating that part of this.
I saw cell phones going around and I'm thinking, this past week, one of our kids just got possession of a new home to him. I'm just thinking like a parent and I'm visiting my grandchildren, thinking like a grandparent, well, we need to make sure we have lunch for everybody. Please go ahead.
Okay, let's look at page 5. You do want to take a look at that and read that into the record, please? Read that section. That's page 5 of 39 of Exhibit B1.
Yep. You want me to read that in?
Yes, please do.
All right. A more immediate study related to winter operations of the dam is being performed as well. Since the revocation of the FERC license, water cannot be passed through the powerhouse, which leads to all the water being passed over the concrete spillways to maintain the legal lake levels. As the dam exists now, this method leads to excess ice buildup on the dam during the winter months and creates unsafe working conditions for the dam operators.
Okay. Can you tell us what the significance of water not being passed to the powerhouse is to the operation of this dam?
Calculations were done that said that if the powerhouse could be used during a flood event, which is not normally the case, you could get another 2,000 cubic feet per second through the powerhouse, but it's very unlikely that someone who owns and operates a powerhouse is going to allow that to happen. For one, you can see even from the videos of the flood that the tailwater increases pretty dramatically. So the water downstream of the dam comes up and there's not enough head to drive the turbine to make money anyway. And it results in the turbine, the risk of the turbine running free. That the braking system, if the braking system fails and they can't stop the turbine from spinning, it can literally turn a powerhouse to dust from the vibration. So normally they shut them down anyway. So you can include that as part of the potential spillway capacity.
But in this case, FERC had shut down, had forced them to
If
shut
they
down.
revoke the license, they are not allowed to. Normally, the ones I've seen, and there's only been one real small one, that I witnessed what FERC required of the dam owner to abandon, and that was fill the turbine pit with concrete. So that there was absolutely no way. They could remove the equipment and sell it or salvage it, but they had to make the powerhouse completely inoperable.
But when the powerhouse was operable, did it allow a better flow of water?
Yes, under normal water conditions.
And so the fact that the powerhouse was no longer available, was that did that need to be a consideration in what the water levels needed to be?
Yes, because that really, the powerhouse has a really useful second purpose other than generating hydroelectricity, and that's maintaining normal water levels, because it's easier to control the flow of the water through the gates that direct the water into the turbine, or the wicket gates. And a lot of hydro users use their powerhouses to control the water so they can make money. That's the whole idea, is to push as much water through the turbine during efficient times as you can.
There's several photographs with this report. Are there any that would be helpful to you to illustrate any of the points that you're making here today? If you want to do a quick look through those. They start at page 18.
What I captured from all the different photographs when I first looked at this was the difference in the downstream slopes, and it's really tough on some of them because of the coloration and the angle of the sun to gather what slope protection is on there. But it is pretty obvious that that left embankment appeared steeper than what the right embankment was.
And which exhibit are you, and which page are you looking at for that?
Left embankment downstream slope pictures are on page 32.
Yeah, hold on.
Hold on, please.
You think you could get that quickly? Yeah.
And the right embankment downstream slope photograph is on page 37. Photograph number
Okay.
30.
Well, you want to, let's first look at the one on page 32. I want you to, can you use that pointer and point out to us what you're identifying?
This is a consistent downstream slope with no break, break in the slope, no additional berm. You can, and number 12, and you can get the relative slope of the embankment from the photograph. Obviously not an exact measurement. But then when you flip to page,
How many degrees? Is that about 30 degrees?
I would guess that's about 3 to 1. It's only a stab. And then on page 37,
Which photo-
photograph 30.
Okay, let us blow that up right here.
These are, I'm all before May 20th, May 19th, 2020, these photographs.
You mean what's the date of them?
I
They're
don't
all,
need the exact date, but
Oh.
the failure was May 19th.
Right.
So this is pre-failure.
yes, these were taken pre-failure.
We agree with that, Mr. Gamble.
Yes, it would look very different if it was post-failure.
Yeah,
Be my
Yeah.
expectation.
Yeah, that's an understatement, but yeah. Yes. So you can see on this one, there is it's much wider at the base. And the slope is less steep and there's a little bench or berm indicating that there's actually a berm constructed on the downstream portion of the embankment.
what's the
Number,
Number 30, Your Honor.
30 at page
37.
Yes, sir.
37 of B1. Okay, and what's the significance of this to you?
This berm appears to have been reinforced with another berm downstream, or what I alluded to earlier on was additional stability added by flattening the slopes and adding more material to the downstream side.
And what does it tell you?
That the embankment was indicated as unstable during an investigation, and I believe, I don't remember what year, but there was a geotechnical investigation where they did soil borings and determined that this was a required action for all the embankments. They just, for some reason, the left wasn't done.
And did you get that information from that 12D report that you looked at?
I can't tell you whether it was summarized in there. I think it was pulled into there as they noted that the left embankment did not have a berm on it.
Should the left embankment have had berm on it?
Yes, this was all constructed at the same time. And actually, there's numerous photographs in the construction log on that left side where it failed that show that the construction techniques were questionable at best by current standards. Again, I'm not taking away from the people who built it originally. They did what they were told to do.
Should that have been a flag, the absence of the berm to the state regulators?
It certainly would have been a question for someone doing a physical inspection of the dam is, why is it burned here and not here? At least find the answer.
I want to go to Exhibit A, Volume 2, Exhibit A19. So it's Exhibit 19 to Exhibit A of Volume 2. We don't have anything highlighted yet, but if you found that, if you take a chance, take a minute to look at it.
And I have asked, Mr. Kramer to check with the building managers, so you can get a little more air conditioning going in this particular room. It seems a little warm to me, and I don't know if it's because of the I'm guessing it might be more appropriate. My office, I keep it subarctic so I can see. Haven't heard any circulation there. Hopefully we got some. Oh, okay. Any particular time I expect? Well. Hearing chirping. That's good. Thank you, Dan. Appreciate it.
Okay.
Maybe one for that.
Did you review this document as part of your review in this case?
Yes.
Okay. And what do you understand this document to be?
Kind of a summary and questions and answers based on why what happened. It's kind of a foundation.
And does this come from come from Lizel Clark, the director of Eagle? Does that appear to come from there?
That's who signed it, yes.
And it's dated June 15, 2020, and it's addressed to Congress, to United States House of Representatives Committee on Energy and Commerce, correct?
Yes.
And she's answering various questions here. And does this go through the history of suing for the mussels at page 7?
It does.
And does this also go through the denial of the permit to lower the water in November 2019? If you look at page 6.
Yes.
Can you look at page 5, number 6? Can you pull up? You got that? Thanks.
Okay.
Do they acknowledge in that, does the director acknowledge in that by early 2020, the dam safety program suspected that the dam did not have adequate spillway capacity to convey the design flood 1/2 PMF event per 315 requirements?
Yes. I see that.
And can you read the part starting after that with this deficiency? Can you read that into the record, please?
Where do you want me to start?
Right after what I just asked you about, but this deficiency, yeah, yeah.
Oh, the deficiency would have warranted a poor overall condition assessment of the dam. Fair. No, not from all indications, no. It should have been poor. Then you can skip whatever design flood you want if it can't meet the state regulations, especially when it comes to spillway capacity. Anything above a pour is not correct. Yes.
If you look at the question there, they're being questioned. Can you read the question?
Starting with according to press reports. According to press reports, a January 31st, 2020 communication from an engineer employed by your department to consultants indicated that the dam did not meet safety standards. What additional assessment or action undertaken by Michigan during the period between October 2018, when the dam was found to be in fair condition, and January 2020 led to the conclusion that the dam did not meet safety standards?
Okay. I think I'm looking at by early. Okay. When they did not need one half. Does he tell us that people believe that it's still overall condition?
Yes.
The way you part of the flood.
That's my understanding. Yes.
Yeah. If you assume that it's a state's position that relative to water levels, that Boyce and Four Lakes Task Force always intended after the winter drawdown, the proposed winter drawdown, to always raise the water back. The fact they intended to raise the water level back, does that change the regulator's duty in any way?
If they did not raise it back up?
No.
I
Does
guess I
it-
don't understand your
If,
question.
okay. It is the state's position that the denial of the permit in November 2019 was irrelevant, basically, because Boyce always intended to raise the water back in the spring anyways. Does that make any difference to the regulator's responsibilities?
I don't know how to answer that yes or no, but by not having that water level lower like we talked about for spring runoff and snow melt greatly increases the instability in the dam and the
What's the-
likelihood it will fail.
Does the owner's intention affect what the regulator intends to do, is required to do?
I'm not sure how to answer that, so sorry. It's
I mean, whose decision is it when you're talking about dam safety?
it's the regulators.
And
It's-
so is
and
that
it's
ultimate decision their decision?
Yes,
So whatever Boyce was thinking, did that matter to the fact that this dam needed to be raised or lowered at a particular time?
now I get it.
Okay,
Yeah.
I'm sorry I wasn't
No.
clear. I know, it's dancing
No, they
around that.
it should have been drawn down anyway at this point. It shouldn't even have been a question whether Boyce wanted to bring it down for whatever reason they want to control ice, to work on a mediation for ice, or to do whatever they wanted to do for repairs on the dam. That in itself was another indicator that if the owner wants to draw the water level down to do work, that it should happen, that they understand that it is critical enough to get the work done now.
I want to put, let's see, Exhibit C, Volume 3, Exhibit C 118.
Volume what?
118. You know, that starts getting into another area where there's going to be a few exhibits.
Gonna take
Yeah, I think it
right
would,
now,
yeah, I think it would be good. I'm sorry, I can't hear you.
being overruled by one of your colleagues.
No, I want to continue. Actually, Your Honor, there's been a staff with who we requested lunch from. And so I know we had said 45 minutes, if we could extend it to an hour.
No, Your Honor.
It's fine. Let's reconvene at 1:00.
Thank you.
It's 5 minutes before the hour. Is there anything that the plaintiffs would like to memorialize or place on the record before we take a recess for lunch today?
I believe that, I just would like the record reflect that Mr. Trumbull is in the courtroom today.
Okay,
He's a member of.
any
the-
objection?
Yeah, but we have no objection to it.
Mr. Campbell, any objection to that?
No, he is indeed.
Okay, he is here. We can all stipulate to the physical presence, of Mr. Trumbull. Thank you. Mr. Campbell, anything for the defense before we recess?
No, Your Honor.
Okay, thanks.
Thank you, Your Honor.
I'm gonna be probably in chambers if if something comes up in the next 65 minutes. Well, let's call it 55 minutes. You need to talk to me beforehand. Get a hold of Dan or somebody and you can take the secret passageway down to the chambers. It's it's apparently not generally accessible to the public. So, yeah, and just warn me if they're coming, Dan, so I can, lower my voice. So,
I do have one question. Is there a room?
Yes,
out
ma'am.
here that we could
pardon
use?
me?
Is there a room that staff could use?
Yes, there is a room immediately at the back of the courtroom. There's a room with some conference tables that is, anybody using that today?
There's something going on. We talking about the UTM.
No, I'm talking about our room right
Oh,
here.
yeah.
Yeah, so there's a council conference room just in the back of the courtroom. And feel free to have your lunch there. Please don't, open a gaming casino or something while you're there, but anything that's okay. All right, we're in recess until 1:00. Thank you. Are we? I don't know, Ron. I just said to my assistant on the way up,
We have an espresso machine set up here in the future.
I'm very, yeah, do whatever is needed for the good of the order for all concerned.
Well, when you had the coffee brought in, I'm smelling it going, that smells beautiful right now.
You got 87 lawyers. I mean, All right. Pardon me?
Yes, start here.
Oh, yeah. All right, time is 1 o'clock in the afternoon. The day continues to be September the 16th, 2025. We have our very capable lawyers who were present previously. There's a couple more lawyers on plaintiff's side who are here. I don't know if they want to identify themselves. Nope, they're talking to each other instead of the court, so we're going to move on. All right,
Thanks.
please be seated, counsel. That's 1 o'clock. You may continue with your exam.
Okay. Where we are. Okay, 118. Let me get to there.
And I have no objection to any lawyer having coffee at council table. I know some trial judges, I've been a coffee drinker my whole life, and certainly it was any chance of not being one was removed during any number of mid-watches at sea in the US Navy. So we have what's called mid-watch coffee. It's very strong. And I wasn't at sea that much, but when I was, I would drink it. So
I'm not sure I properly identified this for the record. It is Exhibit C,
oh, I'm sorry.
118 in Volume
Mr.
3.
Sturman, you're still under oath, as I said previously. So, okay. Which one are we at, please?
We are at, in Volume 3, Exhibit C, 118.
I need.
What tab number?
118. It's way in the back. Oh,
Defense ready? All right, so am I.
okay. Have you found it yet?
Yes.
Okay. Can you take a look at that document? Ready to talk about it? You need another minute?
Okay.
Okay. What do you understand this document to be?
A request from Boyce Hydro at the owner at the time to the state asking for assistance.
And what's the date of that document?
October 3rd, 2018.
Okay. I want you to look at the screen, and can you look at the screen and the yellow highlighted? Can you read that? Okay. Can you read that into the record?
The yellow part?
Yes.
Okay. The matters that I wish to bring to your attention and for which I regard it to be appropriate for you to respond today and tomorrow are technical issues that pertain to the subject matter of the title of the division of the, I'm assuming that's Michigan Department of Environmental Quality,
Yes.
wherein you are employed, i.e. it is called dam safety.
Okay. And looking at the first paragraph. Can you read the second sentence into the record?
I have undertaken the prudent course of action to request your participation in discussions about the structural safety issues attendant to the operation and maintenance and future construction alterations of the Edenville Dam, now that it falls under the regulatory jurisdiction of the MDEQ Dam Safety Unit.
And what is the significance of these sections that you've read here? To you?
It's the owner requesting assistance from the state.
And does that put the state on notice that there's concern with the dam?
That's sort of going to be my job, I think, at the end of the day. So instead of asking what it means, that, because I think I get to decide that, I'm pretty sure.
Yeah.
But if there's authority to the contrary, I'd be happy to hear the argument, but I'm not sure if that's an appropriate subject for opinion. What do you think?
I will obviously defer to the court.
No objection, Your Honor.
Let's see. I want to go to, let me tell you what this is. Volume 4, Exhibit B6.
It's number 6 on the tab.
Right at the end of 4.
Thank you.
It's like voice 6.
Oh. Here, I thought you were ahead
No,
of it.
Can you find out that's the statutes?
What's that?
That's the statutes. Can you find that?
Yeah, it's right at the end, isn't it?
Yeah,
Yeah.
it's B6. B6, volume 4.
It's MCL 324.31506.
That's the start of it, yes. Okay. Have you found the documents in the binder?
Yes.
Okay, but can you look just briefly through, there's 5 pages there, just so you can see what's there. I'm going to be shown on the screen. Okay. In preparing your review of this matter, did you review these statutes?
I did at the onset to see what the state's ability to regulate the dam were.
And reviewing these statutes, is that something that an engineer ordinarily would do in carrying out their duties in dam safety?
Yes.
And is it important for an engineer to know what these statutes provide?
Can you rephrase?
Is it important as an engineer to know what these statutes, what they
Yes.
require? And what is your understanding of the enforcement authority that was available to the state of Michigan in this case?
It's similar to what I've seen in other states is reduce the hazard is the primary focus or the primary reason behind the enforcement abilities, and that's to either lower the water level behind the dam or to breach the structure altogether.
Why don't we start out with 324-31506, jurisdiction of dams? What information did you learn from reading this statute?
That the dam falls under the state's jurisdiction.
Okay. Then let's look at 324-31516.
315, sorry.
I think I read that wrong.
16?
Yes.
Thank you.
This sets the spillway capacity requirements for the dams falling under certain hazard classifications.
And which hazard classification did this dam fall under?
High hazard classification.
And what information do you glean from this did you obtain from this for the purposes of your opinion?
That the dam was required by state statute to pass 1/2 PMF.
Let's look at 324-31518.
Can you hold on for just a second, please?
Certainly.
Thank you. Thank you.
Okay, what do you understand? Did you understand about 3243158 that was important to your opinion?
That based on an inspection report either from the owner on the required schedule or the state can assert jurisdiction.
And asserting jurisdiction means what in this context to you?
They can decide whether or not to leave the reservoir up at full pool or lower the reservoir or to breach the dam itself. Physically remove a section of it so it can't hold water.
Are you describing enforcement actions that they can take?
Yes.
And are those enforcement actions to be taken if there's a dam safety issue?
Yes.
Should those enforcement actions have been taken in this case?
No. Were there actions taken or
No,
should
should
have
they
been?
have?
Yes, they should have been.
Let's look at 324311519. Okay. Is that another enforcement provision?
Yes.
Let's look at 324311521. Did you review this part of the statute for purposes of your opinion?
Yes.
Does the state have emergency powers when dam safety is at issue?
Yes, how the state, that's how I would interpret this.
And have you ever exercised that similar type of authority, whether it's under Wisconsin or Colorado law?
Yes.
And in those circumstances, the state orders the dam owner to do something?
Yes.
And in this situation of this particular dam, should the state have exercised those powers?
Can you repeat that, please?
In this situation with the Edenville Dam, should the state have exercised those powers that it had?
Yes, in my opinion, yes.
You know, I want to go back to one exhibit that we had right now, just quickly. That we had looked at earlier. I want to look at Exhibit A, Volume 2, Exhibit 19 to Exhibit A. Go to page 4 of that document.
Excuse me? What tab are we on?
19. Yeah. Okay. We already looked at this document.
So, gotta catch up.
Oh, yes.
I'm sorry. What are we looking at again?
We're looking at Exhibit 19 of,
Thank you.
okay.
And I do again appreciate the physical exhibits. I know it's a enormous headache for litigators, but it's very helpful for the court.
I'm a paper person.
Thank you.
Okay, I want you to look at this last paragraph where it starts with the state of Michigan on page 4.
Excuse me. Excuse me.
Okay.
Does this document tell you when the state of Michigan knew or was informed by Spicer that the dam did not likely have adequate capacity to convey 1/2 PMF?
Yes.
And what does it tell you?
It tells me that there was more information needed to verify that, but they believe that the dam did not have adequate spillway capacity.
And that was known well before the 2020 report that we looked at earlier. Is that
That's
correct?
correct.
Okay. Right. I do want to go back to that 2020 report that we looked at. Let's find that. Okay, this would be volume 4, exhibit B1.
Say exhibit 1.
Exhibit B1 in volume 4.
Okay.
Okay. I want to go to page 4.
All right.
Which volume?
That is, lost it again. That is slide. That is volume 4.
We have a moment.
N-
I'm sorry, this on what exhibit number 4?
It's exhibit B,
501.
B1, yes.
Right.
It's that Spicer report. Okay. You have it, Mr. Sturdivant?
Yeah.
Okay,
Page, please.
we're going to be looking at page 4 here. Mr. Sturdivant, the document that we've pulled up again, is that the Spicer 2020 report?
Yes, it is.
Okay. And at page 4, do they have identification of what various ratings for the dam, such as satisfactory, poor, fair, poor, et cetera? Does that include that information?
It does.
Are those ratings as they've defined them accepted in the industry?
Yes, yes. We had, actually, as a state engineer, the state has to report these condition assessments to the National Inventory of Dams maintained by the Army Corps of Engineers.
And in this case, how do they define poor?
Or did you want me to read it?
Yes, please.
Poor is defined as dam safety deficiency is recognized for loading conditions which may realistically occur. Remedial action is necessary. Or may also be used when uncertainties exist as to critical analysis parameters which identify a potential dam safety deficiency. Further investigation and studies are necessary.
And what does fair, how is fair defined?
Fair is defined as no existing dam safety deficiencies are recognized for normal loading conditions. Rare or extreme hydrologic and or seismic events may result in dam safety deficiency. Risk may be in the range to take further action.
I believe we may have discussed this, but in October 2018, the Michigan Dam Safety Official rated the dam as fair. Was it fair at that point in time?
No,
And why wasn't it actually fair?
the primary condition that would push it to poor is that it was foreseen that the loading conditions that the dam underwent were not unforeseen. When the dam is maintained at full pool and you can't operate your gates and the dam doesn't have sufficient spillway capacity, it's foreseen that there's going to be an issue if that water level rises.
Would it also have been if they needed to calculate the PMF, would that have been a parameter that they needed to further evaluate mandating poor under those circumstances?
I think certainly there would have been other studies identified that had to be ordered. Additional spillway analyses, additional stability analyses of the embankment in particular.
In the Part 307 proceedings, what is your understanding what the state's role was in that?
When you say the state, are you referring to the state's dam safety?
Yes, I am.
They would have a role in if they saw an issue with the structure or holding the dam at a higher water elevation. They have the opportunity to chime in and give their opinion on whether or not the dam would remain safe at those high levels. And the dam met statutory requirements that exist.
Did they tell based on your review of the records, was the court informed that this dam had safety concerns?
My review of the record did not show any of that.
Okay. And did they allow the dam to operate when they knew the PMF did not? Did they, the state? My ambiguous pronouns, very bad. Did the state allow the dam to operate when they knew that the PMF did not meet state standards?
Yes.
When they sued to keep the water levels high to protect the mussels, did that mislead the public about the safety of the water levels? In your opinion?
In my opinion, absolutely. Again, in my opinion, the environmental concerns were held over public safety concerns.
When a dam is evaluated as fair, when it is not in fair condition, is that misleading in your opinion as a dam safety regulator?
Yes, it is.
Second here. If I may.
Please. Yeah, if you want to just, I'll just caucus over your tables. we've been at it for a bit, so. you- Mr. Campbell, are you gonna want to take a recess or you be ready to go in?
No, we'll be ready to go. Thanks, Your Honor.
If that changes, let me know.
Just a few more questions. Okay, in reviewing section 318 of the state statutes that suggested that there was a report. Do you recollect that, or do you want me to pull up the state statute again so you can look at it?
Could you pull it up?
Yeah, can you do that, Craig?
Is that the ones we just looked at?
Yes,
Oh. Was that?
I can read.
I am two at the very end, I think.
Yeah, it's it. Oh, let me find that again myself. Oops.
Last of the skinny binder. I
Yeah.
think.
It's up.
It's up.
Oh, thank you.
Can you see that? Okay. Okay, the 2015-12D report that you testified about earlier, did that identify deficiencies that could lead to the failure of the dam?
Yes,
And would that report have been consistent with the type of inspection report, as you understand it, under 318?
oh, absolutely. Those Part 12D reports are very detailed, very inclusive.
Is it fair to say that as of the state's receipt of the report in October 2018, the state had the requisite report that would trigger the enforcement authority provided under October of 2018, as you understand this as a regulator?
Yes.
I have no further questions at this point.
Thank you. Phone Road, Servant, ready to go for further questions from other council?
Clear out.
Ready?
Yes, yes,
Okay.
yes, John.
Right. Stay at the table, Ms. Campbell.
Yes, if that's okay, Your
Okay
Honor.
with me.
Thank you.
Servant,
That's why they gave me a swivel chair.
Good afternoon, Mr. Sturdivant. My name is Nathan Gamble, and we've spoken before during your deposition. What Ms. Almonroe just went through was a direct examination. She would ask open-ended questions, and you would have an opportunity to explain in detail your answers. My examination will be different. It'll be a cross-examination. And so in order for this to move as smoothly as possible, if you could just please listen closely to my question, just answer my question. Most of them will be yes or no questions. If I'm assuming the other side will have an opportunity to redirect if you have further explanation. But in order for this to go smoothly, if you could just listen closely to my question, just answer the question. Do you understand, Mr. Sturdivant?
I will do my best.
Great, thank you. Mr. Sturdivant, you don't consider yourself an expert in Part 301 of the Natural Resources and Environmental Protection Act of Michigan, do you?
I do not.
And you don't consider yourself an expert in Part 307 of Michigan's Natural Resources and Environmental Protection Act,
I
don't
do
you?
not.
And the same question as to Part 315 of Michigan's Natural Resources and Environmental Protection Act. You're not an expert in that section, are you?
I understand it. I'm not an expert.
Have you ever regulated a dam in Michigan?
No,
Have you ever served as a dam safety engineer in Michigan?
no.
Have you ever,
Assisted your past dam safety engineer on projects in the Upper Peninsula?
have you ever participated in a Part 307 inland lake level process in Michigan ever?
Not in Michigan, no.
What is the difference when it comes to dam safety between the Michigan Department of Environment, Great Lakes and Energy and the Michigan Department of Natural Resources. Do you have an understanding of the difference?
My understanding is Eagle is dam safety
Mm.
and the DNR is the natural resources branch of that.
As far as you know, the DNR doesn't have any dam safety authority. Is that
That's
right?
my understanding.
The motion that brought us here today was a motion filed by the defendants that challenges 5 specific opinions that you have raised. So are you familiar with that motion?
I am.
Did the council who you work for, did they provide you a copy of that motion?
They did.
Okay, and so you've seen the 5 opinions that were challenging, is that right?
Yes.
Okay, so my examination will go through each of these 5 opinions and ask you questions about them. So let's start with opinion number 1, which is your opinion that both the Michigan Department of Natural Resources and the Michigan Department of Environment, Great Lakes and Energy had operational control of the Edenville Dam. Is that your opinion?
Yes.
Did you know that the Edenville Dam was private property surrounded by a fence?
Yes.
Have you ever visited the Edenville Dam?
I have not.
Did you ever speak to a person named Greg Ohl?
I did not.
How about a person named Ron Heilig?
The name is not familiar.
Have you spoken to Lee Mueller?
That name is familiar, but I don't recall the conversation.
Did you interview or speak with anyone who worked for Boise Hydro to determine who they believed that they reported to?
No.
Did you review the transcript of deposition testimony provided by anyone from Boise Hydro as part of your preparation in this case?
Excuse me. Transcripts or depositions from this case or from other cases, or do you want to be more specific or just you do it global first and then?
Global first, yes. Thank you, Your Honor.
I
So
reviewed so many documents, I can't tell you who's in particular without seeing those documents.
do you recall reviewing any deposition transcripts as part of your work in this case?
Yes, I did Luke's, I believe.
Any others that you can recall?
Not offhand, no.
Did you speak to anyone within the state of Michigan, either the Department of Natural Resources or the Department of Environment, Great Lakes and Energy, to ask them about whether they had operational control of the Edenville Dam?
No.
Let's look at Exhibit 4, Amy. Defendants Exhibit 4, and we'll bring up paragraph 12. And is everyone with me? Okay. Mr. Sturdivant, have you reviewed this affidavit before?
I did briefly go through this, yes.
Do you know who Brian Rudolph is?
I don't know him personally, no.
Okay. You didn't ever speak to Mr. Rudolph though, right?
did not.
Okay. So paragraph 12, could you please read this sworn statement from Mr. Rudolph into the record, please?
Paragraph 12, the statement is the Edenville Dam was private property that was surrounded by a gated fence. Neither I nor any of the staff I worked with at Eagle's district office had any ability to control or operate the private Edenville Dam at any time.
Did you review evidence that led you to believe that Mr. Rudolph was not being truthful in this statement?
In the context that he gave the statement, no.
Have you ever reviewed or seen a notice from the Department of Environment, Great Lakes and Energy informing private dam owners that their dams were under the operational control of the Department of Environment, Great Lakes and Energy?
Not in that context, I wouldn't expect it either.
Are there any dams in Michigan under the jurisdiction of the Department of Environment, Great Lakes and Energy that are not under the operational control of the Department of Environment, Great Lakes and Energy?
They
Based,
are not.
yes.
In my opinion, the statute gives them control over the dam, whether they are the person turning the gate control or requiring that gate control be operated, they have control.
So it's your opinion that any dam that falls under the jurisdiction of the Department of Environment, Great Lakes and Energy is subject to operational control by the state agency. Is that your opinion?
In the event that it doesn't meet the statutory requirements or any of the things that the state is going to regulate on, specifically spillway capacity, they have, in effect, operational control by having the ability to order that reservoir lowered.
So do they have operational control if they haven't issued the order you just referenced?
Yes, statutorily, they do.
So
I'm having trouble hearing Mr.
oh, really?
I hear you and then you drop off, so I can't touch the tail end of your question.
I can hear you, Mr. Gamble, but.
I'm pretty close.
The cancellation between you and.
Okay. So, Mr. Sturdivant, it's your opinion that, and I'll just say Eagle for short, for the Department of Environment, Great Lakes and Energy. Do you understand
Yes,
who I'm referring to? Okay. It's your opinion that Eagle has operational control of any dam in Michigan that doesn't satisfy state safety standards. Is that what your opinion is?
if they choose to take that action, yes.
If they don't choose to take that action, do they still have operational control of that dam?
In the context of being able to enforce a statutory deficiency, yes.
So they could take operational control, but is that what you're trying to say?
Yes.
Okay. What about dams that don't, or excuse me, what about dams in Michigan that do satisfy state safety standards? Does Eagle have operational control of those dams?
They're under the same statutory requirements. It doesn't, in my professional opinion, it wouldn't be necessary if they meet the letter of the law and the requirements of the statute and meet dam safety best practices, then there'd be no reason for the state to assert that jurisdiction.
So I'm going to ask the question just one more time because I'm not sure if you answered it, so I don't mean to be rude, but so is it your opinion that as long as a dam in Michigan satisfies state safety standards, Eagle does not have operational control of that dam?
To me, that's kind of misleading in its context because if the dam meets standards, they wouldn't assert it. Is that assertion still available to them? It is.
So by operational control, really, and I'm trying to get this straight, by operational control, you really just mean that the Eagle has the statutory authority to assert operational control if they want to.
Yes, and I would.
Well,
they could certainly get a warrant, get on the property and force the operation of the dam.
And in your experience in Wisconsin, you had said, and I think you said, quote, everyone has a right to contest what we do, unquote. Do you remember saying that earlier today?
Yep. Yes.
So that means in Wisconsin, let's say you gave someone an order as a state dam safety official. The fact that you gave them that order doesn't mean they would automatically do what you ordered them to. They could still contest it, right?
No, it does not mean that. They were required to take the action and then they contest following that action. We had the authority to issue a verbal order on site to operate the dam to whatever level we felt that needed to be operated at, if it was in trouble, if it was failing, if the dam was filling at a rate that was unsafe, whatever the reason, we had the authority to issue the verbal order with the intent of following up with a written order, and that written order could be contested because it includes a course of action that they must abide by.
So did you know that in Michigan that there's two different types of orders that can issue under Part 315?
I did see that.
I'm now going to move to the second opinion that we've challenged, which is your opinion that the Department of Natural Resources and the Department of Environment, Great Lakes and Energy forced Boyce Hydro to return Wixom Lake to its normal level in the spring of 2020. Is that still your opinion?
Yes.
And I'm going to use the word normal level and winter level to draw a distinction between the normal operating level during every other time of the year and then the winter level, which is just during winter time. Do you understand the distinction I'm making?
100%.
Okay, I thought you would. So did you talk to anyone at Boyce Hydro? Well, excuse me, let me just rephrase that so I don't ask the same question. You testified previously that you never spoke to anyone at Boyce Hydro about who they reported to within the organization. Is that correct?
Yes.
It's fair to say, or it's accurate that you've never talked to anyone from Boyce Hydro, right?
Correct.
Okay, so you didn't talk to anyone from Boyce Hydro about whether they thought a state agency forced them to return Wixom Lake to the normal level in spring 2020, right?
Correct.
Did you talk to anyone at the Four Lakes Task Force to determine if they thought that a state agency had forced them to return Wixom Lake to its normal level in the spring of 2020?
No.
How about the Spicer Group? Have you ever spoken with anyone at the Spicer Group?
No.
And I asked previously about state agency employees in the context of whether they had operational control of the dam, but for the purposes of your review, have you ever, or excuse me, for the purposes of preparing your report, have you ever spoken to any employee of the Michigan Department of Natural Resources?
About Edenville Dam?
Yes.
No.
And the same question, have you ever spoke to any employee of the Department of Environment, Great Lakes and Energy about the Edenville Dam?
No.
Let's go to Exhibit 5. Defendants Exhibit 5. Do you recognize this email chain, Mr. Sturdivant? You take some more time if you need to. Sorry.
I do remember it.
Okay. And these email chains, they're awkward because they start at the bottom and then they go to the top. So let's start at the bottom. And Amy, could you highlight the date that this email was sent and who? So capture enough to see. There we go. Thank you. And you know that Lee Bowler is the owner or the person who operated Boyce Hydro. That are you aware of
my
that?
understanding.
Okay. Do you know who Dave Kepler is?
Not offhand, no.
Is it, if I explained to you that he was the chairperson of the Four Lakes Task Force, would that refresh your recollection at
Yes,
all?
it does. Thank
Okay.
you.
What's the significance of September? Well, instead, isn't September 25th, 2018, isn't that the day that the FERC's revocation order revoking Boyce Hydro's license went into effect?
Without seeing it, I'm not gonna, I don't know for sure what the date is. There's so many documents and dates. And I have to actually see it.
Okay. So if you look at this email, if you could please read the highlighted portion for us. This is from Lee Mueller to, oh, you can't tell, just, sorry. From Lee Mueller to Dave Kepler with the Four Lakes Task Force.
To whom? Dave?
Dave, excuse me. Oh, to her point. Dave Kepler with the Four Lakes Task Force.
This is to him from Boyce Hydro,
Yes.
correct?
Could you read it out loud for us?
Today, the DC Circuit Court denied our motion for an emergency appeal of the FERC Edenville license termination order. Boyce will therefore cease Edenville operation at 11 p.m. tonight and file constructive notice of this action with FERC. The circumstances now engenders a necessary change in operation and a flow regime for the Edenville Dam, spillways, and the reservoir. Effective next Monday, Boyce will be laying off approximately 50% of its staff as a result of the loss of the Edenville Dam electrical generation revenue. When you have time, I would like to discuss potential options for obtaining financial assistance that would be required in order to retain the minimal operational staff needed to support water levels in the Edenville Dam reservoir, if such an option is even available.
Mr. Mueller, in that last sentence, he's asking for financial assistance to support normal water levels, right?
Yes, I
Do you-
read that as normal operation of the dam.
Do you see any indication in that email that he is worried about the safety of that course of action?
Yes,
And is it that he wants to have enough staff on hand? Is that right?
no, not completely. I'd read into if such an option is even available. He understood his dam wasn't in good shape and he understood it didn't meet regulations. So in my mind, he's questioning whether it's even an option for him to hold normal pool at this point in time.
Okay, all right, well, why don't we continue reading this email? And so, so like I said, it goes from bottom to top. And so let's go to Dave Kepler's response.
Sorry to hear. I can call you tomorrow around 1 or 1:30.
Oh, Mr. Sturdivant, we don't need you to read.
Oh, I'm
the whole
sorry.
No,
Sorry,
that's,
I thought you asked me to do that. I
no, that's
apologize.
okay. That's
She's always
okay.
asking me to read stuff.
But you see, it's from Dave Kepler that same day to Lee Mueller. Do you see that?
Yes, sir.
Okay, and so we've highlighted, if you look up at the screen, just two of those lines.
Yeah.
If you could read those, please.
On water level, want to discuss both what is needed through winter and how we bring it up in the spring, ? We should have a plan by then. Has DEQ or DNR engaged ?
Great, thanks. And why don't we go up to Mr. Mueller's response? Also that same day. Yeah, that's just fine, Amy. Thanks. Yeah, go ahead and take your time and kind of look through that for a minute.
Excuse me.
So at the first highlighted paragraph that you can see on the screen there, what is the concern that Mr. Mueller raises regarding income? Do you see that?
Yes,
And he's saying unless we have the income necessary to maintain the reservoir lowered approximately 8 feet below normal pond level, which will probably be achieved in the next 30 days. Do you see that?
yes,
And in answer to Mr. Kepler's question about whether DEQ or DNR had engaged, what's his answer? Do you see that second highlighted paragraph?
yes.
What, could you read that for us?
There's been no interaction with either MDEQ or MDNR as of today.
So you didn't see any evidence in the documents you reviewed indicating that DEQ or DNR had forced Mr. Mueller and Mr. Kepler to have this email exchange, did you?
No,
In fact, the email itself says that DEQ and DNR have not engaged on this topic. Do you see that?
Yes, I do see that.
And this email doesn't say anything about mussels, does it?
No, not yet. No.
Let's go to defendant's exhibit 7. And it's a letter with an attachment. And so the letter, the main letter is the first 2 pages. And it's titled a letter of understanding regarding acquisition of lake level assets. Have you seen this document before, Mr. Sturdivant?
I did.
And it's addressed. Why don't you turn the page so you can see who it's from? You see that it's from Mr. Kepler,
Yes.
and then it's addressed to Mr. Mueller, right?
Yes.
You don't see anyone from Eagle or DNR on this letter, do you?
I do not.
So Amy, if you could bring up that highlighted paragraph. Could you read that for us, the one that's highlighted, Mr. Sturdivant?
As we negotiate the final terms and conditions of the definitive purchase agreement, we agree to transitional payments to be applied to the purchase price, and that as a consequence of this consideration, Boyce Hydro would promptly begin the process to bring up the lake level for Wixom Lake, the details of which are also set forth in attachment 2.
Great, thank you. So as far as you can tell in this letter, is there any sign that Eagle or DNR forced Mr. Kepler to write this letter to Mr. Mueller?
No, not as of the state. No.
And so let's turn to attachment 2, which is referred to in that paragraph. Yep, it's just that page. This time it's a letter. This time it's a letter addressed from Lee Mueller to David Kepler. Do you see that?
Yes.
And do you remember reviewing this letter as part of your work on this project?
Very briefly, yes.
Do you see anyone from Eagle or DNR on this letter?
I do not.
So Amy, if you could highlight those first 2 paragraphs. Yep, just like that. Thank you. Could you just read the first full paragraph, starting with Dave, please, into the record?
The following enumerates the costs associated with Boyce Hydro LLC's operations and related activities to be undertaken as soon as possible for the purpose of restoring the, in quotes, normal PERC licensed pond levels and operating regime for the Wixom Reservoir, parentheses, lake. This operational regime will be in effect until there is a closing, estimated to be January 2020, for the sale of the Edenville Dam and bottomlands to SLPA, FLTF, or Lakes Task Force.
So according to the paragraph you just read, what is the operational regime that will be in effect until the closing of the sale?
I believe FERC's regulations called for a summer level and then a winter level that was about 3 feet lower.
And so the operational regime would be that Boyce Hydro would continue to maintain those levels. Is that your understanding?
That's my understanding.
And if you look at the next paragraph, what was the consideration that Boyce Hydro received in order to maintain those normal lake levels?
They would be paid for the operation.
You didn't see any evidence that Eagle or DNR forced Boyce Hydro to enter this agreement with the task force, did you?
No.
I'm familiar with FLTF. What's SLPA?
The Sanford Lake Preservation Association is the predecessor to the Four Lakes Task Force. And you can take some more time to look at this letter if you like, but there's nothing in this letter saying that Boise Hydro is entering this agreement with the Four Lakes Task Force because of mussels, right?
No.
All right, let's go to Exhibit 8, Defendant's Exhibit 8. And I'll give you a second with this. Mr. Sturdivant, do you recognize this email?
Vaguely, yes. There were a lot of emails.
Yeah, I understand. Amy, if you could highlight,
Excuse me. Oh, you've articulated several exhibit numbers. These are exhibits attached to what, please?
these are exhibits that are in the book, the white book.
Which way? I don't think I have it.
Oh, we gave 4 copies of our binder this whole time, Your Honor. I apologize. I didn't know you didn't have a white.
Is that something by?
We have another one right here on hand. Yeah.
My powers of cognitive recognition do not. Thank you.
And it's just one binder. So those are 2 copies of the same set of exhibits.
Dan, would you like a copy?
I apologize, Your Honor. We were going quite a while there.
Not have anything to apologize for.
Okay.
If I had more moral courage, I would have asked sooner. And frankly, your team has been enlarging them on the screen that's right in front of me, so I have been able to follow along. But when I started to walk around, it was a little harder.
Got it.
Okay.
So Defendant's Exhibit 8, Mr. Sturdivant, I'm sorry. Did you say that you did recognize this email?
I recall seeing it. I
Okay.
looked at it as this is normally what every dam owner does when you refill or raise the water levels in your reservoirs. This is what you do. This is the normal undertaking.
And do you recognize, or you see that it's from Lee Mueller to Ron Heilig and Greg Ohl? Do you see that?
Yes,
Did you know that Ron Heilig and Greg Ohl were the operators for Boise Hydro?
I had seen that somewhere in this.
Okay. Do you recognize the name Richard D. Perkypile, who's copied there?
Yes,
He prepared the Part 12D report, didn't he? The 2015 Part 12D report?
yes,
Yeah.
that's correct.
Now, this is from Lee Mueller, and if you could read that highlighted sentence for us. Sorry, it's highlighted on the screen, but not on your page, I don't think. It's just the first sentence.
I have made arrangements with the Four Lakes Task Force to start refilling the Wixom Lake Pond to quote normal summer operating levels beginning tomorrow,
And
Wednesday, the 17th of October, or April, 2019.
there's no indication in this email, at least, that Mr. Mueller had taken this action because he was forced to do so by either DNR or Eagle, right?
I do not see that here.
And this email doesn't mention anything about mussels, does it?
This email does not.
Do you see any employees of DNR or Eagle on this email?
I do not. I was kind of surprised to see that. I did not. Because normally a dam safety regulator would be approving that fill plan.
What's the explanation that Mr. Mueller gives to his dam operators for why they need to start refilling the Wixom Lake Reservoir?
Has he made an arrangement with Four Lakes Task Force?
Let's go to Exhibit 9. And like many emails, this one starts at the bottom. And so if you could highlight that, Amy, thank you very much. You see, this is a message from Ron Heilig to, he says, hello, Lee. Do you see that?
Yes.
And he's reporting to him that the Wixom Lake had been returned to its normal level, right?
Yes.
And 675.8, that's the normal level, isn't it?
Yeah, I think it was 675.82 or yeah. Yes, for all intent and purposes, yes.
Okay. Okay, Amy, could you bring up the response there? Thank you.
This did surprise me that they were already spilling. Sorry,
We'll ask questions and then
understood. Excuse me, Your Honor.
questions, and you'll get the answer. And then I'll bet Ms. Almanroth's going to answer questions, and then you'll get. It goes a lot smoother.
Excuse me, Your Honor.
No worries, no worries. We're all just anxious to find out the information. So
So this is from Lee Moeller to Ron Heilig. You see that, Mr. Sturdivant?
Yes.
Okay. And could you just read the first, let's see here, 1, 2, 3, 4 sentences of this email from Mr. Mueller?
Thanks for the update this morning. I received a thank you from Dave Kepler earlier this morning for the Wixom Lake Pond level achievement. He in turn had numerous people contact him expressing appreciation for the restoration of quote unquote their lake. Going forward, we want to make every effort to keep any commitments that are made to the Four Lakes Task Force.
Great, thank you. And so going forward, what did Mr. Mueller want his dam operator to make every effort to do?
Maintain that water level.
Well, more specifically in that 4th sentence that you just read, what is it that he wanted his dam operator to do?
Maintain the water level of 675.81.
Right, because they had made that commitment to the Four Lakes Task Force, right?
Yes.
And this email doesn't mention anywhere, at least as far as you can see, that Eagle or DNR somehow forced this result on Boyce Hydro, does it?
Can you repeat that, please?
This email doesn't indicate that Eagle or DNR forced Boyce Hydro to maintain the normal
This
level.
does not.
This email doesn't mention mussels, does it?
It does not.
Who thanked Mr. Kepler for returning Wixom Lake to its normal level?
Can you rephrase that? Because Dave actually thanks Lee.
According to the 3rd sentence that you read, who thanked Mr. Kepler? Who contacted him to express appreciation?
Oh, excuse me, riparian owners.
Yeah, who are they?
Pardon me?
When you say riparian owners, who are you referring to?
People who live directly around the impoundment of shoreline property.
Let's turn to Defendant's Exhibit 15. Thank you.
One five.
Yes, 1-5.
Thank you.
Do you recognize this document, Mr. Sturdivant?
Yes.
Uh, If you turn to the second page of this document, Mr. Sturdivant, will you tell us what the date is?
May 28th of 2019.
So this is the Part 307 order, is that right?
That's correct.
And this was issued after Boyce Hydro had already returned Wixom Lake to its normal level, wasn't it?
Yes.
If you look at paragraph 2 on page 2 of Exhibit 15, you see that it concluded that the normal level of Wixom Lake should be 675.8. Do you see that?
Yes.
Now, this order did not actually apply to Boyce Hydro, did it?
Not directly, but I thought they were still under ownership.
It didn't directly apply to them though, did it?
Not in this, no, not right in that context.
Let's go to Exhibit 10.
Let me ask you a question.
Yes.
In paragraphs 1 and 2 of 15, page 2, it uses the acronym NGVD and NAVD, which the internet tells me is National Geodetic Vertical Datum of 1929 or North American Vertical Datum of 1988. What I'm wondering is, what is the 630.8 from what? So what's sort of the, what is zero? Is it the height of water on the Atlantic coastline? I just don't.
I can get you that answer in just 1 second, Your Honor.
Let somebody else, I'll bet 2 people in this courtroom could answer that question.
I would guess you're right, Your Honor.
The point of reference is average sea level, Your Honor. Does that answer your question?
Average sea level for the Atlantic Ocean, the Pacific Ocean, or are they the same? And if they're the same, why do we have a canal between 2 continents?
You want me to answer everything?
Sure.
I believe that the points are along the eastern seacoast. but
Okay.
in the 29 datum only had 1 or 2 points,
Oh.
and the 88 datum took several points and then averaged them all together. So
Do you agree with that?
He's right.
Okay.
Yeah.
Good, thank you. We have a stipulation the parties agree to.
We're done.
Thank you. Yeah. See, I told you I was a consensus builder. Council, you never believed me. But okay, thank you both, Mr. Trumbull and Mr. Sturtevant. I assume you're Mr. Trumbull, but
So Mr. Sturdivant, we saw previously Exhibit 9, which is Ron Heilig returning Wixom Lake to its normal level in early May 2019. Right?
Yes.
Okay. Yeah, that was 9, just to refresh. So in early May 2019, Wixom Lake is returned to its normal level. So let's move forward to Exhibit 10. So defendant's Exhibit 10. And yeah, Amy, if you could bring up the Zoom there, thank you. So do you recognize this email, Mr. Sturdivant?
Vaguely, yes.
All right, you see it's from David Kepler to Lee and Michelle Mueller. Do you see that?
I was starting at the bottom. Yes, I do.
Okay. And this is October 2019, right?
Yes.
So in this email, Mr. Kepler is referring to a plan to lower Wixom Lake over the winter. And then quote, the plan is to bring it back up in the spring to normal levels with the other dams. Do you see that?
Yes.
Do you see anyone from Eagle or DNR on this email?
I do not.
Uh, Amy, could you go to the next email up? And you can just skip to the top one. Not the got it, thanks. This one right here. Yeah. Yes. Okay, this is Mr. Muller's response to Mr. Kepler's plan to temporary lower Wixom Lake in the winter and then bring it back up in the spring. Does Mr. Muller object to that plan at all, as far as you can tell in this email?
No.
And if you could please read the last sentence, starting with moreover.
Moreover, Boyce acknowledges that it is committed to work in cooperation with the directives of FLTF, the Four Lakes Task Force, regarding the operation of the Edenville Dam. That Four Lakes Task Force is delegated to pursuing permitting matters with Eagle, whether or not they may actually be required by law.
So according to this email, who did Lee Muller think Boyce was accountable for the operation of the Edenville Dam?
Four Lakes Task Force.
Is there any indication in this email that Eagle or DNR had forced this relationship on Boyce Hydro and the Four Lakes Task Force?
Not directly, no.
And this email doesn't mention anything about mussels, does it?
Nope. No.
Okay, let's turn to Defendant's Exhibits 11. Have you seen this press release before, Mr. Sturdivant?
I vaguely remember reading this one.
Okay, who's it prepared by? Or who's it issued by, do you see?
Four Lakes Task Force.
Okay. And Amy, if you could bring up the highlighted areas. If you could look up at the screen, Mr. Sturdivant. Based on the highlighted language, I'll give you just a minute. So based on the highlighted language, is Four Lakes Task Force expressing any intent to keep the level of Wixom Lake down permanently?
No,
No, their plan is to bring it back up in early spring, right?
that is correct after the, yeah.
So their request to lower it over the winter, at least according to this press release, was not a request to change the normal summer level at all, was it?
No,
Do you see any indication in this press release that either Eagle or DNR were forcing Four Lakes Task Force to return Wixom Lake to its normal level in the spring of 2020?
Only that they knew they were required to as part of the 307 order.
And this press release doesn't say we have to return it in the spring of 2020 because of mussels, right?
No, as a result of the order, the water levels order. No detail.
Let's turn to Exhibit 21, Defendant's Exhibit 21. When Boyce Hydro and Four Lakes Task Force asked to temporarily lower Wixom Lake over the winter below its normal winter level, Eagle said no, right?
Correct.
And they did it anyway, didn't they?
That's my understanding.
Do you recognize this document, Exhibit 21?
I do.
Okay, this is an enforcement notice dated December 12th, 2019. Do you see that?
Yes.
And Amy, if you could highlight that first paragraph. So the unauthorized activity that this enforcement notice identifies is dropping Wixom Lake below the level of 672.8. Do you see that?
Yep.
That's
Yes.
that's not the normal summer level, is it?
No.
That's just the normal winter level, wasn't it?
Yes.
Okay, Amy, if you could look at highlight the last two paragraphs, Amy, please.
Sorry, what was the normal summer? What was the normal winter?
The normal summer level, Your Honor, is 675.8. The normal winter level is 672.8. And they had, Mr. Sturdivant, they had dropped it even below the normal winter level, right?
8 feet below normal summer level.
Yeah. And if you look at the last two paragraphs of this enforcement notice, do you see any indication that Eagle is directing Boyce Hydro to return Wixom Lake to its normal summer level?
No.
This is just a request to return Wixom Lake to its normal winter level. Isn't that right?
Yep. Raise it 5 feet. That's what it comes to.
Let's go to Defendant's Exhibit 20. So if you turn the page, you'll see some very small writing. This is a permit application. If you go to the very bottom, Amy, to the timestamp, that's a permit application dated February 27th, 2020. Do you see that?
Not yet.
Super small on the very bottom.
What page are you on?
If you go to the second
Oh,
page,
yes.
yeah.
227, 2020. Yes, I see.
Okay.
It. Thank you.
So this is a permit application, and Amy, if you could find the highlighted portion that describes the purpose of the permit application. Keep going down. We'll come back to that one later, but if you could find the next highlight. Here we go. Could you pull up the highlights? Thank you. And so, Mr. Sturdivant, see the page reference there so you can find it. Page 7 of 12. Are you with us?
Yes, I am.
Okay. So if you reference the highlighted portions of this permit, this is just a permit asking to restore Wixom Lake to its normal summer level. Isn't that right?
Yes,
That's what Boys Hydro and the Four Lakes Task Force had already planned on doing, wasn't it?
that's what they wanted to do, yes.
At this time of February 2020, Spicer Group had already concluded that the dam lacked sufficient spillway capacity, hadn't they?
That's correct.
So Amy, could you scroll up to the previous highlight? So if you could bring up both of those for the consultants. Yep, just like that. So that's page 5 of 12.
Yes,
So even though, and if you see the second highlighted, Ron Hansen with the Spicer Group is a consultant on this application, isn't he?
yes,
So even though the Spicer Group had concluded that the Edenville Dam lacked sufficient spillway capacity, there's still the consultant submitting an application asking to return it to its normal summer level. Isn't that right?
yes.
Did you ever see any evidence that the Spicer Group recommended not maintaining the normal summer level of Wixom Lake?
No, nor would I expect it.
Let's turn to Exhibit 12. So let's go down to the bottom of Exhibit 12. Do you see that this is an email from Dave Kepler to Lee Mueller?
What page of this exhibit?
It's date stamp 003.
Okay,
And it's dated April 9th, 2020. Do you see that?
okay. I believe I'm on the right one.
Okay. So let's go up to the next email from Lee Mueller to David Kepler. And he said, I'll give you a second with this. Well, first, is this looking familiar to you, Mr. Sturtevant? Did you review this email?
A little bit, yes.
Okay.
Exactly what we talked about.
Okay. So this is Mr. Mueller informing Mr. Kepler that he had asked his dam operator to prepare for the reservoir refill in spring of 2020. Do you see that?
Yes,
Do you see any indication in this email that he was forced to do this by Eagle or DNR?
no, only precaution.
Okay, let's go to the so let's go all the way to the top there. This is bait stamp 002.
Thank you.
Or excuse me, no, it's 001, isn't it, Amy? Or actually, sorry, let's go back to the previous email. Its time is 4/9/2020, time 3:19 PM. It's on date stamp 002. It's from Lee to Dave Kepler. There, thank you. So this is Mr. Mueller acknowledging the Boyce plan for implementing the now issued DEQ permit for reservoir pond level restoration. Do you see that, Mr. Sturdivant?
Yes.
Kate, what's the difference between a permit and an order in your experience in Wisconsin?
You would get a permit that operates within the scope of the order, whatever that order is for.
Well, let me be more specific. So at least in Wisconsin, if someone asked for a permit to do something in Wisconsin DNR, was it with DNR?
Yes.
And Wisconsin DNR gave it to them, was that the same thing as an emergency dam order?
No.
That person didn't have to do the thing that the permit allowed them to do, right?
Correct.
Whereas an order is a mandate, you have to do this, right?
That is correct.
And in this email, Mr. Mueller is just referring to DEQ permit, isn't that right?
Yes, not uncommon that someone outside of the industry or outside of the regulatory environment would go back and forth.
Okay. Well, let's go to now let's go to bait stamp 001 of Defendant's Exhibit 12. And look at Dave Kepler's message. Those first two lines, actually, Amy. So what's Mr. Kepler asking about here?
I have to find that.
Oh, it'll be the very first page of the exhibit at the
Okay.
bottom.
Can you rephrase your question, please? Sorry.
That's okay. Mr. Kepler is asking Mr. Mueller for an update on the lake level drop. Do you see that?
Yes.
And in that second line, what's the explanation he gives for needing that information?
He's getting a lot of calls.
Yeah. From who? Who do you think?
Riparians.
Yeah.
Normal practice.
Uh-huh. All right, let's go to the top email, Amy. Thanks. All right, so Mr. Mueller on April 11th, 2020 confirms that Boyce Hydro personnel will commence the water level increase starting on April 13th, 2020. Do you see that?
Yes.
Oh, Amy, could you bring in the second paragraph? I was looking in the wrong paragraph. That's why I was confused. The second paragraph of that email. Thank you. Yeah, loop that in. Mr. Mueller In that second paragraph of the email, he explains that the reservoir will continue at a daily rate until normal pool is achieved. Do you see that?
Yes,
And then he says in the very last line that normal pool will be maintained until otherwise directed by Four Lakes Task Force. Do you see that?
yes,
So he didn't say we're going to maintain the normal pool unless otherwise directed by DNR or Eagle, did he?
no,
No, he's referring to the Four Lakes Task Force. Isn't that right?
that's correct.
So take note of this date. It's April 13th that the reservoir will start refilling based on an order given on April 11th. Do you understand what I'm saying? Or excuse me, a direction by Lee Moeller to his personnel.
Yes,
Okay. So let's go next to Exhibit 19, Defendant's Exhibit 19.
Excuse me. You have a bit more in questioning.
Why don't, maybe 3 more minutes and then a break? Is that okay, Your Honor?
Sure.
Thank you. Do you recognize this document? I'll give you a minute to flip through. It's a legal complaint.
What's the exhibit number, please?
Pardon me. It's Exhibit 19, Defendant's Exhibit 19. So, Mr. Sturtevant, if you turn the page, that's really the meat of the document. And as you flip through this, do you recognize Exhibit 19, Mr. Sturtevant?
yes,
Do you see the date that the document was issued on the very bottom of the very first page?
yeah, I did.
The very bottom, it's a stamp,
Yep, May 1st.
May 1st. So that's after Wixom Lake had already been directed to let me rephrase that. That's after Boyce Hydro had directed its personnel to return Wixom Lake to its normal level, right?
Correct.
It's about 3 weeks later, isn't that right?
Yes,
So this document is not the reason that Boyce Hydro directed its personnel to return Wixom Lake to its normal level in the spring of 2020, is it?
can we rephrase that, please?
This document dated May 1st is not the reason that Boyce Hydro directed its personnel 3 weeks prior to return Wixom Lake to its normal level, is it?
Response?
We just went over the previous document showing why Wixom Lake was returned to its normal level at Lee Moeller's direction.
All right. First, this is a Daubert hearing. This is not the trial. So why do we need this for the Daubert hearing? I guess my first question, Mr. Gann.
This
Challenge the ability of the witness to provide testimony. How does that question that you have proffered to him make it more likely than not, which is the 400 series of rules of evidence, that he is or is not qualified to testify?
the opinion that we're attacking under MRE 702 is Mr. Sturtevant's opinion that the Four Lakes
date, this, filing took place on Y date. And then you can make whatever arguments you want out of it, but I'll let you ask the question if you really want to, but I think you can accomplish the same And I'm not trying to, I guess I am kind of telling people how to try their case, but I mean, just for purposes of this, it's up to you. I'm gonna overrule the objection. If you want to rephrase it, you may, or simply, I think in fairness to the witness, you need to say what the question is anyway. I can't frankly remember what the basic question was.
I understand, Your Honor. So if we go back to Exhibit 12, Mr. Sturdivant. Exhibit 12 is the email exchange that we just reviewed, in which Boyce Hydro explained that it was directing its personnel to return Wixom Lake to the normal summer level. Do you remember talking about this document?
Yes.
Did you see any indication in this email exchange that the reason they were doing that is because of a threat by DNR or Eagle?
Not in this email.
In fact, the lawsuit, it was filed 3 weeks after they had already given this direction. Isn't that right?
Yes. Again, I don't know what their foundation knows for that.
Okay. I think now would be it. Were you asking about a break earlier, Your Honor? That now would be a good break for us. Okay.
Plaintiff's okay with that as well? All right, so it's now, it's 2:36. Let's reconvene at 5 minutes before 3. Okay, that'll give us a little bit of extra time. There is, I can't offer, a food truck, but there are vending machines, so,
right.
Thank
try
you.
to stay healthy, but that may be sort of where we're at. So
Thank
we're in
you.
recess until 5 minutes before the hour. Thank you. Just go about your business. All right. It's 5 minutes or 6 minutes before the hour. Quick jump. Mr. Trudell, everything okay? Frozen. You're frozen in time. Are you able to hear us okay?
Hey, curious to Judge, can you hear me okay?
I
don't know
can't.
if you can.
No.
It's not, okay. Oh, I don't have a camera on this computer. Yeah, he's Judge, or Mr. Vidal, you're frozen for me as well. Let's see.
Can you hear?
Oh, it looks like he just got booted out. So I will add him again as soon as I can.
No, that's a must have.
Yep, absolutely. Absolutely. Oh, looks like you're back.
All right.
Can you hear me now?
We can. We lost you for a second and I was more than a little worried. So good. Everything all right on your end?
Yes, thank you.
Okay, thank you. All right, it's 5 minutes before the hour. We're back in session. Mr. Sturtevant, you're still under oath. Mr. Gamble, you may continue your exam.
Thank you, Mr. Sturdivant. If you could please pull out this time the blue binders, and it will be volume 2. Volume 2 of the blue binder.
We called the blue binders, that's the plaintiffs, right?
Plaintiffs,
Okay.
pardon me. Yes, the plaintiffs binder, volume 2. So if you go to tab 19, Mr. Sturdivant.
Really testing the clasps on these.
Gold stars for whoever picked the binders. They're holding
Yeah.
up quite nicely.
Yeah, normally they break, but I don't.
Yeah, they do. First turn.
Do you remember speaking about this letter earlier today, Mr.
do.
Sturdivant?
Yes,
This is the letter from the director of Eagle to, I think, the U.S. House of Representatives. Is that right?
yes.
So if you turn to page 7 of 8 of Exhibit 19 in Volume 2 of the plaintiff's binders. You with me?
Yes, I am.
You'll see some bullet points, and maybe turn the previous page to see question number 7. And the question that the U.S. committee was asking was, what legal and regulatory actions, if any, has Michigan taken against Boyce Hydro with respect to the Edenville Dam? Do you see that? This is on page 5 of 8.
Yes.
Okay. So just to provide context of these bullet points. So now if we flip forward to page 7 of 8.
Excuse me.
Eagle lists on April 9th, 2020, a permit issued to Boyce at its request to refill Wixom Lake to its normal summer pool elevation. Do you see that?
Yes.
Okay. So could you please read the bullet point for May 1st, 2020?
May 1, 2020, complaint was filed in Circuit Court, Hingham. Is that right? Circuit Court against Boyce to recover natural resource damages for the harm caused by the unauthorized yet temporary winter 2018-2019 drawdowns. The complaint had nothing to do with the lake level. It did not seek to require Boyce to maintain a certain lake level. The Part 307 orders obtained by the local jurisdictions already did that. Nor did it seek to require Boyce to raise the lake level to its normal summer pool level. Boyce had already done that. It was solely to recover damages for the past temporary drawdowns and to require Boyce to obtain permits before performing any drastic temporary drawdowns.
So at least according to Eagle, the May 1st, 2020 complaint was not a demand to Boyce Hydro to raise the lake to its normal summer pool level, right?
Not directly, no.
Yeah, because according to Eagle in this letter, Boyce had already done that, right?
Yes.
Okay. So I've asked you questions about the first opinion and the second opinion that we're challenging, and now we're going to move to the third opinion. Thank you, Danielle.
Are we done with volume 2?
Yes, we're done with volume 2. You can put that away. And so your third opinion that we've challenged is that Eagle and DNR concealed the hazard rating of the Edenville Dam from the public. Is that still your opinion?
Yes.
Now, earlier today, you examined the 2017 order that the Federal Energy Regulatory Commission issued that identified the hazard rating of the Edenville Dam. Do you remember seeing that?
Yes.
That was a public document, wasn't it?
And I don't recall whether that was public or protected.
If it was a public document, would that change your opinion about whether Eagle concealed that information?
No.
So who at Eagle concealed that information from who?
By not providing that information actually at the 307 hearing, I believe that they concealed that information.
Did you conduct any studies of the plaintiffs or the riparians rather in this area to determine if they were aware of the hazard rating of the Edenville Dam?
No.
Did you speak to any any riparians that told you they were not aware of the hazard rating of the Edenville Dam?
No.
Let's go to Defendant's Exhibit 6. No defendants. So do you recognize this document, Mr. Sturdivant?
Yeah.
This is the study that Spicer Group prepared for the Part 307 proceeding, isn't it?
Yes.
And it's your understanding that the hazard rating of the Edenville Dam was not disclosed during the Part 307 proceeding, is that right?
Yes.
Okay. Let's turn to Bates stamp 005 of Defendant's Exhibit 6. If we could bring up the highlighted area. Could you please read this paragraph, Mr. Sturdivant?
Edenville Dam, which includes both you want me to read it aloud?
Yes, please.
Which includes both the Tidbawassi and tobacco embankments, is classified as having a high hazard potential due to the impact that a potential failure could have on downstream developments, potential loss of life, and potential for failure of downstream dams in the maximum height of, I think it's 4.5 feet. There's some errors in the yeah, I don't have all the letters in mind. There's some errors in the fonts.
Oh.
And it's actually missing some of the.
Oh, I see. I see what you're saying. Yeah, well, if you can look up on the screen, are you able to see that, Mr. Sturdivant?
Yes. Maximum height, yeah, I did remember right, 54.5 feet. The state of Michigan law requires this dam to have a spillway capacity to convey half the probable maximum flood.
Thank you. So it turns out that the hazard rating of the Edenville Dam was part of the Part 307 proceeding, wasn't it?
I wasn't aware that this was made a public document by Eagle, so I don't know.
Okay. Um, now, a hazard rating, just because a dam is high hazard doesn't mean it's in poor condition, does it?
That's correct. It has nothing to do with the physical condition of the dam.
So just because a dam is high hazard doesn't mean that this dam is going to break and hurt everybody, right? I mean,
No, it means if it did break, it's going to kill somebody.
right, but by notifying the public this is a high hazard dam, it doesn't say anything about the actual condition of the dam, right?
No.
Okay. Um, and you also testified that Eagle and DNR concealed from the public that the dam lacked sufficient spillway capacity. Is that still your opinion?
Yes.
Well, you previously reviewed the document from FERC that it issued in 2017, in which it identified the need to identify the lack of spillway capacity. Do you remember reading that?
Yes.
I mean, are you aware that that was a public document?
That was FERC's requirement, not the state's. But
Okay.
yes. You know what? I don't know that that's a public document. FERC seldom releases anything to an owner that falls under the public's purview or the public's eye. It's not an easy challenge to get into their electronic library, and it's much of their stuff, unless it's the owner can access it. I can access the stuff on our FERC dam, but the public cannot.
Okay, well, if needed in the future, we can show that was very much a public document, but I understand that you can't remember off the top of your head whether it was or not. So let's look at this lake level report. First, Amy, page PDF 3. No, could you highlight the other highlight? Yeah, that one. All right. So this is on. I apologize, there are a few printing errors, but the version that we put up on the screen here is complete.
What page is this?
This is it's page 2. If you're looking at the page in the middle of the bottom, it's
Those
Bait
page
stamp
numbers are
00.
missing on some of them.
okay. It's bait stamp
I see the
003.
two.
Okay.
Two did show up.
All right.
Sorry, what exhibit number, please?
This is Defendant's Exhibit 6,
And date stamp.
003. So in this highlighted sentence, as part of the Part 307 proceeding, Spicer Group recommends the establishment of a special assessment district. Do you see that?
Yes.
And that's to provide a method of financing the acquisition, operation, maintenance, repairs, and improvements to the dams to ensure that the dams meet state of Michigan dam safety standards. Do you see that?
Yep. Yes.
And if you turn to
Leave
Bates,
it there for a second.
yes.
Thank you. Please. Thank you.
So if you turn to the next page, Mr. Sturdivant, late stat 004, we could bring up that middle highlight. So if you look at the highlighted language on the screen, Spicer Group is explaining that their conclusion is that it should be anticipated that modest improvements to spillway capacity at Wixom Lake and Secord Lake will be required. You see that?
Yes.
Um, and that repairs at all four dams will be required?
I see that.
Okay. So it's your opinion that Eagle concealed this information from the public?
The extent of what's necessary and the hazard it poses, yes.
Okay. You didn't see any evidence at all in which someone from Eagle told someone at Spicer Group, don't tell the public about the need to increase the spillway capacity at Wixom Lake? Did
I
you?
have not seen it.
Did you see evidence of that sort from anyone from Michigan Department of Natural Resources?
No.
Let's go to Defendant's Exhibit 32. So this is a long email chain. I won't make you read all of this. But as you look at this, Mr. Sturdivant, do you recognize at least some of these emails?
Yes.
You see, this is an exchange between Teresa Seidel at Eagle and a man named Bill Lang. Is that right?
Yes.
And Bill Lang explains that he lives on Wixom Lake, right?
He explains what?
That he lives on Wixom Lake.
Thank you.
So Amy, if we start at the bottom, just like we always have. So just the bottom email, yeah. And we'll just hit the highlights here. But according to Mr. Lang, he says that I spoke, it's addressed to both Teresa Seidel and Dan Devon at Eagle. And he says, as a property owner on Wixom Lake, it's been trying to get specific information on what is actually going on. It's been very frustrating. Do you see that? That top
I
highlight
think I'm
there?
on the right page. You're on
Oh, it's
4?
at the very last page. Yeah, 004.
Sorry.
That's okay.
Okay.
And he says, the Four Lakes Task Force has been telling people the state of Michigan is going to increase the spillway capacity requirements for dams. Do you see that? It's highlighted there,
On the bottom highlight?
the top highlight.
Okay.
Okay. So according to Mr. Lang, at least, the Four Lakes Task Force has been informing him and other property owners that there's a need to raise money to increase the spillway capacity of the dam. Do you see that?
Yes.
And if you go to the second highlight down at the bottom there, what he's asking these Eagle employees, he says, I would like to know if that is the Michigan law. Do you see that?
Yes.
All right, so let's go to the next email. Yep, thank you, Amy. This is from Teresa Seidel back to Mr. Lang and Dan Devon. And she confirms in the highlight, yes, the spillway must be able to convey the half probable maximum flood, right?
Yes.
And then if we go up to the next email, Mr. Lang responds with a follow-up question that's highlighted in the end there. He says, I want to make clear that my questions are in regard to whether the spillway capacity has to be increased. You see that?
Yes.
Now, the versions of this email that you reviewed as part of your report stop here. Do you remember reviewing that email?
Yes, I believe I did.
But this version of the email can it includes the full series of conversations for these people. Do you know why the version that you reviewed didn't include the full exchange between these two?
I don't know.
Okay. Did you rely entirely on the plaintiff's attorneys who hired you to provide you with this type of information?
These emails, yes.
Right. You didn't have a way
I didn't have a
to
way to
contact Ms. Seidel and say, was there any further discussion after this point? Right.
Correct.
Okay. So let's go to the full email exchange. So it's a long one. Like I said, I won't make you read the whole thing. But if you get one more, Amy, yep. And so this is from Teresa to Mr. Lang. And she says in that highlighted, so she answers this question. And so we'll just look at the highlight. She says, I asked one of the dam safety engineers to provide an answer to your question, and then below is his response. You see that?
Yes.
So, we'll go ahead and just skip to the end. Yep, that right there. So if you could highlight that, Amy, thank you. And her response, and her response was to this member of the public who lives on Wixom Lake, saying it is likely that the dam does not, in its current condition, meet state requirement to be able to pass half PMF and will require modifications to meet this standard. You see that?
Yes.
So at least in this exchange, these Eagle employees were not hiding this from this member of the public, right?
Not from this individual, no.
And then if we go to the very top email, he responds and he says, thank you. This is exactly the kind of factual information I've been attempting to get. You see that?
Yes.
And these final two emails weren't part of your initial review, right?
I remember reading about the 60,000 cubic feet per second and the 28,000 and the justification that it's really not 50% of the PMF, that a half PMF is a different calculation and.
So you remember seeing something about these emails?
Yes.
Okay. But the bottom line is that Ms. Seidel gave this man the information he was asking for, right?
Yes.
Okay. So I've asked you questions about the first three of your opinions that we've challenged. So now we're going to move to the fourth opinion from you, which is the fourth opinion was that it was your opinion that Eagle and DNR both knew that because the Edenville Dam lacked sufficient spillway capacity, returning it to its normal level would cause the dam to fail if it rained hard. Is that your opinion?
Yes, it is.
And there's no dam safety guideline published by the Federal Energy Regulatory Commission that directs that the water of an impoundment must immediately be lowered if the dam is let is found to lack sufficient spillway capacity, is there?
No, not directly.
Okay.
You're talking about FERC regulation.
Yes, FERC guidelines.
Yeah, they can fine us. They can order the
I
levels
understand,
lower.
but my question is, there's no dam safety guideline issued by FERC directing that just because a dam lacks sufficient spillway capacity, the impoundment must immediately be lowered. There's no guideline from FERC that directs that, is there?
I can't answer that. I don't have their federal register sitting in front of me.
So there's no guideline from the National Dam Safety Review Board directing that the water of an impoundment must immediately be lowered if the dam is found to lack sufficient spillway capacity, is there?
They don't have any authority to regulate.
So is that a no?
That's a no.
Is there a published guideline from the Association of Dam, or excuse me, there's no published guideline from the Association of State Dam Safety Officials that directs that the water of an impoundment must be immediately lowered if the dam is found to lack sufficient spillway capacity, is there?
They have guidance documents that is a normal procedure.
But my question is, there's no guideline from the ASDSO that directs dam owners, says, as soon as you discover that a dam lacks sufficient spillway capacity, you must immediately lower the reservoir level.
No, they're not a regulatory authority. No,
They don't issue that guideline, do
they
they?
can't.
FERC first notified Boyce Hydro that they lacked sufficient spillway capacity at Edenville Dam, or excuse me, not Boyce Hydro. It would have been a previous owner. So FERC first notified the owner of the Edenville Dam that the Edenville Dam lacked sufficient spillway capacity, at least back to 1993. Isn't that right?
Yes.
And then FERC still issued a license that required the owner of the Edenville Dam to maintain the normal level of Wixom Lake, even though it lacks sufficient spillway capacity, right?
They did during that time period, yes.
So that license was issued in 1998. Is that
That's
right?
what I recall.
Okay. And
Here, please.
1998. So in 1993, FERC notifies the owner you lack sufficient spillway capacity at the Edenville Dam. And then in 1998, it issues them a license requiring them to maintain the normal level of Wixom Lake. Isn't that right?
Yes.
So just because FERC found that the Edenville Dam lacked spillway capacity did not lead FERC to conclude that the normal level should not be maintained. Is that fair to say?
Response.
This goes exactly to the fourth opinion that we're challenging, Your Honor.
Overruled. Go ahead.
The question would arise, and this is,
Well,
I can't go yes or no to that question. I just can't, because there's too much information that's missing.
Okay, hold on a second. You want to rephrase?
Yes.
Thank
Go
you.
ahead.
So FERC notified the owner they lack sufficient spillway capacity in 1993, right?
Yes,
In 1998, they required them to maintain the normal level of Wixom Lake, right?
correct.
So that requirement was included in the license for 20 more years until the license was revoked in 2018, right?
Yes.
Let's go to Defendant's Exhibit 30. You know who Frank Christie is, Mr. Sturdivant?
I do not.
He was a dam safety engineer employed by Boyce Hydro. Does that refresh your recollection at all?
Yes.
Okay. And so it's fair to say you never spoke to Frank Christie, right?
Very safe.
Okay. So, have you reviewed Defendant's Exhibit 30 before? It's just a few pages.
I looked through it. I did not review it in detail because it's been superseded.
Okay. So at least in 2013, which is the date of this letter exchange, let's bring up that third page, Amy, that's highlighted. So this is a letter from Frank Christie to the Federal Energy Regulatory Commission, right?
Yes.
And in this letter, Mr. Christie explains to the Federal Energy Regulatory Commission that as of 2013, Boyce Hydro did not see any benefit from trying to pre-lower Wixom Lake prior to a PMF condition, right?
During a PMF, that was the conclusion.
Yeah. And FERC never required Boyce Hydro to pre-lower Wixom Lake, right?
No, not to meet a full PMF requirement, no.
And in fact, as far as you know,
Excuse me.
FERC personnel agreed with Boyce Hydro's assessment that pre-lowering Wixom Lake would not address the PMF concern, right?
Response.
I can just go to the next exhibit, Your Honor.
Sustain. Move on.
Let's turn to Defendant's Exhibit 31. So do you see that this is, I'll give you a second to look at this, but it's a letter to a U.S. House committee, subcommittee from the chairman of the Federal Energy Regulatory Commission. Do you see that?
Yes.
Okay. So the committee asked question 2, if you could bring that up, Amy. And I'll give you a second with that, Mr. Sturdivant.
Okay.
So this question is saying, FERC knew about the lack of spillway capacity. And so did FERC require limitations on reservoir level, right?
To my knowledge, they did not.
Right, they didn't. And so let's go to the next page. And in answering that question, FERC offered this explanation. I'll give you a second with that, Mr. Sturdivant. So FERC did not require a preemptive drawdown in order to address a PMF condition, right?
Correct, looking at their requirements of a full PMF.
Yeah. So, did you ever speak to anyone at FERC regarding the Edenville Dam?
No.
You didn't have the ability to contact them to help you prepare your report or anything like that?
No.
Let's go to Defendant's Exhibit 13. All right, I think you recognize this document, right, Mr. Sturdivant?
Yes.
So this is the Part 12D report from 2015. Do you see that?
Yes.
And I believe you testified previously that these are exhaustive and detailed reports, right?
Yes, for the most part, they are.
I think you said they were incredibly valuable. Is that right?
Absolutely.
Okay.
Especially to another regulatory agency taking over jurisdiction.
Yeah.
It helps them at least give them guidance.
So this Part 12D report recognized the lack of spillway capacity at the Edenville Dam, didn't it?
Yes.
And it factored that lack of capacity into its recommendations, right?
Yes.
Did this report direct that Wixom Lake should be drawn down because of the lack of spillway capacity?
No, this is prepared by an independent consultant.
Did it recommend drawing down Wixom Lake as a risk mitigation
reduction factor.
technique?
Yeah, I don't remember offhand. I'd have to reread it.
Okay. Can let's go to it's Bait Stamp 005 of Defendant's Exhibit 13. And we can go to the recommendations. So I believe earlier in the day, you analyzed or discussed many of the potential failure modes that were addressed in this report. Do you remember that?
Yes.
And the Part 12D report goes through and talks about those different potential failure modes, but it doesn't ultimately recommend that the dam stop operating, right?
No.
In fact, the recommendation is actually, in fact, could you just read the entire thing into the record, please? This is paragraph 1.3.1.
Based on site inspection, review of documents included in the SDID, supplemental SDID information, and a new stability analysis, as well as stability analysis for the proposed improvements, the independent consultant finds the projects and its facilities suitable for continued safe and reliable operation.
All right, so the Part 12D report concluded that the dam was suitable for continued safe and reliable operation, right?
That's what they concluded. Yes.
And there's no legal requirement that FERC, who is the regulating body at this time, was required to ignore this recommendation, was there?
I don't understand the question.
Was FERC required to ignore this recommendation?
No.
Was Eagle required to ignore this recommendation? Let's turn to the potential failure modes analysis that you referred to earlier. It's on page 010, Bait Stamp 010, or if you're looking in the middle, it's page 24 of Defendant's Exhibit 13.
Okay.
Okay, are you with me, Your Honor? Okay. So at the top of this page, it describes a PFMA core team. Do you see that?
Yes.
And it shows that in 2005, the core team included a list of people. Do you see anyone on there from the state of Michigan?
No. Surprisingly.
And then it says there was a second PFMA session in 2015. Do you see that?
Yeah.
And then it also describes the people who participated in that 2015 session. You see that?
Yes.
Is anyone from the state of Michigan listed there? And then let's go to the next two paragraphs down where it starts the 2015 PFMA. Yep. And this will describe what the potential failure modes analysis process included. I'll give you a second with that.
Okay.
So at least according to this report, they considered all available information about the dam, and including its construction, operating, performance history, right?
That's what it says. Yes.
And they also inspected the embankments and spillways, right?
Correct.
You didn't inspect the embankments or spillways of the Edenville Dam, did you?
No, I did not.
And so let's go to the different potential failure modes. And so let's move forward to date stamp 011, paragraph 3.2.1. And this is the first potential failure mode analyzed in the report as a category 1. Do you see that?
Yes.
So this is the failure mode that they thought might occur because of the dam's lack of spillway capacity, right?
One of them, yes.
Yeah. So they were worried that potentially because of that lack of spillway capacity, the embankment could be overtopped, right?
Correct.
And then let's go to the next paragraph, which is 3.2.1.2. Yep. So these are the risk reduction opportunities because of the lack of spillway capacity. Do you see that?
Yep. Yes.
And they say that the risk is going to be reduced because of the plan to increase the spillway capacity, right?
Yes.
And then they don't list lowering the Wixom Lake Reservoir as a way to reduce the risk presented by the lack of spillway capacity, do they?
No.
So let's go to paragraph 3.2.1.3, which is the next one down. And this describes the surveillance and monitoring plan. Do you see that?
Yes.
I'll give you a second with that.
Okay.
So the report concludes that the surveillance conducted in the current manner and frequency is adequate to satisfy the public safety risk posed by the lack of spillway capacity, right?
That's what it says.
And it says that that second sentence, riprap exists along the top of the upstream slope. And except for a flood of magnitude much greater than that seen in the 92-year history of the project. And it says no such occurrence is anticipated to occur. You see that?
Yep. Yes.
All right. So you also discuss potential failure mode 4. So let's just go to the next one down. Earlier today, do you remember that, Mr. Sturdivant?
Yes.
The dam piping failure?
Yes.
So this spawns two pages, but first, I guess I can just ask you, because of potential failure mode 4, this report doesn't recommend lowering Wixom Lake, does it?
No.
It doesn't say that that's one of the risk reduction measures that needs to be taken, right?
No, it does not.
And then if you go to paragraph 3.2.3.3, assessing the surveillance and monitoring plan. It ultimately concludes that the continued surveillance that was already being done at the dam is adequate for the purpose of oversight. Do you see that?
I do see that.
I believe you also discussed potential failure mode 9, concrete deterioration of the OG spillway earlier today.
Yes.
Okay. None of the risk reduction measures or opportunities identified here for potential failure mode 9 were that the dam should be lowered below its normal level, right?
For some reason, I'm not even seeing that one. You're on page 014.
No, 012,
Oh.
PMF
Excuse
9.
me, I was a step ahead there.
No, it's okay.
Okay.
So the report doesn't recommend a risk reduction measure of lowering Wixom Lake in order to address the risk posed by PMF 9, right?
No, just repair of it.
Okay.
Reconstruction of it.
All right, let's skip forward to probable failure number 5, which is page 016 of Defendant's Exhibit 13.
Okay.
So you didn't discuss this one this morning, so I thought we should go through this. This refers to liquefaction, doesn't it?
Yes.
And is it your understanding that the Edenville Dam failed because of liquefaction?
Static liquefaction.
I understand, but do you have a different opinion than that reached by other engineers who have concluded that the dam failed because of static liquefaction?
Do I disagree with that?
Yes.
No, I agree with that.
Okay. So if we look at PMF 5, it describes that liquefaction triggered by a seismic event is a potential failure mode. You see that?
Yes.
And then to reduce the risk or risk reduction opportunities, we'll have to go to 2 different pages. It says that a liquefaction analysis was performed for the Edenville embankments. Do you see that?
Yes.
And then it remarked that based on the data obtained from that analysis, that the embankments were not subject to liquefaction. Do you see that?
Pardon me, please. Objection, that's misread.
He did not read it correctly. He's asking if it says something and he's read that.
Well, the witness gets to answer the question.
Can you restate the question?
Sure. The risk reduction opportunity for PFM 5 noted that the embankments of the Edenville Dam were not subject to liquefaction, right?
Under these specific conditions, that's true.
Right, because there's a seismic trigger or a static trigger. There's different triggers. Is that fair to say? Potential for liquefaction?
There's a component missing you're not addressing.
Okay, well, let's just focus on what the report says. So the report concludes that the embankments, or excuse me, in paragraph 3.2.11.3, it says the embankment soils are not subject to liquefaction, doesn't it?
Under seismic loading at normal pool, that's what it is saying.
Right. And so for that reason, the only reference to liquefaction in this entire report is a conclusion that the soils are not actually subject to liquefaction, right?
Under seismic loading, they are not.
It didn't consider static liquefaction as a potential failure mode, did it?
It would not have. They don't use that term in PERC.
Okay, so let's go down to the very end. On page, it's just lower below that very last sentence. They just say they haven't identified any other failure modes for this project, right?
No, I would hope that they have to say that. But
Yeah.
that's the conclusion, or they have to readdress.
So they did not study static liquefaction specifically, right?
Not using that specific terminology, no.
But they did
look
study
at it.
seismic liquefaction,
Yes,
and they ultimately concluded that the embankment soils are not subject to liquefaction, right?
Excuse me. Okay, we have one witness. We have about 15 lawyers. And I have heard multiple times today, lawyers commenting about what they think maybe the witness should have said, could have said, or did say. That will stop. I don't want to hear that again until this case is in the Court of Appeals of the state of Michigan, whether that is 1 day, 1 year, or 10 years. It's called gesticulation. It is an act of a testimonial nature from someone who is not on the witness stand. So I understand the temptation to do so, and I understand we don't have a jury here. However, it is not appropriate and it shall cease. Thank you. Continue the exam.
Stick on there. It's okay. Yeah. What does it mean? Well, I'll direct you on page 47. So this one doesn't have a bait stamp, but it's page 47 of Defendant's Exhibit 13. And at the very top, that PFM5. Do you see it, Mr. Sturdivant?
yes, I do.
So in reference to a liquefaction analysis, the report concludes that this potential failure mode should be reclassified as category 4 and is no longer a concern for this project. What does that mean for a potential failure mode to be recategorized down to category 4?
You wouldn't consider it any further.
Right. I think you also discussed potential failure mode 10. So let's look at that same page. If you go down to the bottom, yeah. Says, are you with me, Mr. Sturdivant, where it says
totally with you,
PFM 10? Okay. So could you read that paragraph for us, please?
Absolutely. With the installation of the weighted filter tow drain systems, this is no longer a significant concern. The new filters are designed not to clog. The mass of the weighted filter berm will also add stability to the tow area and allow the phreatic water line through the embankment to be intercepted more readily.
Okay. So at least according to this report, they weren't that concerned with potential failure mode 10, right?
Not in the sections that actually had this berm.
Right. And so, let's move to the condition of the embankments. And so if you turn to the next page, which is page 66. And Amy, could you bring up that highlight? So the Part 12D report, I mean, it included a review of the embankment's stability, didn't it?
It did choose a cross section to analyze, yes.
Okay. And it ultimately concluded that the embankment stability studies were done correctly. Isn't that what this paragraph says?
It does.
And so let's turn to the next page again. It's page 67 of defendants 13. I'll give you a second with that, Mr. Sturdivant. Okay, so ultimately, the Part 12D report concludes that the embankments provided adequate factors of safety, right?
The embankment that includes the fill-through buttress.
And it
Yes.
didn't raise a concern that any of the other embankments were dangerously unstable, did it?
They did not.
And ultimately, it concluded in that last line, because you had spoken about the phreatic line. In that last line, it says the drains act to intercept the phreatic line within the embankment and safely conveys the collected seepage to measurement weirs. You see that?
Yes,
So nothing in this report says that the embankment stability is a concern for any of the embankments of the Edenville Dam, does it?
they did not look at the left embankment.
Okay. Let's go to defendants exhibit 17.
Excuse me.
Do you recognize this? I'll give you a moment with it, Mr. Sturdivant. Do you recognize this document, defendants exhibit 17?
I do.
Okay. Did you review this as part of your work?
Yes.
Okay. Amy, could you go to the next page? So these are this is a resolution passed by Midland County, right?
That's my understanding.
Okay. And ultimately, well, before I ask that question, the date of this resolution is October 16th, 2018. You see that at the top of the first page?
I do.
Okay, so that's after FERC revoked the license, right?
Yes, that's my understanding.
So the county resolved, they resolved that determining a normal lake level, it's important to do that to protect the public's health, safety, and welfare. Do you see, if you look up on the screen, it would help. But this is the 1, 2, 3, 4, 5, the fifth paragraph down on the second page.
I do see that.
Okay. And then they directed their legal counsel to file a Part 307 petition to establish that normal level. So if we go to page 003, it's the first large paragraph. Do you see that, Mr. Sturdivant?
Yes.
And then the third, and then that second full paragraph, they appointed Spicer Group as the engineer for the lake level project to see that.
Yes.
And did you ever speak to anyone at Midland or Gladwin County as part of your work for this, for your report?
No,
Have you ever spoken to anyone from any county officials about the Edenville Dam?
no.
And Part 307 proceeding, it takes public safety into account, doesn't it?
It should, yes.
So let's go to Defendant's Exhibit 26. So if you turn the page, Mr. Sturdivant, you'll see highlighted language. This is an excerpt from Part 307. Do you see that?
Yeah.
Okay, so if a court finds that a particular level of a lake is the lake's normal level in a Part 307 proceeding, according to this language, that means that's the level that best protects the public health and safety and welfare, preserves natural resources and property values, right?
That is what it says in the text.
So let's go to Defendant's Exhibit 16. Do you recognize this petition, Mr. Sturdivant?
Yes,
This is the petition filed by the counties, right?
correct.
And neither Eagle nor DNR filed this petition, right? As far as you know?
No, they wouldn't.
So was this petition a public document as far as you know?
As far as I know, yes.
Okay. So paragraph 14, it acknowledges that the Edenville Dam needs repairs. Is that correct?
Yes,
And if you look at paragraph 28, part of the reason they want this Part 307 order is essentially to raise money to fix the dam, right?
yes,
And the counties ultimately asked the court to find that the normal level for Wixom Lake was just its traditional FERC license level, right?
yes.
Yeah.
Additional what? I'm sorry, please.
FERC license level.
Thank you.
So if we go to paragraphs 37 and 38. So it notes that the Edenville Dam had been operating at that level harmoniously for almost 100 years. You see that?
Yes,
But it still wanted the court to take a look and ultimately just adopt that same level into a Part 307 order, right?
that's what I read. Yes,
And they're alleging that that's the level that best protects public safety in paragraph 38, right?
that's what they're alleging.
Okay. When FERC revoked the license that Boys Hydro had, the revocation order didn't recommend lowering Wixom Lake below its normal pool level, did it?
It did not.
It didn't even mention the normal pool level, did it?
No, it would not.
So the county hired Spicer Group to help them with this process, right?
That is my understanding.
And so Spicer Group prepared the report, which is Defendant's Exhibit 6. So that's where we'll go back to if you go to Defendant's Exhibit 6. Then Amy, if you could go to the second page of Defendant's Exhibit 6 and bring up that highlighted language. So at least from the perspective of the engineer that the counties had hired, they say that they were petitioning the court to establish this lake level not only to protect the interests of the counties, but to protect the interests of the property owners, right?
Yes.
And we saw previously that Spicer Group acknowledged that the dam lacked spillway capacity in this report, didn't they?
Yes.
And they laid out a plan to increase the dam's spillway capacity. If we skip ahead to Exhibit 6, Bait Stamp 007. And I apologize, we're just seeing that there are a few printing errors in the printed version, but if you look up on the screen, those errors are not present. And so they, according to the construction plan they outline, if you look at the top, Amy, they say that the repairs to the Edenville Dam are to be completed by the end of 2023. Do you see that?
I see that as their tentative schedule.
Right. And if you, Amy, if you go to the next highlight, that list of dates. Yeah, I mean, so December 2023 is when construction is finally completed, right?
That was their plan. Apparently.
And in the meantime, Spicer Group recommended continuing to maintain the normal level of Wixom Lake, didn't they?
That is what they proposed.
So at least in Spicer Group's opinion, the fact that the dam needed spillway capacity to be increased didn't require a drawdown of Wixom Lake, right?
They did not recommend it.
Right. They actually recommended that the normal levels should be maintained, didn't they?
For all the considerations, yes.
You're not aware of, well, let me start over. We've looked a lot at a Part 12D inspection report required by FERC regulations, but those weren't the only inspections that FERC requires, right?
Correct.
Does FERC also does annual inspections of dams with their own engineers, don't they?
Yes.
Okay, so you reviewed FERC's annual inspections of the Edenville Dam. Did you review those
I
reports?
honestly only looked at one.
Okay.
To see if they were similar to what I was used to seeing what Chicago produces.
Okay, and so you've reviewed reports from FERC engineers about the Edenville Dam, right?
Yes.
And you've reviewed reports about Part 12D reports prepared for the Edenville Dam, right?
Correct.
And those Part 12D reports, those aren't FERC engineers. They're supposed to be outside independent engineers, right?
Yes.
Okay.
They have to be, FERC has to approve those ICs.
Have you also reviewed the reports prepared by Boyce Hydro's internal dam safety engineers too? Like Frank Christie?
Very brief.
Okay. And then you've reviewed the report that Spicer Group prepared, right?
Yes.
Have any of these engineers ever recommended lowering Wixom Lake because of the dam's lack of spillway capacity?
No.
None of them, right? As far as you know, no engineer who has ever inspected the dam prior to its failure ever recommended that Wixom Lake should be lowered because of the dam's lack of spillway capacity, right?
No,
That's not right? Or no one, I did not.
I did not see that someone recommended or pushed forward the idea to lower the reservoir before.
Thank you.
I've asked you questions about the first four opinions that we've challenged. We're now on to opinion number 5, which is your opinion that the Eagle and DNR knew that the soil of the embankments of the Edenville Dam were so unstable that a major storm would cause the dam to fail. Is that correct? Is that your opinion?
That's kind of a summary, but bits and pieces of that, yes.
Okay, so it's your opinion that the reports on record at the time the dam failed showed that the soil of the embankment was so unstable that it was dangerous to maintain the normal level. Is that your
It was
opinion?
dangerous if the water levels increased. Yes.
Okay. Um, well, I guess we've already looked at several of those topics, which is that at least the 2015, the most recent Part 12D report, it did not raise any concerns about the stability of the embankments, did it?
Not directly, no.
And it didn't say that the dam was subject to liquefaction failure, did it?
Not under a seismic load.
Yeah. And the Spicer Group also, they did not conclude that the dam showed signs of instability, right?
No, they did not.
Did you see, well, you didn't see any report prepared by any of these engineers over the years that concluded that the left embankment of the Edenville Dam did not provide adequate factors of safety, did you?
The 2010, I believe it was, geotechnical report did address embankment instability.
Why don't you open that up and show us what you're referring to?
That's not possible.
Isn't that included in the
It-
documents that you reviewed?
It is, but I would need to go back and review it in detail.
You can't tell us just looking at it?
I do remember seeing that there was stability issues and that those soils were not compacted very well. They were loose soils, especially on that left side.
Did that 2010 report conclude that the left embankment did not provide sufficient factors of safety?
For the normal pool condition and the drawdown that they tested, that is what they concluded, that it provided adequate factors of safety.
Right. So a normal pool condition, it provided adequate factors of safety, right?
That's true.
And then ultimately, the 2015 report concluded that the dam was suitable for continued safe and reliable operation, right?
Yeah, normal pool, yes.
You also reviewed this morning the report that Spicer provided to Eagle after the dam failed. Do you remember the one I'm referring to?
Yes,
Did that report recommend lowering the normal level of Wixom Lake?
it did not recommend lowering the normal level.
Um, let's pull that report up. It's volume 4. Volume 4 of the plaintiff's binder, and it's tab 1 in volume 4. Are you with me, Mr. Sturdivant?
Yes, sir.
So if you go ahead to page 4 of that report where it lists the different dam conditions, you see that?
I do.
And it ultimately concluded that the dam was in poor shape, right?
Pardon me?
Didn't this report ultimately conclude that the dam was in poor condition?
I believe it said fair to poor.
Okay,
Fair.
fair enough. If you look in the middle of that page, of page 4, it describes the condition for unsatisfactory. Do you see that?
Yes.
That's the only condition in which reservoir restrictions may be necessary until problem resolution. Do you see that?
It is specifically labeled there,
Yeah, none of those other conditions specifically mention reservoir restrictions, do they?
not specifically.
Okay. Your Honor,
Yes.
if I may, I'd like to take a quick break and talk to co-counsel. I might be pretty much done until potential recross if needed.
I think there's going to be an opportunity for recross, but
Fair enough. Is it okay if we take like a few minute break?
yeah, yes, we'll, 3 minutes, we'll be reconvene at 2:50 or 4:15.
4:15?
Enough time?
Yep. Thank you.
Thank you. Stay in the courtroom or? maybe people are like, God, you're so uptight about time, right? I'm like, well, in my first job after law school, if you were late for work, it was a federal crime. So, it's like, I didn't like to do that. Anyway. Counsel?
Your Honor, for the purposes of this hearing, which is us challenging 5 specific opinions offered by Mr. Sturdivant, we don't have any further questions for those.
Okay. Thank you. Solomon Road.
Read it right. And may I do it from here?
You may.
Can we get that low enough for me? Fix me. A little vertically challenged here.
I mean, Gamble's like, 6'7" or something.
Maybe in the future, we could have a lower microphone. It would.
I'll get right on that, Council.
Doesn't it fall under
Happy
ADA?
that we have remote microphones. I think we have made such progress since we all began this journey together of making this an actual trial courtroom. So anyway, I'm so grateful, and our IT people I know are monitoring us from an undisclosed location. And I'm very grateful to our IT folks. So.
Well, we appreciate the IT people too.
And I do, in all seriousness, I appreciate that the lawyers, took efforts to communicate with the IT people, find out what's the rules of the road, how are we going to do this? One of my colleagues had a trial in July, and here in this courtroom, that was, I think, the first full trial here. And we've been trying to, get it a little better each time. So by the time, if we go to trial in January, I mean, we're going to be pros at this. Anyway.
Mr. Sturdivant, having been shown a variety of selective emails and documents by defense counsel, did any of those documents cause you to conclude that your methodology that you used in reviewing this dam failure was flawed or incomplete?
No,
Did anything you saw cause you to question your prior analysis?
no,
Did anything you saw cause you to change your opinions or prior testimony given here today?
no,
Do you still contend that the methodology, the analysis, and the opinions you reached in this case were reliable, credible, and helpful to the court and valid?
yes.
Thank you very much.
Okay. Thank you. Sturdivant, I do not have any questions for you at this time. You may step down. Thank you for being with us today. And
Thank you, Your Honor.
I understand you're from one of the Centennial States, Colorado now. So and hope you have safe journeys back home. So thank you. All right. Let me step down. All right. It's 20 minutes after 4. What do we want to do next?
Your Honor, Nate Gamble with the defendants. To be honest, my preference would be to just push through and do all the motion hearings. We're all here. So
I want to check with the 2 people who are arguing on our behalf. May I ask them?
Sure.
They're good with pushing forward.
All right. Let's, my Army friend said, let's put the pack on and do the march. Okay, I'm ready. Right, you're first.
may I?
Yeah, let me just, go over let council is going to cover it. I think they need to change some seats around here. So, and does anybody need to talk with Mr. Sturdivant before we, commence? Yeah, go ahead. All right, and everybody needs to stand up and stretch. Bit for today and.
We can say.
As far as I know, we have, yeah. Mr. Trudell, are you available to keep going?
Yeah, absolutely.
Thank you very much.
Yep.
Yes.
Rolling tables next time.
Yes, sir. Literally had the CFO for the court come over with Judge Yates and I and Dan and Elizabeth and some of the other lawyers. And it's like, okay, well, and we're sitting here in that chair, somebody's over there. When we first started, suffice to say, the seating was not as stable for the witnesses over there. It's like,
It's funny, I had not been up here, so I'm just seeing the little, the witness stand that you had set up.
Yeah.
I mean, it works.
So they're free to start without.
No, I'll stay forever.
I will. Yeah, thank you.
No, thank you.
Is there a walk?
That's on there. That's on there.
Oh, there you go.
Elizabeth abandoned us?
It's like the.
Yeah, it's weird. Being in here for the Court of Appeals, yeah.
Yeah, it is weird. Yeah. Here and. Yeah. I don't know, well, did you times I'm looking and then it's over. Yeah. Yeah.
All right, thank you. Okay. Before we go into oral arguments, I just want to, the exam of the witness we just completed, by both sides was very helpful to the court. So thank you both. I thought it was, very informative. And while voluminous, the manner in which the exhibits were organized by both parties, once I figured out where the people, the defendant's binder was also very helpful. So I appreciate that very much. I know that the preparation of the exhibits is a Herculean effort, and I very much appreciate it. It's I can't emphasize how much assistance that provided to the court and will continue to provide. I now have a rolling, I don't know, not the old guy in the law firm, the old partners would always have the rolling, little bookshelf. Well, I'm that guy now. And so the top shelf starts with the complaint, and every month has your pleadings in it. And so that's from the top, and now I have lots of binders for the bottom of the shelf, and it's immediately to the right of my desk in chambers, so I get to look at it every day, read it often. But your organization and work in all seriousness is very much appreciated. So thank you. All right, Mr. Gamble, you, in the order that I issued back on August 15th, I said immediately following the hearing, counsel will be prepared to present oral argument on the Mr. Sturtevant as a witness issue, and each side's allowed not more than 20 minutes. I then indicate that we'll take a 30-minute recess and go into the C10. I don't have any intention of taking a 30-minute recess after we're done talking about the witness. But if either side feel it's necessary, I'm happy to listen. I'm not saying I will agree to it, but I will definitely consider if people feel like hey, we do need a recess after that. I will tell you right up front, I do not plan on ruling from the bench on either of these issues. So when you're done arguing and we are done sort of closing up our business affairs for the day, then we're done. We're not listening to me drone on and on for, you know, whatever amount of time I've made you listen previously. I'll take the matters under advisement on both of them, but that's sort of my view of where we're at on this. Okay? Mr. Campbell, without further ado, and you can come to the podium for this one. So just like in regular court.
Thank you, Your Honor.
Thank you.
So I don't know that I'll need all 20 minutes.
And I said that, I frankly don't think either of you probably need it, but
Probably not.
you have it if you would like.
Thank you. And I would like to reserve some rebuttal time though.
Fine.
Um,
Couple minutes.
yes, at
Fine.
least, yeah, I'll set a timer if needed. So,
I got a run clock. That's one thing when you're a PJ in the Court of Appeals, you do learn how to figure out how to keep track of 30 minutes and subtract from 30. So, and
well, Your Honor, we've already had some motion, or excuse me, a hearing on this motion. I appreciate the opportunity for this evidentiary hearing. And honestly, as I sat through this hearing for the past several hours, I feel like the plaintiffs and the defendants presented, or at least were presenting, two completely different objectives. It seemed to me that the plaintiffs were focused on demonstrating that Mr. Sturdivant, generally speaking, is a qualified dam safety engineer, has experience in the field, et cetera, and really did not spend any time specifically addressing any of the 5 specific opinions that we identified in our brief. Whereas from our perspective, we're not challenging that Mr. Sturdivant's a dam safety engineer with many years of experience. We're not suggesting that he can't testify generally about dam safety. That's not our argument. Our argument is instead has identified 5 very specific opinions that he has offered. And the court rule, or excuse me, the rule of evidence requires that for each of those opinions, it has to be based on sufficient facts. It has to be the product of reliable principles and methods. And then the plaintiffs third have to show that that opinion reflects a reliable application of those principles and methods to those facts of the case. So for each of those 5 opinions, it's a 3-step at least analysis. And the plaintiffs have not met their burden here. Really what it comes down to is at least, so let's go to the first opinion, which is that the Eagle and DNR had operational control of this dam. Mr. Sturdivant didn't identify any facts at all to support his conclusion that the people who were actually operating the dam somehow answered to Eagle or DNR. They didn't. They answered to Boise Hydro. Boise Hydro operated this
provide
dam.
testimony that said he felt that they had the ability to control. Is that of any moment?
It's not, Your Honor, because that's ultimately this court's analysis. Because what he's saying is that simply by virtue of dam safety regulation, Eagle can operationally control any dam in the state. But that's just factually incorrect. It's legally incorrect. In terms of his testimony, it doesn't help the court at all. He's not offering the court anything helpful there because that's ultimately the court's legal analysis. There's no question Eagle had dam safety jurisdiction. No one's challenging that fact. That fact doesn't mean that Eagle operationally controlled this dam. All the evidence showed that the people who operated the dam didn't answer to Eagle. They answered to Boise Hydro. And Boise Hydro, actually, according to the evidence we reviewed today, answered to the Four Lakes Task Force. Plaintiffs have offered no evidence at all that Eagle, as a factual matter, or DNR operationally controlled this dam. And a good contrast here, Your Honor, would be the emergency manager in Flint, because the plaintiffs have relied heavily on the Flint case. So in that case, a state employee actually did control Flint's water system because it was an emergency manager who reported to a state agency, came in, displaced the local, that's what the Court of Appeals and Supreme Court concluded, and displaced the local authorities, so the state employee is in charge now. So that's an example for, just as an example, to contrast it with the scenario here. Eagle and DNR didn't come in and push out Lee Mueller and his dam operators and start operating this dam, which is similar to what happened in the Flint water situation. So it's just different. And they didn't identify, the plaintiffs didn't identify what principle or method that Mr. Sturdivant relied on based on the facts of this case, or show that that opinion reflects a reliable application of those principle and methods to the facts. They just haven't met their burden as to the first opinion. And then if we go to the second opinion, they encounter the same shortcomings the plaintiffs do, which is that Mr. Sturdivant is essentially being offered as a fact witness, as someone to tell the court, yes, Eagle and DNR forced, that's his opinion, forced the dam operators to maintain the normal level of Wixom Lake. Well, he hasn't identified any facts showing that. All the facts in this case actually show that the Four Lakes Task Force entered into a contractual relationship with Boyce Hydro, and Boyce Hydro remarked at least twice in these exhibits we reviewed that they were answering to the Four Lakes Task Force's direction, which is not Eagle or DNR. And the plaintiffs haven't identified any facts showing that the Eagle or DNR forced Boyce Hydro to maintain the normal level of Wixom Lake in the spring of 2020. And that's only the first two steps of the analysis. They still have to show that that opinion is based on reliable principles and methods, and then that the opinion reflects a reliable application of those principles to the facts of the case. And they haven't done that. All the facts in this case show that neither Eagle nor DNR forced Boyce Hydro to do anything. It was Four Lakes Task Force and Boyce Hydro who agreed to maintain the normal level of Wixom Lake. There is no evidence that Mr. Sturdivant or the plaintiff's counsel could identify showing that the defendants here compelled them to do that. And going to the third opinion, Your Honor, this to me is even easier than the others. He's claiming that Eagle and DNR concealed information from the public. That Eagle and DNR concealed the dam's hazard rating from the public. No, they did not. There's no facts anywhere showing that. He couldn't identify any communication or any method that Eagle and DNR apparently used to try and keep the public from finding out about the hazard rating of the Edenville Dam. That was all public information. It wasn't secret. Contrary to Mr. Sturdivant's recollection, the FERC safety orders that were issued were very public and publicly available. That's why the news talked about them, and it was a big deal. And so, and same with the Part 307 report that the Spicer Group prepared. That was all very public, circulated among the plaintiffs and all those folks in that area, identifying the hazard rating of the dam. So again, no facts support his opinion that Eagle somehow concealed this public information. Same for the spillway capacity. He says Eagle and DNR concealed the lack of spillway capacity. Well, the only exchange on record that any of us can find where Eagle and DNR, or excuse me, Eagle is conversing with a member of the public about the spillway capacity shows the literal opposite of what Mr. Sturdivant is opining. It shows that Eagle was very candidly answering this man's questions. This man who said he lived on Wixom Lake, he said the Four Lakes Task Force is telling us the dam needs to increase its spillway capacity, and that's why we have to pay all this money, and we don't want to, and so Eagle confirmed, yeah, it lacks spillway capacity. So this is not hidden. So there's just no facts to support this opinion for Mr. Sturdivant. It's just him kind of supposing that that's what happened. And so if we move to the third opinion that he offered, his fourth opinion is that the engineering reports up to the date of the dam failure had somehow given Eagle and DNR knowledge that the dam was going to fail if the normal level of the lake were maintained. And he really focused on the lack of spillway capacity. Well, really, when we look at the reports, everyone, all of these engineers for 30 years almost recognized the lack of spillway capacity. All of them did. None of them recommended, as Mr. Sturdivant acknowledged, that the normal level should be modified in any way. In fact, the latest Part 12D report, which Mr. Sturdivant repeatedly described as being highly valuable, really thorough, these Part 12T reports, it concluded that the dam could continue operating in a safe and reliable way. It didn't recommend modifying the normal level of the lake at all. So the plaintiff's counsel has really tried to emphasize the fact that the dam lacks spillway capacity. But as the evidence shows, Eagle knew this. This wasn't some secret. This was very openly considered and shared with the public.
Any moment that when we look at, and I don't think it was during your exam, but you see these photographs pre-May 19th, 2020, that show the left and the right embankments, and then the discussion of the witness proffered by the plaintiffs. I mean, is it so apparent that the grade of the left embankment is so steep that you've got a real serious risk?
No, that's what a stability analysis is meant to find out. So, and we mentioned that several times, and Mr. Sturdivant testified about a stability analysis where an engineer analyzes whether an embankment, because of its construction methods or because of its steepness or whatever, presents a danger to the public. And that's where the factors of safety language comes from. So factors of safety is when you do a stability analysis to determine if there are enough factors of safety based on the embankment's condition. And he acknowledged that no engineering report had ever concluded that the dam's steepness meant that it did not have enough factors of safety. So, I mean, it's really kind of surprising that he thinks that he can diagnose this problem by looking at kind of a grainy picture when all of these engineers over the years had already done this analysis, and he recognized that they concluded that they didn't identify any embankment stability problems because of this steepness of the embankment. It's just not in there. So when Eagle inherits this dam for the first time, they're getting reports that are telling them there are no embankment stability problems here.
Should the fact that FERC withdrew the federal license, should that have been like a flare going off in the middle of a dark, dark night to put the agency on alert that we have a real serious problem here?
Yes. And that's why the agency kicked into gear. And that,
Right, but we have some emails somewhere, and we were all struggling with the literally thousands of pages. And that's, I mean, in a good way. I mean, you brought a lot of evidence to court today. Both sides did. But there is an email somewhere shortly after the license by the federal regulators is withdrawn. It's my recollection anyway, that the owner says, we need to meet about, dam safety, dam regulation.
yes. And they did. And so it's helpful to understand that email if we track the dates. And so the license revocation was September 25th, 2018. Mr. Mueller sent the email you referred to on October 3rd, 2018, asking for a meeting to talk about the dam. And October 4th, Eagle engineers showed up at the dam in person the next day to go and look at this. And they asked for the exact same information that Mr. Sturdivant said that he requested from the plaintiff's counsel. They said, all right, show us the latest Part 12D reports, show us the STID, show us the condition of the dam, or excuse me, the reports analyzing the condition of the dam. I mean, you've raised this red flag essentially, Lee Mueller. So we're here. Show us what you have. And those are the reports that said this dam could continue safe, reliable operation, no recommendation to lower the water level, didn't raise any concerns about the embankment stability, didn't say that any of these embankments lack sufficient factors of safety. So, and Eagle went through still and confirmed the information that they were receiving from the plaintiffs, from Mr. Mueller and Boyce Hydro, and ultimately worked hand in hand with the Four Lakes Task Force to get a plan in place as soon as possible to get the spillway capacity increased. And, Mr. Fusco testified, as we note in our briefing, that the State agency was making way more progress than the federal agency ever had. And that's because you really had the Four Lakes Task Force who was organizing, getting funding, and really moving it forward in a way that the dam owner wasn't. So this idea from the plaintiff's counsel that Eagle somehow neglected or ignored the seriousness of the situation, it just isn't borne out by the facts of the case. And this takes us to the fifth opinion, Your Honor, which is that goes to the topic we were just discussing, which Mr. Sturdivant was saying. Well, the fourth opinion was that the lack of spillway capacity gave the Eagle and DNR knowledge that the dam was going to fail. Then the fifth opinion is that the soil stability of the embankments gave the DNR knowledge and Eagle knowledge that the dam was going to fail. But again, I don't need to repeat what I just said, but none of the engineering reports reached that conclusion. None of them raised any problems with the embankment stability. So really what it comes down to is it's not whether Mr. Sturdivant is a dam safety engineer who can talk about dam safety in general. The question is, for each of these five opinions, do the plaintiffs meet their burden to walk through the analysis required by MRE 702? And they do not, Your Honor. So none of these opinions should be admissible. And I'll reserve the remainder of my time.
Hold on, Jim's finish up. Yes. Good.
Good afternoon, Your Honor. Christopher Desmond from Venn Johnson Law on behalf of the plaintiffs. Specifically, Your Honor, I represent the mass plaintiffs, but obviously we're arguing this collectively today. Your Honor, I'm glad that there's an acknowledgement from defense counsel that this isn't about Mr. Sturdivant's general qualifications and his ability to testify. I think he has overwhelmingly demonstrated today that he is as qualified of an individual as a trier of fact could hope for in a complicated case like this. This is an individual who's been trusted by the state of Wisconsin for more than 3 decades with their dam safety program. He's been consulted by states throughout this country, from our federal government. This is an individual who is deeply respected by people who do this kind of work, and I think we can see why. Now, I do disagree, though, with defense counsel when he says that we didn't focus on the 5 opinions. And to be clear, those 5 opinions that we're discussing, it's not as if Mr. Sturdivant has authored a report where he says this is opinion 1, this is 2, this is 3, and those are the opinions that are at issue today. These 5 opinions are things that this court identified in its opinion denying summary disposition as 5 general things that Mr. Sturdivant thinks that were relevant to this court. I think we went through all of those opinions with Mr. Sturdivant, but really what we started by doing at the very beginning, what Ms. Almanroth started with doing was focusing on methodology, which I think is extremely important anytime you're dealing with Daubert. And looking right at that very first issue, operational control, one of the very first things that Mr. Sturdivant told us today was that he started by reviewing Part 315. He explained how when he was in Wisconsin, one of the things that he had to do was employ, and he talked about how, we're hesitant as dam regulators to employ that ultimate power of being able to come in and take control. But I looked at Michigan's statutory structure, I compared it to what I dealt with in Wisconsin, and they're essentially the same. We have the same tools.
He testified, I believe, that under Wisconsin law, the dam regulators have the authority to orally tell an operator, stop, then you go to then get the formal written submission and then go into whatever process. Is that?
No, that's correct. You're right.
Is that allowed to happen in Michigan?
No, Your Honor, the process
That would not be my understanding.
Right.
I'm just,
and it's
I'm a mouth breathing trial judge, so I don't know all of the ins and outs.
No,
know it better, but
it's not my understanding that process, that oral process, that verbal process works identically between the 2 states. But what Mr. Sturdivant focused on was MCL 324.31519, which is the overarching authority that allows the state to step in the interest of property, human safety, life, when there's a dam that poses a high hazard potential to people.
But doesn't, if a individual or a group of individuals is seeking to show an adverse taking, so by, the common law equivalent of a condemnation proceeding, really, in some ways. And I know, dear friends on the appellate courts, I'm not applying that standard to my review here, but it's sort of when I start thinking about it, is that the fact that a regulatory agency, whether it's the dam safety supervisor for the state of Michigan or the Department of Agriculture or whatever agency that has a regulatory health and human safety function provided in the statutes, does that automatically then mean whenever the agency hasn't acted, then there is either, you fill in the blank. If it's a hospital, maybe a tort. If it's a property issue, it's a taking. Is that what we're saying?
No, I don't think it is, Your Honor. And respectfully, I will say that we are butting a little bit into what we're going to be doing with summary disposition. There's a little bit of an overlap in the issues, and I know Mr. Carlson will be speaking.
I think all of us, probably are in the wrong line of work.
Right, but Mr. Carlson will be speaking more specifically to the summary disposition status, but no, there's case law from the Michigan Court of Appeals, and this is referenced in the Court of Appeals opinion in this case. There's case law from the Michigan Court of Appeals saying simply having regulatory authority and having the ability to issue or not issue a permit, that's not enough. Right. So that's not our position here. Our position here, and I think this is what the Court of Appeals was acknowledging, and this was true in Mays as well. When you have informed decision-making that's going on at the permit stage, when you have a very deliberative process where it's not simply someone sends in a form to someone and they rubber stamp it and they say, yeah, you're allowed to pull a permit to put in a new driveway. When we're talking about something like here, where we have FERC involved, we have FERC, by the way, because this is where I think that statutory language is so interesting when it talks about a threat to human safety or property. That's the exact language that FERC invokes when they get rid of the license in 2018. And when they revoke that license in 2018, they say repairs are urgently needed because of the lack of spillway capacity here if we want to avoid risks to public safety, health, property. And so here, where you have state actors that are making those sort of informed decisions, and Mr. Trumbull, by the way, and again, this is sort of SD territory, but Mr. Trumbull testified that throughout this process, this was a joint conversation between Boyce, Four Lakes Task Force, and the defendants in this case, Eagle in particular. And so we know that there's active communication going on between these parties. We know it by virtue of the fact, I mean, you look in December of 2019 when the state issues the notice of an enforcement action relative to Boyce. And so they are absolutely, prior to the events in May of 2020, flexing sort of their regulatory muscle relative to Boyce. And so I think when we look at the Court of Appeals language and when they're talking about some of the previous cases, like there's one, the Hinosa case, I think was one dealing with a permit, they say the allegations in this case are very different than that. And I think the facts have only bore that out to be true, Your Honor. And so I think what Mr. Sturdivant was doing when it comes to operational control is explaining that, look, I was a regulator for 32 years that had this same ultimate authority that the state of Michigan and the defendants had here. And I know that looking at what I'm looking at and what I've seen, they had an absolute obligation under the statute because the statute says that they shall. And Mr. Sturdivant was asked at one point, well, are you saying that anybody who the state has some regulatory authority over, the state is in operational control of every single dam? And he said, no, they're not. But with this particular dam, because of those criteria from the statute that are factually present here, they were in operational control of this dam. Now, the fact that they gave up that operational control, well, actually, they didn't give it up. They exercised it by when they issue the permit to raise the water level to the spring levels. When they issue that permit out, and they bake language right in there saying to Mr. Mueller and Boyce, you're not allowed to lower this level again in the future. They essentially make them a part of the 307 order that Four Lakes Task Force was subject to, but that Boyce wasn't. They do that through that permit language. And so they're taking steps in this case to impose their control differently, I think, than they do in those other cases, Your Honor. Now, Your Honor, it also, and relevant to operational control, because this brings in the concealment factor that I think is very important. It was kind of fascinating to listen to all the emails where, it's, well, did Mr. Mueller say in this email that he's raising it because of the state, or was he referencing riparian owners on the land that want to have the lake levels higher? Well, remember, we're talking about concealment here. And so what we have, the state's saying there was no concealment. We know that in October of 2018, when Luke Trumbull goes out and does his initial visual inspection, he comes back and says it's in fair condition. The dam's in fair condition. This isn't about FERC. If FERC put out a public document that said we don't think the dam is in fair condition, they're not our defendant here. The state of Michigan is. And the state of Michigan was telling people this dam is in fair condition. So the fact that you have certain riparian owners, and by the way, we have thousands of property owners involved in this case. So these little one-offs of this person sent an email to the state and the state told that one individual person the truth, I don't think that does much to move the needle in general. But the fact that we have.
You don't think that multi-bullet pointed response of A, B, C, D, E, F, G, here's what we're doing, that doesn't move the needle?
I don't think it does away with concealment as being present in this case, Your Honor. We have one person who wrote to.
We have an example of the state affirmatively withholding information and or intentionally communicating false information.
No, I wouldn't say I have evidence of them intentionally communicating false information. What I would say, there are ways to communicate that don't necessarily require explicit language, right? We kind of had an acknowledgement of that in this courtroom earlier today. You don't have to directly say something to someone to say something to someone.
Right.
When
I'm speaking from the bench about the conduct of counsel, I am not adversely taking the property of another citizen or resident of the state of Michigan.
Got you, Your Honor. I understand.
So the court exercises its responsibilities as the court believes it's required to under the statutes and the Constitution and judicial canons. What we're talking about is a constitutional deprivation of property rights.
Right, Your Honor. And when we look at what the Court of Appeals said, the Court of Appeals said that it had to be authorized. We need to show evidence like in Flint that it was authorized, right? And we certainly have evidence here that it was. But when it comes to this issue of concealment, when you have the state of Michigan participating in Part 307 proceedings and not standing up and saying, you know what, FERC has declared that they needed to revoke this license because this dam represents a threat to people until the spillway is taken care of. We need to support them in keeping these water levels lowered so that we can improve those spillways. Or quite frankly, if Boyce is getting up here and saying we're not going to improve the spillways, we as the state of Michigan have a statutory obligation that's been imposed on us by our legislature that says we shall use our regulatory authority to make sure that this dam is safe for the public and for our property in this state. And so when you have the state participating in those court proceedings, when you have the court issuing enforcement actions, when you have the court saying that if you lower these levels again, we're going to sue you for damages that are caused, what that's implying to every single person that's listening to that is it's safe to have this water level high. This dam is safe with the current spillway and the current composition of this dam. It's safe as is for the state of Michigan. We don't need to change anything. What Mr. Sturdivant's saying is that's not true, Your Honor. They had an obligation to tell people the truth. This spillway needs to be repaired, and until it's repaired, it's putting undue pressure on the embankments of the dam that causes risks of stability failures that will be catastrophic should it occur. And so I think when it comes to concealment between both the words of Mr. Trumbull and, I think to go back to discuss the facts a little bit, because I think this got glossed over a little bit. Your Honor, you had raised the idea of, well, wasn't there an email from Mueller at one point shortly after the revocation saying to the state, I need you to come take a look at this?
Right. I just asked that and Mr.
He gave it,
replied, the emails, the license is revoked on September 25th. The emails October 3rd, and this is in 2018. And on October 4th, 2018, the state employees show up.
so I don't have the direct dates in front of me, but my recollection from the timeline that I have together is that Mr. Mueller, and this will certainly be borne out by the papers, Your Honor. Mr. Mueller initially contacts the state and says, I need you to come out here right away. And the state says, we can't do that. They say, the engineers say, you need to discuss with the Attorney General's office because there's litigation that has been in place involving this dam. We're not allowed to come out there. We're not going to come take a look at it. They eventually do it. And I thought it was.
Is that email in the materials that you provided to me today?
I believe it is, Your Honor, but I apologize. I'm not 100% certain that it was. If it's not, then yeah, I apologize, Your Honor. But those initial contacts I thought occurred in September of 2018 from Mueller to the state. And then the inspection does occur in October, as defense counsel stated. But again, that's the visual inspection that they come away from saying that this dam is in fair condition, which Mr. Sturdivant has simply said is not true. When it comes to the other issues, Your Honor, because I'll try to be quick, but when it comes to the other issues in terms of the embankment stability and maintaining dangerous water levels, these things are related to one another and they go hand in hand. You might not see documents from FERC that are saying that the water level has to be lowered, but there's a reason why Mr. Sturdivant said that doesn't change my opinion about any of this, because what those documents do say is that the spillway capacity has to be increased. Well, the reason why the spillway capacity has to be increased is because they recognize we can't get water out of this dam fast enough. We can't get it out of the reservoir, out of the lake fast enough. And when you can't get water out fast enough, what Mr. Sturdivant has explained here today and previously in his deposition is that that increases pressure on the embankment. And that is what most likely causes stability failures. When we talk about the probable failure methods, right? That was the primary one that was identified. Roman numeral 1 was about embankment failure. And so when we're talking about spillway, we're also talking about embankment because these things are linked to one another. But going to the embankment, Your Honor, what Mr. Sturdivant also explained is that you could look at the left side of the embankment. You could visually look at the left side of the embankment. A report might not call it out, but you can look at it. You can see that it's shaped differently. It's steeper than it is on the right side of the embankment. You can see that there's not a berm there. You can see that there are piezometers that aren't in the places where they're supposed to be. So visually, someone with his level of experience can look at this dam and he can make certain assessments that, yeah, it might not be present in some of the documents. But all that means is those witnesses might disagree with Mr. Sturdivant. Or maybe, Your Honor, if those same witnesses who authored those documents that didn't mention anything about lowering the lake level, if they were sitting in that chair today subject to cross-examination, they might have said, yeah, you know what? Sturdivant's right. It should have said something about lowering the lake level. It didn't.
Did you call them in discovery?
No, Your Honor,
None.
we didn't. Your Honor, I can't speak to what.
So we're speculating about someone who's not endorsed as a witness who hasn't been deposed would say.
Well, I think.
Is that accurate or?
No, Your Honor, I don't think it is. I'm not attempting to speculate about what they would say. But what I am saying, I'm not.
Okay, it's been a long day.
Your Honor,
I apologize if I'm not.
No, and I apologize if it's coming across that way because I'm not attempting to say we should guess as to what these people are going to say. But what I am saying is the fact that a witness may disagree with Mr. Sturdivant eventually. That's not the standard by which we describe admissibility and adjudicate admissibility. Mr. Sturdivant is a highly experienced expert who came in here talking about the fact that I reviewed all of these documents. Mr. Gamble's showing him emails saying, did you see this email? Did you see this report? Almost across the board, the response was yes. Yes, I did see that. Yes, I did review that. And then at the end, he tells us, none of my opinions in this case have changed. I thought I had all of the information that I needed to make the assessment. I made the assessment that I made. That assessment hasn't changed. It didn't change based on today, and it didn't change based on Mr. Trumbull's report, which Mr. Sturtevant did his own response to. And so, Your Honor, I think that this is a situation where we have, I don't even know if I want to say it's a classic battle of the experts, because I don't know that there's necessarily an expert that can battle with Mr. Sturtevant. But it's certainly a situation where Mr. Sturtevant will be present for the trier of fact. You can ask him whatever questions you like. And should you conclude when those other witnesses are present in the courtroom, you know what, I think that they're more credible or they're more helpful or what they're saying makes more sense to me, then certainly that's obviously within the purview of this court in a bench trial and the trier of fact in any trial. But I don't think it assists this court to say, we're not going to let Mr. Sturtevant talk about those things. If he talks about them and isn't persuasive, that's a different subject. But I didn't hear anything occur today where Mr. Sturtevant demonstrated himself to not be prepared to discuss these issues with this court or not be able to say what his opinion was formed off of. You know, the very first argument in this motion, and I know we talked about this last time and it hasn't been the focus today, but the very first argument in this motion is that this was a report that was essentially authored by plaintiff's counsel and that Mr. Sturtevant doesn't even know these things to be true. Well, that's not true. He sat up here today saying, I'm the one who looked at all of this. I'm the one who reviewed all of this. I'm the one who formulated these opinions, Your Honor. And so we stand by that testimony from Mr. Sturtevant today. I think he demonstrated himself to be someone who will be assistive to the trier of fact, which is ultimately what MRE 702 is focused on.
All right. Thank you.
Thank you very much.
You're welcome. Thank you. Mr. Campbell, any brief rebuttal?
Yes, briefly, Your Honor. First, just a comment about the broad theme of the plaintiff's case. They recognize that the dam has never had sufficient spillway capacity from the time it was first built, yet it's always been maintained at its normal level for over 90 years. And when the Four Lakes Task Force came in and sought a Part 307 order, all they wanted to do was to continue the status quo. And now what the plaintiffs are saying is that even though no engineer ever warned that continuing the status quo was dangerous, Eagle and DNR constitutionally took the plaintiff's property by not proactively stepping in and keeping the counties from maintaining the status quo. That's their argument. And to the specific issue that's actually before the court for this motion, you know, one judge I've practiced a lot in front of calls it the legal schmiegel, the details of the court rules. And if we look at the Michigan rules of evidence,
That a judge's school.
but she would always press the attorneys to get into the weeds on the legal schmiegel. So the language of Michigan Rule of Evidence 702 requires a multi-step analysis for each of these opinions, and the plaintiffs cannot satisfy that multi-step analysis. They have not shown that Mr. Sturtevant's opinion as to each of these 5 opinions, testimony as to each of these 5 opinions, checks those boxes. They haven't met their burden here. And so they've resorted to, you know, raising alternative ideas and issues that are unrelated to the motion that's immediately before the court. And what they've ultimately done is they've fallen into the trap that the Michigan Supreme Court identified in the Edry case, which we cite in our brief, which is that the attorneys in the Edry case, they just emphasized how experienced their expert was. Therefore, any opinion that that expert offered satisfied MRE 702. And then
You're cutting it. It's a thin cut. We've been here together now since 8:30 this morning. An hour recess for lunch and 2 15-minute recesses. So for the better part of 7 hours. And for 6 of those hours, we had the benefit of the testimony of the gentleman from Colorado, as they say on the floor of the Senate or the House. And the gentleman from Colorado, formerly of Wisconsin, he went in some detail about why he reached the conclusions and opinions that he did. Those opinions may be, as as sound as the pound, as they used to say. And now I guess you can say it again since Brexit, but they may be the clearness of a clarion bell, or they may be of little value or unpersuasive. But isn't it a fact question ultimately? Haven't they met the threshold to at least get to the stage where we have the capacity for the full development of the record, full development of testimony? Under 702, as you say, it's a three-part test. The expert scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. B, so that's 1. 2, testimony is based on sufficient facts or data. 3, testimony is a product of reliable principles and methods. I know you disagree with 2 and 3, but isn't that a factual issue on the record that's before me now?
It's not, Your Honor. And so this is.
Minute, you got 60 seconds to give me the highlights on why you don't think it is.
This is not a battle of the experts. This isn't just two experts disagreeing, nor is this just about the weight of the evidence, or excuse me, the weight that the court gives the evidence that the plaintiffs are offering. Instead, there's a gatekeeping function that the court has, which the court doesn't need me to recite, which is that
Thank you.
if expert testimony doesn't, as an initial matter, satisfy MRE 702, it doesn't come in at all. And
Okay.
that's the briefing that we have provided for the court, and multiple Supreme Court opinions have reached that conclusion.
All right, sir.
Right. Thank
Give
you.
you a little more on rebuttal than you had on the clock, but it's an important issue, and I appreciate both very fine lawyers who just advocated on behalf of these positions. That I appreciate it. So thank you. All right, that matter is submitted. Do we want to turn to the next matter on the docket? I think it's the remains of the SD, or do you want to submit it on briefs?
Your Honor, this is Nate Gamble for the defendants. I think the court would benefit from a short hearing on the motion for summary disposition. So we would like to argue it.
All right, how much time do you want? And the reason I'm asking is I just want to know whether we should take a short recess or whether we should press on.
Maybe a 5-minute recess if that's appropriate.
And then, all right, how much time are you going to want on the clock when you start?
I think 20 minutes again would be appropriate.
Who's got it for this side of the V?
Yeah, Your Honor, Kevin Carlson for plaintiffs.
20 work for you.
That's what I didn't prepare the full set list. I was just gonna play the hits tonight.
All right, I love the hits.
20 minutes, will be 20 minutes.
20 is good. Okay, I have some family things going on this week. I need to do a couple of phone calls and texts, so we're going to take a 10-minute recess. We'll reconvene at 20 minutes after 5.
Okay.
Thank you. Court's in recess. And everybody's welcome to stay. We just come back and there are 2 lawyers in the courtroom. I'm not going to have my feelings hurt, so. All right. My recollection is this is your motion, Mr. Gamble, which means you have the burden of proof, which means you get to go first. You set my magic chronometer here. I don't know what we all did before these ridiculous phones, but. Okay, ready when you are.
Thank you, Your Honor, and I'll reserve time for rebuttal, and I don't expect to use full 20
Okay.
minutes, but Your Honor has the benefit of briefing on this. We've explained in some detail our positions on these various issues. The matter that I really think is important to keep the court's finger on is that the inverse condemnation action is different than other types of property damage disputes. This is not a tort claim, so it is not sufficient for the plaintiffs to create a genuine issue of fact about whether Eagle was negligent in the way it administered Part 315. That is not going to satisfy the inverse condemnation factors. It's a much higher standard. They have to show that Eagle and DNR took affirmative facts directly aimed at the plaintiff's property. That's what they need to demonstrate. And the Court of Appeals said if all the facts they allege are true, then they've hit those elements. And our briefing goes out, identifies each of the facts that the Court of Appeals focuses on, shows that now that discovery is over, plaintiffs cannot create a genuine issue as to any of those material facts. And the defendants did not force Boyce Hydro to return it to normal level. The defendants did not conceal information.
You agree that while the standard of the elements which must be proved is substantial, that at a C10 stage, which is what this is, the court still must take the facts in the light most favorable to the non-moving party with all reasonable inferences that are pertinent and attached thereto.
Yes, but the plaintiffs first have to at least identify facts, and they haven't done it. And so they don't, discovery is over, and they've deposed who they want to depose, and they haven't shown any facts even suggesting that Eagle or DNR forced Boyce Hydro to enter into a contractual relationship with the Four Lakes Task Force, or force Boyce Hydro to maintain the normal level of Wixom Lake. All of that was arranged with the Four Lakes Task Force, who paid them in exchange for that service. And the Four Lakes Task Force worked with the Spicer Group to advise them on that process. And the Spicer Group recommended continuing to maintain the status quo that had been in place for over 90 years, which is, yes, the dam lacks sufficient spillway capacity, and yes, the normal level of the lake should be maintained. In the meantime, they were working very swiftly to get a construction plan in place to actually increase the spillway capacity. And so the plaintiffs still have to identify facts that support the allegations that they've made in their complaint. And as we explain in our briefing, they haven't gotten that far with any of the key elements that the Court of Appeals relied on to allow their claim to proceed. And Your Honor, as I said,
The Court of Appeals, my valued colleagues, Judge Garrett, Judge O'Brien, can't remember who the third judge was on the panel. I haven't read the opinion as recently as the lawyers who are helping me have. But in the opinion, they talk about if the plaintiffs can prove that which is alleged, then they potentially have a claim, basically.
yes.
But they didn't say that's the only thing that they can use to prove. I mean, it's not if they don't hit all of their burden of proof on each of these things in the complaint, that the trial court, you should have dismissed the case. I mean, this was Judge Stevens, I think, ruling some years ago. But I mean, am I wrong on that? Or, how do you read that opinion?
The way I read that opinion is that the complaint is what tells us what facts we need to do discovery on and go through this whole process to talk about. And we've gone through that process, And it turns out that the plaintiffs don't actually have sufficient evidence to support those key allegations that the Court of Appeals relied on. I agree, Your Honor. The court didn't explicitly say if they can't prove these facts, the lower court must dismiss this case. That's not what they said. But they haven't shown enough facts to support the key allegations to push this into a constitutional level violation. There is no point here where Eagle and DNR looked at this dam and said, I know all these engineers told us not to do this, but we're going to do it anyway. The exact opposite occurred. Every engineer for decades who had looked at this dam, none of them recommended lowering the level of the reservoir. None of them. None of them said that the embankments were so steep or unstable that they didn't satisfy the factors of safety analysis or failed to.
If a trier of fact were convinced that on all of the evidence, the quality of the dam was poor, okay? If a finder of fact concluded that. And if a finder of fact were to conclude that one of the departments, I can't remember whether they're all agencies or departments, I think they're both departments, took steps directed to keeping the level higher than it safely should have been. Is that enough?
If there, and I don't mean to challenge your hypothetical, but
But when you get, if you ever seek to serve in the judiciary, you know, you'll remember this day about, oh yeah, I remember when I was a young lawyer and I said to that one crusty old judge who's now with the Lord. But anyway, I'm just, go
well,
ahead.
Your Honor, if there's an engineer that recommends against a plan of action and the government actor who's in charge of deciding whether this plan of action goes forward says, I'm going to do it anyway, even though I'm pretty sure it's going to cause property damage, that could suffice for satisfying, at least allowing a claim to proceed. That is not at all what happened here. And so in terms of the dam's condition, the letter that the Eagle wrote to the U.S. House of Representatives, which both parties analyzed with Mr. Sturdivant throughout the day today, they flatly recognized that, well, now that we have enough information to conclude that the dam lacks Michigan spillway capacity standards, we recognize that it's now in poor condition. But at the time that they first inherited this dam, the engineering reports on file said that it did satisfy Michigan's dam safety standards.
How can that be? If the FERC requirement was 60,000 cubic feet per second to be able to process that, I come from a very long line of engineers, as you've all heard me talk about for many sessions throughout the last nearly 2 years now, but I am not one. But even I can do the math on 60 divided by 2, and that equals 30. Yet the capacity to process the cubic feet per second, I think was either 26 or 28,000. How is something less than 50%, which one half of the cubic, and if I'm getting the acronym wrong, I apologize. But if the device can't process half of what the feds required and half is the Michigan standard, then how are our engineers and regulators not on actual notice that we had a real problem here? And the only testimony of record is FERC's withdrawing a license to a hydroelectric operator is very unusual. Haven't heard any numerical discussions of it. But how is that not enough to let the plaintiffs continue to pursue this claim?
Because, well, first, those are two questions, so I'll try to answer the first, Your Honor. So
I know you should be used to that. At least it's not a three-part question, Mr.
So
Kimball.
The first question is, why didn't the engineers just automatically know that this didn't satisfy Michigan's dam safety standards? And the answer to that is that it does require an engineering analysis. And the engineering analysis that D. Percupile provided in January 2019, so 3.5 months after the license was revoked, Boyce Hydro's engineer went through, looked at Michigan's dam safety standards and said, you know what? This dam already satisfies dam safety standards. And if you look at
Your position that the record shows Mr. Perkville, and I'm sure I'm not pronouncing his name correctly, and I'm sorry for that, but your position is post FERC withdraw of federal permitting, there is a licensed PE, professional engineer, that says they're good to go
Yes.
under Michigan standards.
Yes. Yep. That's in the briefing, Your Honor. So in January 2019, that's when D. Percupile reaches that conclusion. And that's why,
He also issued something earlier, didn't he?
yeah, excuse me. Yes, he was the Part 12D author of
In
the
2016.
2015, 2016.
15.
Yep. So he had been involved in this dam for many years. The FERC order revoking the license said that it currently has approximately 50% of the PMF capacity. It didn't have an exact number. So D. Percupile,
I see the 26 or the 28,000.
I'm not sure, Your Honor, off the top of my head.
You're saying I'm making up evidence.
No.
Is that what you're saying?
No, but I do want to put the court's finger on the fact that Boyce's licensed engineer said this satisfies Michigan's dam safety standards, and that was Boyce Hydro's position all the way. No, this was D. Percupile.
Oh, all right, sorry.
This was, and he maintained that in another letter with his seal of approval, literal seal, all the way up until March 2020. So they disagreed with Spicer. Spicer's engineers, Ron Hansen, Ted Champagne, they said, no, this doesn't satisfy Michigan's dam safety standards. Boyce Hydro's engineer said, oh yeah, it did. And so Eagle looked at it and ultimately sided with Spicer Group. But at the time, which is and they acknowledged this process in detail to the U.S. House of Representatives, where they said, well, when we first looked at this, we didn't have anything telling us that this didn't satisfy Michigan's dam safety standards. By the time we got through our analysis, we concluded that it did, and we recognized the dam should be classified as poor condition. I mean, they explained the process. There's nothing hidden about this. And the second point, it's important to make that just because a dam lacks sufficient spillway capacity, whether it's federal or state spillway capacity standards, as Mr. Sturdivant testified, there is no generally applicable guideline from any dam safety entity that directs that just because a dam lacks sufficient spillway capacity, you have to lower the reservoir. And none of the engineers who had ever looked at this thought so.
None of what? I'm sorry.
None of the engineers who had ever inspected the Edenville Dam reached that conclusion. FERC required that Boyce Hydro maintain the normal level, even though they knew it lacked sufficient spillway capacity, and not just by a little, by a lot. It didn't satisfy the federal standard wasn't even close to the federal standard. And they said, well, you still don't need to lower it. It's fine to maintain the normal level. And in fact, you have to. That's what a FERC license is. It's an enforceable order. And then it gets to the state, and the state says, well, it's questionable about whether it satisfies Michigan PMF standards. Ultimately, Eagle concluded that it did not. But the point is that just because it doesn't satisfy the spillway capacity standards doesn't mean that you have to lower the reservoir. No engineer has ever thought that, not Spicer Group, who was brought in specifically to advise on that issue. They bring him in after the license revocation, tell us, can we continue to maintain the normal level? They looked at the Part 12D reports, they looked at the information Boyce provided, and they said, yeah, you can. You can maintain the normal level. It's fine. In fact, we recommend you do that because we've been doing that for over 90 years. And the plaintiffs are saying that because Eagle didn't step in and affirmatively keep that from happening, that there's been a constitutional violation, and that's just not correct. And Your Honor, and one other nitpicky point, which is that Brother Counsel recently, he said that when Eagle eventually gave Boys Hydro, the permit that they applied for, that they and Spicer Group and Four Lakes Task Force asked for to return Wixom Lake to its normal level in the spring of 2020, said that permit mandated that Boys Hydro could never alter the lake level again. No, it did not. All it said was that in the future, if you want to modify the lake level, just get a permit. That's all you have to do. Just tell us. Didn't say that you can't do it. And that's true for everybody. That's just the law. You need to have permits to do work. And so I just want to impress upon the court that Eagle was not requiring them to maintain a normal level. The plaintiffs have not identified one iota of evidence showing that that was a mandate from Eagle or DNR. And I've gone 15 minutes, so I'd like to reserve the last 5. So, all right.
Okay.
Thank you.
Thank you, Mr. Yeah. Always helpful.
Thank you, Your Honor.
Yep.
All set. Kevin Carlson appearing on behalf of the plaintiffs. While opposing counsel was arguing the motion, I had the benefit of looking back in my notes. In 2018, when FERC revoked the license and the dam reverted to state authority, according to Eagle's dam inventory sheet dated October 18th, 2018, and this is Exhibit 1, or Exhibit Volume 1, page 542 from the original summary disposition briefing back in March and April.
552.
542, sorry.
No, I'm sure.
Quote, max spillway capacity includes 2,000 CFS through powerhouse. Spillway capacity of gate spillways only is 26,500 CFS, end quote. And so as the court noted, this is short of 1/2 PMF, which would be 30,000
I heard
CFS.
something today that even if 100% is 60,000, that the 50% standard may not be exactly 100% divided by 2.
Yeah.
Is there, I could have easily been confused.
I'm confused on that too, Your Honor. I'm not up to speed on that.
But did you hear
technical
something along
difference.
those lines?
I arrived at about 11 a.m. this morning. I
Oh.
think I missed that part of the testimony. Sorry, I can't be helpful
It probably
there.
didn't happen. I'm probably just imagining it. So,
Okay. In any event, the dam that these defendants inherited in 2018 was no longer the same dam that had been analyzed in 2010, 2011, or 2015. When FERC revoked the license for this dam to continue generating hydroelectric power, it wrote, quote, 13 years after acquiring the license, the licensee has still not increased spillway capacity, leaving the project in danger. The spillway capacity deficiencies must be remedied in order to protect life, limb, and property. And so
then they entered into a plan that we're going to replace the spillways. It's going to be a multi-year process.
right.
It's not something that you and I can go down to, Sun Rental and grab a couple of dozers and get done over the weekend. It's a complicated thing. So
Right.
if they know that's happening, which it was, right?
That's right.
How did the state constitutionally take this property?
Right, that's the ultimate, the question following trial is whether a finder of fact can conclude that the state caused damage to plaintiff's property when it authorized raising the water level in Wixom Lake, despite knowing that the Edenville Dam could not pass 1/2 PMF, because we have it's clearly established at this point that they knew before they granted the permit, before they authorized the raising of water level, that the dam could not meet 1/2 PMF.
What do you make of Mr. Gamble's argument that Judge FERC knew they couldn't do it and they had a standard of double what the state was, but they still said, go ahead and do it until they didn't.
Until they didn't, right, which was a huge red flag that FERC no longer believed this dam was appropriate for continued operation under its more permissive standard. The state standard is tighter. So
The federal standard
it has to pass more water, right, you're right. But also at that time, the turbines are operational,
They're only cycling through 2,000.
passing 2,000 more gallons of water or CFS of water. Right. Right. So the critical time frame here is not 2011, 2015, even January of 2019, all these things that my opposing counsel is talking about. And what surprises me, frankly, about the fact that they refiled a motion for summary disposition after fully briefing one is that the only thing that's changed procedurally in this case since the time the first motion was ruled upon is that we have the benefit of deposition transcripts from the three engineers who did work for the state of Michigan at the time, Mr. Fusco, Mr. Trumbull, and Mr. Rudolph wasn't an engineer, I don't believe, but he's the one who signed off on the permit. And so on February 4th of 2020, Mr. Trumbull writes an email reporting that the spillway capacity doesn't meet 1/2 PMF. Mr. Fusco testifies that that quote seems to be a definite answer about the spillway capacity not meeting the 1/2 PMF requirement. So Mr. Rudolph is asked in his deposition, why did you sign off on this permit if Eagle knew that the dam didn't meet the state's minimum safety standards? And Mr. Rudolph says two very damning things, I believe. One, I wasn't told. And two, if it were brought to my attention that there was a genuine concern about that the dam could not pass 1 PMF, then it, quote, should have prevented the permit from being issued. And then Mr. Trumbull admits in his deposition several places through pages and pages of, citing Hercules Poirot, consummate evasion, right? Consummate evasion on this question that my co-counsel asked him over and over and over again, effectively concedes that he did not tell Mr. Rudolph that this dam could not pass 1 PMF in the course of determining whether the permit should be granted. And again, Mr. Rudolph said, had I known that, it should have prevented the permit from being issued. And so if there's ever a question of fact as to whether the state's act of authorizing this increased water level was done despite knowing or in the face of knowledge that the dam didn't meet the state's bare minimum safety requirement, it's established through the testimony of those three witnesses.
Does it matter? You were here, I think, for the afternoon exam of the Crawford expert for the plaintiffs, correct?
Yes.
There was a series of questions from Mr. Gamble when he was having his conversation with the proposed witness that something, let me check the notes, sorry. It was in this colloquy between Mr. Gamble and Mr. Sturtevant about the May 1st, 2020 complaint.
Yeah.
Okay. And that before that, there had been an email from somebody who's running the dam. I think it was directed towards staff of the dam or other people involved in the process that were raising the level back up.
Mhm.
Was that before or after the permit was issued?
Those emails, to my knowledge, were before the permit was issued because the issue arose. Sorry, go ahead.
If that's the case, then how can you demonstrate that it was the state's actions that led to the taking of the property rights that were damaged?
I'm going back to summary judgment record number 1 from April and May, but here's my memory of what's in the record.
There were
Okay.
A
A lot of things, right? September 2019, November 2019, that time frame. Four Lakes Task Force, including its attorneys from Clark Hill, are writing very strongly worded letters to the state saying that you're creating a bureaucratic situation by which, we're never going to be able to satisfy you. We've proposed a muscle recovery plan. You've ignored it. You're telling us we can't lower the water levels to do the winter drawdown. It's going to be seriously damaging and it's going to prevent us from doing much needed repairs. After that happens and Boyce lowers the water level anyway, the state starts threatening, we're going to sue you for what you just did. And the lever we're going to use to do that is damage to natural resources in the form of irreparable damage to mussels. And so if you want to negotiate with us about how much you're willing to pay as a penalty to remediate the mussel damage, then let's come to the table and let's start talking. There's emails going back and forth from Mr. Gamble to Mr. Coogan, who's the lawyer for Boyce Hydro, and they're negotiating these terms. And in the midst of that, Mr. Gamble's making no bones, like continuing to make the threat and the representation that if we don't get this resolved the way that we want it, including an agreement to re-raise the water levels, we are going to file the lawsuit against you. And so it's this constant use of leverage in the form of, we're going to sue you, the complaint is ready. If we don't get this resolved, including raising water levels and paying us something for the mussel damage, you're going to get hit with a lawsuit. And so the fact that the lawsuit ultimately came in on May 1st doesn't mean the state wasn't leaning very heavily and using its power to effectively coerce the raising of water levels, okay? And then as the Court of Appeals held in this case, getting back to the permit granting, the law of this case, as established by the Court of Appeals, is, quote, flooding cases like other takings cases should be assessed with reference to the particular circumstances of each case and not by resorting to blanket exclusionary rules. Thus, a takings claim is established where, quote, the government, acting along with a private dam operator, took affirmative steps that caused the dam to fail and damage downstream property owners. And so in terms of working along with the private property owner, what did the government do here? Well, there's a lot of evidence, but it gets summed up very nicely in one soundbite of testimony. Luke Trumbull, the lead dam safety engineer for Eagle, is asked to describe his interaction with Boyce, the Four Lakes Task Force, and Spicer. And he says in his deposition, it was, quote, a collaboration between the group of what the next steps would be, end quote. So this is not a case where the state is a passive or detached regulator. According to Mr. Trumbull, we're working collaboratively with private actors to determine what the next steps would be. In other words, determining the next operational action related to this dam. And so by the time we get to, and I'm wrapping up, Your Honor, in April of 2020,
Let's take notes.
after all this collaboration, working hand in hand, not just passively, not, the fact that there's a fence around the dam is completely irrelevant. The records here show the state was deeply entangled in a collaboration with private actors. And under those circumstances, never should have authorized the raising of water levels. Brian Rudolph himself says the permit shouldn't have been issued if I had known the dam didn't meet 1/2 PMF. Why wasn't he told that? It's an open issue for trial, and we'll be ready to try that issue in January.
Right. Thank you, Mr. Carlson. Appreciate it. Gamble.
Briefly, Your Honor, I'll try to notch through the different issues. First of all, the plaintiffs, as we point out in our brief with citations to the actual deposition transcripts, they mischaracterized the testimony of both Mr. Rudolph and Mr. Trumbull. Neither one of those witnesses testified that they never talked about it. Both of them testified that they could not remember, which is different. That is a different testimony. This is 5 years after the fact. And Mr. Rudolph did not testify that, in his opinion, the permit never should have been issued. What he said was that if the dam safety unit was concerned about dam safety, then that should have kept the permit from being issued. But that goes back to the point that we have repeatedly hit on. which is that no engineering report from anyone raised any dam safety concerns about maintaining the same level this lake had been at for over 90 years. So the brief has the citations in the record. I don't need to recite it here, but the plaintiffs really bank heavily on the court not cite checking their citations. So Brother Counsel also mentioned that after FERC revoked the license, the dam lost some of its spillway capacity because the powerhouse could no longer be operated. Mr. Sturdivant just testified that powerhouses don't operate in flood conditions because it's dangerous, because you overwhelm the turbines and it will turn the whole powerhouse to dust, I think was the phrase he used. So he just said that you're not supposed to factor that into flood conditions, because any dam operator, they don't operate their powerhouse when there's a high flood. It's dangerous.
Is there some evidence that you can use them as part of your toll in a non-emergency toolbox of assets that are available to the operator to use them in a non-emergent situation to lower, to process, CFS and to lower the level?
Well, yes, if it's safe, then dam operators put water through their turbines to sell the power it's generating. But Mr. Sturdivant's point was that in a flood condition, you shut that door because you don't want that much water or and so that's their, their own expert testified to that. So, and the court asked a question and Brother Counsel wasn't sure what the answer was, which is that in April 2020, when Boyce Hydro directed its internal personnel to return Wixom Lake to its normal level, was that before or after the permit was issued? It was after. So to clarify for the purposes of the court, I just want to candidly say, yes, it was after. And as Mr. Sturdivant himself testified, even in Wisconsin, a permit was just permission. It was not a requirement. There was nothing requiring Boyce to do what they had just asked to do.
Well, it was the 307 order, right?
Yeah, well, really, it came down to, and again, I don't want to burn the court's time. This is all in the briefing. The reason they raised it was to comply with their contract with the Four Lakes Task Force. That was it. And the contract with the Four Lakes Task Force said, hey, we want you to contractually agree to comply with this Part 307 order now that's been issued. And Boyce said, sure. And so that's what they were doing.
Forget for a minute that the Four Lakes Task Force had an agreement where they were going to pay $40,000 a month.
Okay.
Forget that. If there's a 307 order in place, whether it's, the Jim Redford Lake Association, and we've got an order to keep it at 100 feet and in the summer and 90 feet in the winter. And I have the majority of shares in the association. And I said, yeah, I'm not going to raise the issue. That's a violation of the court order, isn't it?
Yes, if the Lake Association owns that dam, it is. But Part 307, so if a county goes and gets an order, and this isn't the only situation this occurs in, if a county goes and gets a Part 307 order, it's a judicial finding from the court. This level is what best protects public safety, the natural resources, et cetera. But if the county...
I've said it before in this case. I had one case involving a Kent County lake, went back 1,000 years ago when I was a circuit judge, that I had those hearings. I made that determination. I felt like Moses.
Yeah, but if the county doesn't own the dam, that order doesn't magically apply to a private entity who wasn't even involved in the Part 307 proceeding. That's like getting a court order against someone who wasn't even in court. So once you get the court order, what that really did is give the Four Lakes Task Force the ability to start raising money so they could buy the dam. So they could establish the special assessment district, collect assessments, and get money in place so they could buy the dam. And then the Four Lakes Task Force is the one who the order would govern. The counties would. But the posture of the case at the time it was issued is that the private dam owner wasn't even involved in those Part 307 proceedings, wasn't even there. The order doesn't apply to him. And so Your Honor, and to go back, the permit, excuse me. It's important to point out, which is why we went through laboriously with Mr. Sturdivant to show that beginning in September of 2019, Four Lakes Task Force and Boise Hydro had already reached a conclusion that they were going to return Wixom Lake to its normal level in the spring of 2020. They announced it in a press release. There's internal emails confirming it. They put it in their permit application explaining, we have this plan. We're going to return this to its normal level in the spring of 2020. Brother Counsel stands up and says, but there's emails 3 months later, state threatening to sue Boise Hydro for this winter drawdown. And that's why they returned it to the normal level in the spring of 2020. This is a classic example of that highlighted in the Bennett case, which is what we identify in our briefing, which is that it is not enough for a lawyer to stand up and just suggest that this is a theory of what might have happened. That is not the sort of thing that the court has to defer to.
No, I understand that.
They,
But I am required. I mean, the case law is replete with trial, with the Court of Appeals, and sometimes the state Supreme Court reversing the trial courts that say, and in their, whether it's the Court of Appeals or the Supreme Court, that says in weighing the evidence at the C10 stage, the court must take the facts in the light most favorable to the non-moving party. You don't have to completely disregard the other explanations, but you have, it is the affirmative duty of the judicial officer to do that. And I just,
Your Honor, if I didn't mean to interrupt you.
you're not, I'm,
Your Honor, the plaintiffs have to identify evidence to begin with for the court to weigh. And so the Bennett case that we put the court's finger on is a situation similar to what Brother Counsel just suggested. What the evidence shows is that months before this dispute about the winter drawdown, Boise Hydro and Four Lakes Task Force had already explained, publicly announced their plan to return Wixom Lake to its normal level in the spring of 2020. Brother Counsel stands up and says, well, but maybe what happened is that they changed that plan, and then in January, they got this threatening email, and so they went back to that plan. So the reason that the Four Lakes Task Force raises the lake again in the spring of 2020 is because of that January email. So that is pure conjecture. They have zero testimony from anyone at the Four Lakes Task Force concerning that, zero testimony from Boise Hydro, zero testimony from the Spicer Group that supports that theory at all. It is pure conjecture. And that's what the Bennett case is so important, because it emphasizes to lower courts, just because a plaintiff's attorney comes up with conjecture and speculation, a theory of what could have happened, that's not what it means to weigh conflicting evidence. They have to actually have evidence to begin with, and they don't. They don't. So,
right.
Thank you, Your Honor.
Thank you. I understand your position. This matter will be submitted. 6 o'clock. Court is in. Is there anything else we need to address for the benefit of the plaintiffs before we recess for the day? Thank you. Anything else for the benefit of the defendants?
No, Your Honor. Thank you.
All right. I want to thank Mr. Trudell. You are great. I really appreciate you being with us for as long as you have.
Thank you.
Really appreciate it very much. So thank you. Couldn't do it without you, literally. So counsel, it's nice to see everybody. Hope everyone has a pleasant journey back to wherever home is, and I look forward to next time we're all together, or I look forward to hearing from you after I issue opinions and orders. Thank you. Court's in recess.
Thank you.
Thank you. Thank you. Daniel, thanks. Appreciate it.